Normally in the standard clause we include that. We have a format. Normally, you just have a look at it. The last you see para 6. Normally we mention that para 6. Ad note maadu. You give the memo to him. We'll not post it, but check. Yes. Freshman. Date code. At the date code. Sir. Who is answering respondent? So you serve him, we'll have it tomorrow. You serve him and you tell him that the court will take it up tomorrow. Fresh matters list tomorrow. Yes. Bank. Manjunath, bank.
A tender matter with regarding to
fresh matter. Fresh matter. Yes. Transportation of? Fresh matter. Kodi. Date kodi. Date kodi.
10.
Tomorrow. Manjunath, tomorrow.
Tender notification.
Adam, your friend is mentioning, isn't it? I date code. Yes. No. Told date code. Bank
tender notification.
Settled. Tomorrow. Settled. Not much.
My lord.
Fresh matter list like that. Yes.
Fresh matter with tender notification.
Give it. Fresh matter. Put it. Date code. Date code. I know date code. Expired. End of the list. Yes, government.
Fresh matter.
See, no, correct. But you have to tell them. Parole is saying the convict's father passed away.
Yes, sir.
So I'm having it the end of the thing. Just find out.
Yes.
Fresh matter with
unconditional entry model.
fresh matter with regard to tender notification, with regard to Davangere Corporation,
tomorrow.
Yes, ma'am.
You serve on the other side also.
Yes, ma'am.
You find out who appears for the
Davangere Corporation, I will serve it.
You find out.
Order is
What is the urgency, money? Okay, we'll have it tomorrow in the fresh matters list so that it will reach. Tomorrow in the fresh. Today it will not reach, even if I get. Correct. We'll still have it in the fresh matters list. You tell the bank to get instruction. So go fresh matters list. Day after tomorrow. I took
15.
Kodi, fresh matter. Kodi.
Fresh matters.
Fresh matter, write and give fresh matters, it will come immediately.
15th.
That's violated.
But
That's being violated.
Sex.
Undertaking is violated. Give it, give it. ತಗೋ. ಆಯ್ತು. ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡೋದು
ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಅದು ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಡಿಸ್ಪೋಸ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡು.
Tenth.
No, but how can this roster, you move it? It's a service matter. ಕೊಡಿ ನಾಳೆ. You inform the who's the respondent? Who's the respondent? Government, you find out. Now you tell him, let him get instruction. It's not sufficient to serve copies. If you are moving for urgent consideration of interim prayer, you have to give one more set and inform the government advocate so that he will take instructions. You inform the government. ಆಯ್ತು, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ಬೇಕು ಫಸ್ಟ್ ಇವಾಗ. ಕೊಡಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ. Just wait, that will call. Yes,
Fresh matter.
ಕೊಡಿ.
Plus, in this case, my lord, in pursuance to the interim order of this honorable court, the sub registrar has released the document. I had given the memo. It was supposed to post it yesterday, my lord. It has not. Can you post it for tomorrow, my lord?
Tomorrow, ಅದ್ ನಾಳೆ ನೋಡು. ಅಲ್ಲ ಇಲ್ಲಿ
My lord, it's supposed to be listed yesterday, my lord. And today also it was not listed.
tomorrow.
Obliged.
ಚೆಕ್ ಮಾಡಿ ಮಂಜುನಾಥ್ ಯಾಕೆ ಬರ್ತೀನಿ. Tomorrow. You inform the government, and now you inform the government and tell them, give them one more set of copy, let it come tomorrow.
The matter was posted for today, my lords.
No 2:30.
No, it was posted for today. Not listed.
Will come tomorrow, but if you don't give government extra copy and tell them, they cannot get instruction, it will again go for a date. Now you give an extra copy to the government and write on top, date given tomorrow, please take instructions.
One matter for tomorrow, because disposition,
Kodi.
electricity and
Tomorrow.
water supply is disconnected,
ಆಯ್ತು.
even though court orders are there.
Tomorrow. ಮಂಜುನಾಥ್ ನೋಡ.
My lord, this is a fresh matter, my lord. Even after the direction of the trial court, the police have not complying with the order of the trial court, my lord. It's a fresh matter.
Tomorrow,
Tomorrow.
petition has been awarded for tender and has been work order is issued, madam. Again, they issued a re-tender notice. Kindly have it.
Fresh matter.
Fresh.
Tomorrow.
Amendments, list 1, page number 1, 125, page number 2.
My lord, serial number 9.
I'm asking the petitioner.
Serial number 20.
Yes,
I'm appealing for petitioner. Regular have this matter Monday or Tuesday.
I request relist the matter on
14th. Page number 4, 24 to 29. Page number 5, 30 to 35. Page number 6, 36 to 39. Page number 7, 40. Page number 9, 41. Page number 10, 42 to 45. Page number 11, 46 to 52.
Lord, serial number 51, my lords.
Yes.
I appear for exponent number 1 and 2. Matter may be taken up after 2 weeks, my lords. I have informed the petitioner.
Rajeshwar PN.
List after 2 weeks, interim order, the operation is extended till the next day. Date.
4th of August.
Obliged, my lords.
Page number 12, 53 to 56. Page number 13, 57 to 64.
60.
Suresh K.
You have informed the other side at request. list the matter next week after next. Date.
4th of August. Page number 14, 65 to 71. Page number 15, 72 to 78. Page number 16, 79 to 82.
82. Forgot.
82. Venkatesh.
Counsel for the petitioner has filed a memo which reads as hereunder. Light of the same petition is dismissed as not pressed.
Page number 17, 83 to 85. Page number 18, 86 to 88. Page number 19, 89 to 94. Page number 20, 95 to 97. Page number 21, 98 to 103. Page number 22, 104 to 106. Page number 23, 107 to 111. Page number 24, 112 to 116.
My lord, serial number 136. 136.
In abundance.
I'm the
136.
136.
Page number 25, 117 to 119. Page number 26, 120 to 125.
My lords, 122, my lords. And for the petitioner, my lords, I pray for 2 weeks, my lords. Interim order, my lords, previous occasion was not extended.
Yes, government 122. They want it on some other day.
Yes.
Relist the matter.
4th of August.
Interim order, my lords.
4th of August. File a memo. If it's skipped in the middle,
Please, ma'am.
you mention on what date it was not extended and you file a memo.
Please, ma'am.
In
I will
light
file
of the memo filed,
Please.
the interim order earlier granted, though not extended on the last date, though not extended on the last date, is extended till the next day.
Please, ma'am.
Page number 27, 126 to 129. Page number 28, 130 to 135.
Serial number 130, my lord.
130.
This is for the respondent, my lord. This
Ah.
matter is about freezing matter, my lord. This matter has come to 4th to 5th and matter was not reached, my lord. Kindly for hearing this was the matter for hearing. My lord. We'll produce some documents. 130, serial number 130.
130. Relist the matter on 21st. On 21st.
Obliged.
130. Put it. Petitioner files a memo. It says follows. In light of the same, petition is dismissed as not calling for adjudication.
Page number 29.
My lord,
136.
serial number 136, 136. I am the petitioner. I appear as party in person. My lord, interim order would expire today. This matter relates to pay a bank loan. I have paid entire loan obtained from the bank and with interest, along with the interest. And the respondents are colluding with one another, trying to fasten huge liability on me. And the only issue involved is whether they are justified in fastening huge liability excess.
Let us see. It may not
Because
reach.
it may not reach today.
Ah.
Interim order may kindly be extended.
We'll extend it. We'll extend it at the end of the day. I'll extend it and give a date.
141, please.
Ah,
Because this matter was posted on Thursday, please, my lords.
ah,
It is a passport matter,
ah.
wherein my lords had pleased to direct relisting today in the same fresh matter list. But it has come up in B group, please, my lords.
We'll take it up just before preliminary hearing list starts, but you must intimate the
Sorry, please.
141.
May I request, please, my lords? I have
Just
already
one,
informed.
just one. All passport matters, if they come in the preliminary hearing at the end of the list or debit freeze, you give it to the court officer, we will take it up just before preliminary hearing. All passport matters and debit freeze.
I will request, my lord. I have already informed the
You
Union
have to-
Government
You
Council.
have to bring him
Day after tomorrow, it may be. I have
Huh?
already informed,
141.
please, in the fresh matters list or any
In
other.
the fresh matters list on.
10, obliged, please.
Huh? Just 1 minute, just 1 minute.
List to 2,
Yes.
page number 1, 1 to 5, page number 2, 6 to 14.
Yes. Yes. Huh? It will reach before that. You be ready. Yes.
Page number 3, 15 to 17.
Number 15.
Yes.
Ramesh RB.
Malaj, I object, Malaj.
We are no more in the panel, so can you please remove our name?
Sumana Baliga.
Sumana Baliga, writ petition 16501.
Who is R2? Who is the second respondent?
Malaj, Mandya Institute.
Second list,
Mandya Medical.
BBMPL, Sumana Baliga, for
Name of-
Mandya Institute of Medical Sciences.
Do you know who is the present counsel?
No.
I wish to delete the name of learned counsel Sumana Baliga for R2. Let us see when it reaches.
Obliged, Malaj.
Page number 4, 18 to 21.
19, my lordship. Senior out of session.
19.
18,
19.
19. At request. This is a club matter in Bedana. Club matter. Mat ನೀವೇ ಸಾಕು ಸೀನಿಯರ್ ಏನಕ್ಕೆ
File from the office ಅಲ್ಲಿ ಇದೆ senior out of session.
ಅದು ನಿಮ್ ತಪ್ಪದು ರೀಲಿಸ್ಟ್ ಆನ್ ಎಸ್
Page number 5, 22 to 26. Page number 6, 27.
yes
My lord, serial number 9, list 1.
yes
I seek for an adjournment,
Yes.
my lord. Senior is unwell. List 1, serial number 9, my lord.
MD Raghunath.
Yes, my lord. I appear for the petitioner.
at request relist the matter on
Any date, my lord.
Not this matter relating to Kukke Subramanya temple, but they have appointed the management committee. One person with a criminal background has been appointed. He was a rowdy sheeter earlier, and he had defalcated money from the institution itself, on which a criminal case was going on. That matter needs to be taken, but little urgency.
government
He has now become the president.
I will verify today it is there. I will verify
Say number 123, list 1. List 1, 123.
at 4 o'clock. I'll take it up at 4 o'clock.
Please.
Yes, sir. By then I'll also secure the instruction.
Obliged.
Kind leave.
Your lordship, kind
Lordship, kind
permission.
leave, my lordship. My lordship, yesterday's one temple matter, my lordship. My lordship, they have taken interim order. My lordship, this Sunday, there is a program for the Shila Vinyasa, my lordship. Not to precipitate order has been. My lordship, same similar matter that connected for the same.
Tomorrow we'll have it tomorrow.
Tomorrow there is a matter, my lordship. It may be connected along with that and
Just along with
tomorrow, my lordship.
inform the government advocate.
Yes, please, I have informed my lordship.
Your lordship, kind permission. I also moved second time. This is the case in which the petitioner is a senior citizen, she is a lady. Only the direction to the KHB, because they have paid entire amount, they have to execute the
Sale deed.
deed in favor of the petitioner. She is aged 65 years, she is suffering
Togo,
from various problems. Tomorrow, last week also it is moved.
I did put it.
My lord, the debit freeze KPID matter, I'll serve set of papers on Mr. Viresh Pudihal. If it could be taken up tomorrow, my lord, debit freeze.
Serial number 87, my lords. Only order is to, the borrower has deposited the money to court. We have filed an IA for release of that money. Bank has filed an IA. 87, if it does not, any time maybe 4:30, my lords.
Yes, we'll take it.
My lord, serial number 48, my lord.
87.
The serial number 48, this is that rare disease marriage where the mother's application NOC was to be obtained. Now, my lord, my learned friend has filed the application. A copy is also forwarded to me. I will follow with the department and ensure that the NOC is issued. Your lordship may kindly have it after 3 days, my lord. By then, I think.
Released on
that's
Friday.
Friday.
Friday. Yes.
This one, serial number 1.
Lords, item number
Correct.
66 in the first list. If your lordships maybe please, Lords, may fix.
Will reach today.
I'm grateful. I'm grateful.
Never this notice.
For the petitioner.
For the respondent, number 1.
I am for the respondent number 2, my lords.
In this case,
My lords.
the settlement between respondent number 2
My lords.
and the petitioner.
Lord, the facts are like this, my lords. The petitioner had availed a loan, my lords. Petitioner under husband.
husband died. There was an insurance policy covering this loan amount, my lords. We made a claim to the insurance company. Insurance company earlier was not honoring the claim, my lord. Subsequent to filing of this petition, they have honored the claim. They say they have settled with the bank. They are paying the outstanding. I don't know what grievance bank is having if they are getting their money.
We were not aware about this memo. The day of the date submitted. We are what memo was going to go. Only one liberty to be granted, my lordship. They are settled between themselves and we are receiving our money. I don't have any objections because my loan will also get clear. Yes, till now money has not come. If money does not come, I maybe said
Lords, money is already paid on 30th, my lords. They are having a document for that.
Yeah, check
They are now settling.
Correct. Now, in the event the settlement is not honored, you can definitely file. I'll take it up.
Please.
This application may be disposed of, my lords.
No further orders are required.
Serial number 2.
Not before me. List after obtaining necessary orders before appropriate bench. Yes.
3. Serial number 3.
And for the petitioner, my lord.
Yes, you take out notice. Take out notice. So RERA.
RERA matter, my lord. It's an
There was
execution.
not a party in that.
Huh?
There was not a party.
The relief is sought
Only,
against the DC, my lord.
They're only execution. Please.
Yes, execution.
DG accepts notice
Execution
for
order is at page 17, my lords.
No, correct. So let them find out what is the difficulty. Meanwhile, if you have any particulars which will enable them to speeden up the execution, you file a memo.
In fact, I had approached them. I had written a letter to them. Initially, what they said that we had sent the files to the wrong Tahsildar, and this went on for 2 years.
Let
And
us
the
see.
order is of 2023.
Let us see.
And thereafter, there is a
Relist the matter. Find out.
to keep it in the last week of
Good. Last week.
Yes, sir. 29th.
Yes.
any fixed date, my lord.
29th. Yes.
Fourth, my lord, as far as the fourth is concerned, lord, they were, your lordship may kindly come to this annex B, wherein this water connection was disconnected by the
No,
association.
just 1 minute.
In such an event, just notice is sufficient in this case. I'm not seeking any interim order or anything like that.
PL Sanjeev is directed to accept notice of first respondent, AGA for third respondent, emergent notice to the second respondent.
Much.
5. Serial number 5.
I appear for the, my lord, the Leonard
My lord, I'm
DSG
appearing
has sought
for-
for a passover, my lord.
Passover.
We'll have it at 4 o'clock.
4 o'clock.
There's one point you have to answer. In the sealed cover, you had given the visa and the passport. That passport number does not tally with his passport number. So how do you say he's impersonating one? 2, whether you have whether that passport of which was in the sealed cover was seized from him, that you clarify. 4 o'clock. Yes.
6. Serial number 6. Right, please.
So now let them come back. You serve on the council. We'll find out.
My lords, I appear for the respondent, my lords.
Yes.
We have received the writ petition copy last night, my lords. We are yet to receive instructions from the institute, my lords.
Find out. I'll have it next week.
All that I am requesting is, we have received an email last week asking us to appear. Proceedings may be stayed. They have not done anything for 15 years. After the directorate said, I am prima facie not guilty. Without any reasons, they continue the proceedings. They have to say why they are not accepting the directorate's report of not guilty
No,
without
correct.
any reasons.
Correct. So let them complete.
That
the
is one.
No, let them complete the instruction. I'll have it next week. We'll hear and we'll decide on the interim.
Let them not, let there be say, they should not say.
We'll see on the next date. We'll
At
pass
least let them say that they will
My
not
lords, we
continue.
have to receive instructions
not
in this
hold
matter,
me.
my lords.
All that I am saying, my lord, is,
Let us see. We'll fix
I have
it.
received a notice last week. If I don't respond to it, they should not take it otherwise. That's all.
Correct. We'll decide it in their presence. Let them complete the instruction. On that day, we'll consider.
Only one thing I wanted to point out. In
Let
similar
us-
circumstances.
No, just wait. Let us.
Yes.
Let them complete the instruction. Next date, we'll see. Now
Until
you appear
then,
for.
my lord, at least let them say that they will inform the institute not to proceed further.
Let us see which date when do you
My
want,
lords,
madam?
only on last night we received the writ petition copy.
Yesterday
We have
afternoon
to
we have
receive
sent it.
instructions. We have no instructions in this matter, my lords.
So
May
when do
have
you
it
want?
any other day at your convenience, my lords.
We'll have it
Would your
on.
lordships have it day after at least?
Can you get back by Friday?
Thursday, my lord.
We'll receive instructions by Friday, my lords.
Can it be Thursday, Friday?
We'll try to
Matter
receive
of
instructions by Friday.
Thursday, so
Thursday.
and so. You
My
undertake
lords,
to appear
Friday, my lords.
Friday. You
Would it
undertake
be
to
on
appear.
Friday, my lords?
You undertake to appear for.
ICI, my lords. Respondent number 1.
So and so undertakes to appear for R1. Emergent notice to 2 to 5. Relister in the same stage on Friday.
Friday.
My lords, Sumana Naganan name may be shown in the appearing for respondent number 1, my lords.
Office to show the name of learned counsel.
Sumana Naganan.
Sumana Naganand for R1. Yes.
Friday I have some personal inconvenience. I'm
Monday.
not.
Monday will have it.
Monday also. Can it be on Tuesday or
Tuesday.
Wednesday? Next?
Tuesday. Yes. Tuesday.
Just since your lordship has seen the papers, I want to just point out that the Delhi High Court
Next
on
day,
similar set of facts have closed the
See, next date will. Yes, next.
Grateful, my lords.
7.
Petition. But interest-free loan was availed by the petitioner under a scheme formulated by the Union of India.
Take out notice. Who appears?
Union of India, my lord, DSG.
DSGI Shanti Bhushan is directed to accept notice for second respondent. AGA for.
They have received the subsidy reimbursed for some time,
2
but
and
for
3.
the reasons best known to them.
Emergent notice to the third respondent. Petitioner is at liberty to take out notice by way of hand summons to the.
But they are threatening.
Huh?
Notice is issued by the bank. I am not at fault. Subsidy is to be reimbursed by the central government. There is threatening coercive action. She is a medical student by suppressed class.
You served today. We'll have it on Thursday.
But annexure, the loan, the threatening action may be stayed for some time now.
Just 1 minute. Now you serve on the union. Union is to reimburse. So you serve on Shanti Bhushan today. I'll have it on Thursday.
Please.
I'll list the matter on Thursday in the
Same stage, madam.
Same stage. You ask him to get instructions.
Please.
8. Raghavendra.
Petitioner. Kindly pass over the
Huh?
Kindly pass over the
Petitioner. You have to file a habeas corpus is what the amicus is stating.
Today is there.
Huh?
Today is there, my lord.
Habeas corpus. Then shall we have it some other day?
Yes, ma'am.
Huh?
Yes, ma'am.
We'll have it. Relister. Date for that. In case something happens there ends the matter.
Nine urgent 10. Serial number 10. Neeraja Karan.
I appear for the
Hilpa.
this one number 1. I have just got the sketch.
Till the door.
So this sketch shows not from Hassan to Bangalore, then we come left hand side, there is Kadamba Hotel. There is a Kadamba Hotel, there is the petitioner. So now when you look at, there is a purple color line, this both sides, there is ROW, that is NHA road. So that belongs to national highway, central government, west with the central government. That, Kadamba Hotel, you see that it's coming beyond so it's coming within the NH road. So we have no objection. We are not, as of now, I'm not saying no objection, but as of now, we are not taking any steps which is beyond ROW. We are just taking steps so far as what was there in ROW. So they have done two things. One, they have put, because they are using their customers parking on the highway. So that we said it is not acceptable because that hinders the traffic movement. So they had put the sheet for shade for those parking area. So those we said you have to remove. If your lordship see the notice, which is at annexure A, here there are only two things. Notice annexure A, page 14 below. This is the final notice. If your lordship found it?
Yes, now just 1 minute.
Final notice. Prior to that notice was sent.
Just 1 minute.
Yes.
Now, what we can suggest
Yes.
is that in their presence, you make a spot inspection and a spot inspection and drop a report. Let it be done in their presence. And then you place the report, we'll see what is to be done.
That could be. Until then, protection may be given.
Protection, Milord, that
We are not saying anything, madam.
Milord, that restaurant is
No, correct.
within.
Now we are not saying anything. What we are saying is that I'll fix a date by next week. Meanwhile, I'll give a direction. In their presence, you make the make a spot inspection and a measurement. You furnish whatever records you have. Drop a report. Place it before the court. We'll see what is to be done.
Yes. Now, Milord, I read one like in that representation. In that representation is what? We are running hotel from 2015. So, Milord, yes, one day we have to take steps, and 2024 also notice was issued. Sufficient time was given.
Now you are.
I will just produce one.
26-2 notice we have not received.
By the Honorable Supreme Court, that you have the law and it is only on paper, NHA is not doing anything. That is what Supreme Court is telling us.
Yes. Paragraph.
Entire this thing on that only. Say that, paragraph 3, Milord.
Yes, read.
Firstly, we find that there is no machinery created to carry out survey of highways under the jurisdiction of the various highway administration to ascertain whether there are unauthorized structure or unauthorized occupation of highway land. Unless survey is regularly carried out, the highway administration will have no source of knowing whether there is any unauthorized occupation of highway land. They say regularly you have to keep doing this exercise. You just, so there's judicial notice will have to be taken of the fact that different parts of India there are unauthorized encroachments on highway land. Under section 31 by 31(2) of 2002 Act, it is provided that the highway authority must step in when highway becomes congested or unsafe for vehicular and pedestrian traffic. This order was passed on in 20th February 2024. Milord, all over India immediately steps started, Milord, because there was that direction was that filed the report, and then they noticed that there was a encroachment at this location, and based on that, notice was issued in 2024 itself. No action taken.
Now you do correct. Now we are not coming in the way.
Yes.
We'll give a direction. You place the report. We'll see what is to be done.
It also says survey has to be conducted.
Correct.
Because
So
they
now
have
let
come
it be
directly demolish.
It's done, and based on that, this notice has been
No,
issued,
correct.
and this is the sketch.
We should be
No,
informed.
that let it be done in their presence. There ends the matter.
Please, Your Lordship, please.
The petitioner has challenged action of the respondents, which is in the nature of a final notice for removal of unauthorized occupation. Learned Counsel, Ms. Shilpa Shah, appearing for the NHAI, files a memo and places a sketch prepared and submits that there is a encroachment of the national highway. Learned Counsel for the petitioner submits that there is no survey conducted in their presence. Full stop. In order to appreciate the controversy and the context in which the notice was issued, it would be appropriate that the survey is conducted in the presence of the petitioner and a report be submitted to the court by the next date. Now the date will fix, or you will fix amongst yourselves?
Your Lordship fixes,
Your
we
Lordship,
will.
fix it. We have no objection. We
The-
are in hurry to
The parties,
remove encroachment.
the petitioner and the respondent authorities to be present at the site on
Saturday, Milord?
just 1 minute.
Friday may be kept because Saturday I'm not sure officer is available. Friday.
On Friday
Yes.
at 11:30 a.m.
Please, sir.
After survey in the presence of the petitioner.
Petitioner and owner, because Milord, they are tenant. They are
Petitioner,
raising objection that owner.
petitioner and the owner or duly authorized representative. The report to be filed by R1 before this court by the next date. Relist on, when do you want?
Next week, any day.
Put in the same stage on.
Milord,
22. 16th.
Till then,
16th.
Milord,
until then, Milord, the previous order.
Milord, petitioner may be directed to inform Milord owner, because they are a objecting owner. You have not given notice to owner.
It is the
But they have not
responsibility of
made owner the party.
it is the responsibility of the petitioner to ensure that the owner or his authorized representative with due credentials is present at the time of the survey. Needless to state, no precipitative action till the next date. Yes.
11. Given at 11. My lord, a show cause notice, my lord, would be issued to him at Annexure J, page number 32, my lord, by the Tahsildar. Now, I bring to the notice of the Tahsildar that until and unless there is a violation of the conditions, it is, my lord, found by the Assistant Commissioner. Under the rules, it is only the Assistant Commissioner who has got the jurisdiction to take any precipitative action. My lord, I have placed that reply, my lord. Thereafter, nothing they do. My lord, a caveat petition is filed, my lord, as per Annexure M, stating that they want to re-auction and they want to take the possession of the property. The Tahsildar, my lord, files a caveat petition before the competent civil court. Thereafter, my lord, they come near my property and, my lord, say that they are going to dispose of me. Now, my reply is not considered and a jurisdictional issue is what I have raised. Without that being considered, my lord, precipitative action is sought to be taken. In the previous occasion, my lord, they had done the same thing.
Correct. What is the procedure?
My lord, 32 rule 16, my lord, is the 3116. Karnataka Hindu Religious Institution and Charitable Endowment Rules 2002. Rule 31, my lord, sub rule 16. That is what they invoke, my lord, in the show cause notice that they issue at Annexure G. Rule 31, sub rule 16, my lord.
Yes.
Any violation of terms and conditions of the lease shall result in termination of lease. On termination of the lease, if the lessee fails to hand over to restore the property to the institution, the Assistant Commissioner shall initiate proceedings against such lessee under the provisions of the Karnataka Public Premises.
Now, just like in the municipal corporation, tender, shops, etc., we'll dispose it of, saying you can proceed against him. If even if you do a tender,
yes, ma'am,
it will come into effect only after this.
Yes, ma'am.
There should be a termination of the lease, my
No,
lord,
correct.
until and-
You should follow the procedure.
Yes, ma'am.
And do it.
Yes, ma'am.
We'll dispose it.
Yes, ma'am. Yes, ma'am.
The petitioner has a sought for
quashing the notice at Annexure G, my lord.
setting aside the notice at Annexure G. In terms of the notice at Annexure G issued by the Tahsildar, the petitioner has been called upon to show cause as to why orders are not to be passed to evict the petitioner in light of default in payment of rent and non-renewal of the agreement. Full stop. It is a notice that the notice is issued by the Tahsildar. Counsel for the petitioner submits that the respondent authorities cannot evict or recover possession from the petitioner except in accordance with the power conferred under Rule 31 Sub-rule 16 of the Karnataka Hindu Religious Institutions and Charitable Endowment Rules 2002. Full stop. Perused Rule 31, Sub-rule 16, which reads as follows. Full stop. Next. It is clear that there has to be a termination, and upon termination, if there is a failure of the respondent, failure of the petitioner to vacate, Assistant Commissioner is required to initiate proceedings against the lessee under provisions of the Karnataka Public Premises within bracket eviction of unauthorized occupants close bracket Act 1971.
1974.
In light of the said legal position, the petition is disposed of, directing the respondents not to interfere with the petitioner's possession except in terms of Rule 31, Sub-rule 16.
No, 17 also he requires, 17 requires, he has to inform regarding the renewal, because his agreement, what is the annexure F, my lord, is executed somewhere in 2016, and that 5 years is completed. He has not made an application.
I'll do that, my lord.
He has not made an application to renew. 31 rule 17 speaks of that.
Correct. And now,
So
even
we'll follow that
otherwise,
procedure.
correct. Even otherwise, you'll have to go under 16.
Yes, yes.
So let us see. All contentions, including as raised by the petitioner, the present petition, are kept open.
Please. Great.
AG accepts notice of the respondent. Yes.
Well, Swaroop, yes.
It's a matter where, my lord, I sought a writ of mandamus
Yeah.
to return the documents. My lord, in
Yeah.
fact, we cleared the loan. In fact, I spoke to my friend, my lord, they're agreeable. The only thing is, my lord, the compensation which I'm entitled, I'm not seeking, my lord, I'm not going to pay. Yes, sir.
So let them, we'll fix a date, let them hand over, then you report.
My lord, they
Tomorrow,
said that tomorrow
tomorrow we'll get out the documents, my lordship.
We'll dispose it of.
We'll dispose it of.
The-
One submission, my lord, they have other loan with us in which the petitioner's father has availed. The larger extent of the same properties with us only documents,
That I'm
original
not
documents.
claiming.
So they have told that they will release these documents, avail a fresh loan and close that one. So that may be recorded, my lord, so they will.
What my friend is saying that, one more loan availed by my father, different the set of property, my lord, which we given as a collateral security. What is, my lord, I don't know, my lord, however, what transpired me, my lord, my borrower said that, my lord, we'll avail the loan in this after release of the document, and my lord, we'll repay that loan also. That, however, my lord, there is no significance in this matter. Here I paid the entire loan, they let them release the document. I will, my lord, I already, my lord, other bank, my lord, sanctioned the loan, which, my lord, they duly agreed, my lord, they're going to, my lord, hand over the documents tomorrow.
The petitioner has sought for issuance of writ in the nature of mandamus to direct the respondent to return the 12 original documents received under the mortgage deed dated 27/2/2018.
My lords, it's not 12 documents, but only 3 originals are there, my lord. 2 gift deeds and 1 discharge deed.
Page
Only
number
3
18.
originals are there. Rest everything is copy.
Whatever I deposited.
12 original. Full stop. Petitioner has also sought for compensation for certain action of the respondent. Next. Now the loan is taken over, is it?
No, no, loan is closed.
Closed.
In respect of the present loan is closed. They issued a notice certificate.
Learned counsel to the petitioner submits that the loan account is closed.
Present loan, yes.
Present loan account is closed. Counsel for the respondent also submits that said assertion is true. Full stop. Next. Insofar as the documents return of which is sought for, counsel for the respondent submits that all documents in original handed over duly acknowledged to the petitioner, which is in the possession of the respondent bank, will be returned.
Returned.
Full stop. Said submission is taken note of. Full stop. Accordingly, the petition is disposed of, taking note of the undertaking of counsel for the respondent. Full stop. Petitioner submits that they do not insist upon consideration of prayer B. Said submission is also taken note of. Next. Petitioner submits that there is a loan of the petitioner's father and they would take appropriate steps to clear the same as well.
Grateful.
Much obliged.
Accordingly, petition is disposed of.
Deeply.
13.
For the petition in this case, ma'am,
Yes.
they sought for a writ of mandamus, ma'am. The identical matter is already disposed by the Sabal court.
Club. Amusement order and thing.
Because the respondent police have insisted me to get a license under the KP Act, my lord.
Same order as in 18409 of 25. Ali mail bari bank draft ali. Same order. Nanu innೊಂದ್ಸತಿ check ಮಾಡಿ. Once paragraph ಬರ್ಕೊಳ್ಳಿ. Petitioner submits that it is registered association, registered under the provision of the Karnataka Societies Registration Act 1960. Petitioner sought for issuance of writ in the nature of mandamus to direct respondents not to insist upon the petitioner to obtain license either under Karnataka Police Act or under the licensing and controlling of public amusement order, comma. Petitioners also sought for a writ in the nature of mandamus to direct respondent not to interfere with the recreation activities in the scheduled premises. In same order. Repeat. From para 2 onwards. AG accepts notice for the respondent. You just make one circular. Why everybody must come to court? You make one circular. You say 1, 2, 3, 4. In case of amusement order, Police Act not required. If it is a game of chance, they will inspect. Otherwise, they will not. If there's any offense, apprehension of offense, they'll intervene. So you make one circular and do it. That's all.
Much obliged.
Prakash Hegde, Ajay Prabhu, 14 Ajay.
So I had filed a similar writ. So then I was arguing. Justice Thakur asked, "What is the urgency?" We'll see. So I said, "Lawyers are also members." So he says, "Bars, they're members of both the bars." Yes.
Hearing for R1.
For the petitioner, my lord. For the petitioner in this matter, the petitioner is a qualified environmental engineer with a master's degree in science.
So which is that order? You say covered. Which is that?
15026 of 2016, my lord.
You have produced
He has not produced a copy of that, but he
Lord, I
mentioned
have
it.
the interim order.
Give it. Give one. The petitioner submits that in an identical, not this. So at least some.
Three orders.
Okay, you give where interim order should say stay whatever. As prayed for means nothing. It's Kodi.
Accreditation, national.
What is the interim order? The petitioner has filed the present writ petition not to sought for stay of operation of notification at annexure A, office memorandum at M, N, and P. The counsel for the petitioner submits in an identical factual matrix where similar legal contentions have been raised. An interim order is in operation as granted in WP 10548 of 25 and other connected matters. In light of the same, there would be stay of annexure A, M, N, P.
Yes, my lord.
List along with WP 10548 of 25. Central Government Standing Council is directed to accept notice for the Union of India, AGA for R2. Ajay Prabhu. Ajay Prabhu for R1. Undertakes to appear for R1. AGA for 2.
With the 2016 notification that they.
The question of delay and latches in filing the petition is kept open.
15, Suram.
I appear for petition, my lord.
This delay also from your side in not getting the petition disposed of. Yes.
My lord, this is the similar to one, my lord. Yesterday, your lordship was pleased to grant an interim order where Commissioner of Food and Civil Supplies exercised the power, directing the second respondent, my lord, who has vested with the power under the Act, my lord, to suspend the authorization, my lord, without considering the document, my lord, the statement made by the online complaint made by the concerned person, my lord.
Where is the statement?
Statement page 15, my lord, may kindly see, ma'am. Last para, page 16, your lordship could kindly see.
Yes.
Last para, ma'am. ಆದ ಕಾರಣ ನನಗೆ ನನ್ನ ತಪ್ಪಿನ ಅರಿವಾಗಿದ್ದು ಸದರಿ ದೂರಿನ ವಿರುದ್ಧ ಯಾವುದೇ ರೀತಿ ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ಅವಶ್ಯಕತೆ.
Typed copy page.
Typed copy page 16, my lord.
16. Yes.
He gives a complaint to your lordship, online complaint here. There was no complaint at all yesterday. An anonymous complaint was given using the name of a card holder. Here, card holder himself has given a complaint, but however, he realized the mistake that he has not lifted the commodity on his own, he has taken it subsequently.
Now
that's all the allegation.
Yes. Now the order of suspension is at?
Annexure B, my lord. Annexure B. I'm sorry, my lord. Annexure C. Page 18, my lord.
Yes. The petitioner has called in question the order of suspension of authorization at annexure C. Full stop.
Identical order I have produced annexure D, my lord.
It submitted that the complaint on the basis of which the order of suspension was passed
based on the direction issued by the
has now in effect been withdrawn by the communication at annexure A2. Taking note of the contents of A2, there would be stay of annexure C. Annexure C. AG accepts notice for the respondents. Yes. Witness turning hostile. Yes. Next.
16.
In this, I appear for petition. This also one, my lord, the similar matter, my lord. Your lordship for granting interim order, my lord, directed me to file an appeal before the appellate authority, my lord, before Shumogga in 18,645 of 2025, day before yesterday.
18,645
of 2025. Here is a case, my lord, a suspension order similar to the one, my lord. Suspension order came to be passed, which was challenged before the deputy commissioner.
AGA accepts notice for the respondents. What is the order we passed?
Order, my lord, now the order passed, my lord, annexure F. It is not yet released, my lord. Annexure H is the order under challenge now.
Annexure
H. Page 40, my lord.
Now this order by the deputy director.
Deputy director of Food and Civil Supplies, my lord.
Appeal is under?
Appeal under 17.1, my lord, before the deputy commissioner, my
lord. 17.1 of the?
KEC PDS control order 2016, my lord. Formerly, the power vested with the Commissioner of Food and Civil Supplies by virtue of amendment in 2016.
The petitioner has sought for setting aside of the order at annexure H. Full stop. It learned AGA appearing for the respondents who accepts notice submits against the order at annexure H passed by the deputy director. There is a provision of appeal under regulation 17 of the Karnataka Essential Commodities
PDS control order 2016,
within bracket public distribution system close bracket control order
2016. First ಇರ್ತದೆ.
Karnataka Essential Commodities Public Distribution System Control within bracket Order 2016. Full stop. And Council for the petitioner submits that appeals filed are not taken up in time, and accordingly they're constrained to file the writ petition.
No, appeal is yet to be filed, Your Lordship.
Correct.
The reason for filing the writ petition is
Yes, full stop. Taking note of the said submission, the petitioner is delegated to avail of the substantive remedy under Regulation 17. Full stop. If appeal is filed within a period of
4 weeks, Your Lordship, from the
4
date of
weeks.
receipt of the copy of this order.
4 weeks
Otherwise,
from date of receipt of copy of the order, same would be taken and appropriate orders passed. Then interim relief, what we
interim relief, my lord, this honorable court, my lord, and also the DC, my lord, has protected my interest. There afterwards, this order came to be passed. Therefore, interim order, Your Lordship granted an interim order staying the operation of this order till the application of mine is considered, my lord, in the appeal.
order at annexure H would be stayed till the application for interim stay that would be filed in the appeal.
Yes.
Filed under 17 is considered and
Yes.
orders passed.
Yes, sir.
Appeal to be filed within a period of 4 weeks from today. The
From the
if
date of
appeal is
receipt of the
filed-
copy, my lord, may say.
From date of receipt of copy of the order.
Yes.
If appeal is filed within 2 weeks, the authority may condone the delay by passing appropriate orders, taking note of approach before this court.
Yes,
All
great.
contentions are kept to.
The previous order, my lord, is not uploaded, Your Lordship.
No.
Therefore, time is running short. my lord.
Yes.
Public.
17.
They have no. Yes.
I accept notice
Please,
for
my lord,
R1 in
petitioner is challenging show cause notice and under my lord, the public premises at page 56.
Which is the authority?
the commissioner, my lord, commissioner of the
Chikmagalur
Urban Development Authority.
You serve.
No, my lord, what has happened is, my lord, similar case, I'll just. In 2008, my lord, a show cause notice was issued under Town and Country Planning Act. And the petitioner approached this honorable court, my lord, at order at page 52. There's a writ petition at page 52, my lord, a common order came to be passed. At 55, my lord, operative portion recording. The authority was asked to reconsider its show cause notice and take appropriate action, my lord.
On what ground?
Lord, then the
Please, my
notice
lord,
came
at page 54.
And on what ground it was directed to be reconsidered?
My lord, then the notice was issued.
On their own undertaking.
Huh?
Their undertaking at
Correct.
para 2.
No, so now you serve on the other side.
No, my lord, the connected petition, my lord, there is a stay of
Which connected petition?
that writ petition, my lord, which I pointed out.
That is
There are 2
2000
petitions.
That is 2009 and 8.
Correct, my lord. Now they have also approached this honorable court, my lord.
So
The
let us
thought-
correct.
The show cause notice has been stayed in the.
On what ground we don't know. What will be written there? Interim relief has prayed for.
No, my lord, your lordship have noted.
Good. Yes.
On the very ground that it's not reconsidered. Since 2010, they have not taken any action. Now another notice came to be issued. Their contention is that civic amenities has been utilized by me and I have constructed the house. The very same contention was countered, asking them to reconsider.
For the petitioner submits that in an identical factual matrix of a petitioner similarly situated, this court in WP 17602 of 2025 has passed an interim order, and on parity the same order may be passed in the present case also. Interim order passed in WP 17602 of 2025 reads as follows. Next, in light of the same, there would be stay of
Annexure L.
Annexure
L.
And proceedings pursuant thereto till the next day. Read is the matter along with the WP number 17602 of 2025 on date coding. Emergent notice to the respondents,
2 and 3.
Chikmagalur Urban Development Authority. Ravi Shankar, Gangadhar. AG accepts notice of first respondent, emergent notice to 2 and 3. Now, after 2008, we don't know, they may have reconsidered it.
No, they have not taken any action. I'm still residing there.
18, Mithun,
Petition.
Prithvi
Kindly pass on.
Anand.
Pass on.
Your Lordships, here, this was yesterday's matter with regard to that Societies Registration Act. Recommendation made by District Association was supposed to be considered by the State Association. Anand Council was directed that whether they will consider.
My lords, I appear on behalf of P. Anand, my lords. I seek for a pass over, my lords.
Pass over.
Kindly pass on.
Let us see.
Yes.
Pass over.
Your Lordships.
19.
They have to come with the proposal that whether they are,
Please, my lords,
otherwise pass overing is nothing but.
My lords, he wants to come and make his submissions, my lords. My lords, may kindly pass over.
Yes, yes. Next.
19.
So appear for petitioner.
Yes.
The present petition is filed challenging the notice issued by the respondent police, my lords, wherein I was restricted from conducting the protest. My lords, if I kindly take your lordship to Annexure A, page 19, the reasons for restriction. My lords. May I read, my lords?
Yes.
ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸಿಪಡುವುದೇನೆಂದರೆ ನಿಮ್ಮ ಸಾರಥ್ಯದಲ್ಲಿ ರಾಜಕಾಲುವೆ ದುರಸ್ತಿಗೆ ಆಗ್ರಹಿಸಿ ದಿನಾಂಕ 23/6/2025 ಸೋನ್ಸೋರಲ್ಲಿ ಪ್ರತಿಭಟನೆ ಹಮ್ಮಿಕೊಂಡಿದ್ದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಆದೇಶದಂತೆ ಬೆಂಗಳೂರು ನಗರದಲ್ಲಿ ಫ್ರೀಡಂ ಪಾರ್ಕ್ ಸ್ಥಳವನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ಸ್ಥಳದಲ್ಲಿ ಯಾವುದೇ ಮೆರವಣಿಗೆ ಧರಣಿ ಯಾತ್ರೆ ನಡೆಸಲು ಅನುಮತಿ ನೀಡಬಾರದೆಂದು ಆದೇಶಿಸಿರುತ್ತದೆ. My lord, now my lords, if I kindly take your lordship to order passed by division bench of this honorable court at page 27. Para 5, my lords, page 27. In view of the aforesaid submission made before this court, which is placed on record, we dispose of this writ petition with a direction to the respondent to ensure the compliance of the provisions of the order of 2021 in the latter and spirit and to continue to initiate actions against the persons. My lords, division bench of this honorable court, my lords, has not stated the protest and marches should be restricted to Freedom Park. Division bench has only stated that, my lords, in compliance of the order 2021. If I kindly take your lordship to that order, my lords, it's at page 33. Lordship, get it, my lords? Section 4, my lords. The venue for the protest in Bengaluru city is identified as Freedom Park. However, depending on the situation, Commissioner of Police may also designate any other suitable place in the city for the said purpose. It is not that, my lords, it is restricted to only the Freedom Park. My lords, what happens is, my lords, in Bengaluru there are 28 assembly constituencies, my lords. All cannot be directed to come to Freedom Park and conduct protest. Every constituency will be having its own reasons for conducting protest, my lords. I cannot be directed to conduct protest only in Freedom Park is concerned.
You find out. AGA is directed to accept notice for the respondents. The petitioner submits that in terms of the licensing and regulation of protests, demonstration and protest marches, Bengaluru City Order 2021. In terms of subpara 4, the Commissioner of Police may also designate other suitable place in the city.
Please.
And the government requires to take appropriate steps to designate other suitable place apart from Freedom Park, for say of the state. Relist the matter on
16th, 21st.
My lords, this order needs to be passed by Commissioner of Police. Notice may be issued to respondent number 2 to 7.
Yes, yes.
20th, 21. Great. Vinos Kumarian.
My lord, this is a writ of mandamus, my lord. However, by mistake, my lord, instead of Annexure G, I wrong document I have placed. I may be permitted to replace Annexure G, my lord. Annexure G. By oversight, my lord, representation, wrong representation has been affixed while filing, my lord.
I'll have it tomorrow, you replace.
Please, my kind.
Petitioner is permitted to replace.
Please, ma'am.
Annexure G, release the matter tomorrow in the same stage.
Much.
On serial number 20, nobody has sought any adjournment, my lord, in serial number 20. Both sides are here.
Maybe some mistake.
My lord, sorry.
20?
Somebody else must have mentioned, my lord, something else, and by mistake, my lord, it must have happened. We can. My lord, the petitioner is an NBFC, non-banking financial company, my lord, governed by the RBI regulations. It had, my lord, the fourth respondent, Nanjundaya, my lord, had borrowed loan from it. And, my lord, page 23, my lord, is the sanction letter. Your lords cannot turn the page, my lord. Then 29 is a term loan, but more important is, please come to, my lord, page 87. He had mortgaged the property. The sale deed, my lord, which your lordships get, my lord, at running page 74. 74 is the sale deed under which he purchases in the year 2006.
Yes.
89, my lord, if your lordships come to, there is a memorandum of entry, a registered equitable mortgage created in respect of this property. Page 87, my lord, it starts.
Yes.
And if your lordships come to, my lord, page 95, the property, my lord, which is a property, which is a mortgage, my lord, is there. Then, my lord, what happened was, there was, my lord, he was one of the directors, my lord, in a cooperative, my lord, the bank, credit cooperative bank called the society, called, my lord, the Kanva Sauharda Credit Cooperative Credit Limited. There was, my lord, ED, there was some, my lord, they had taken 650 crores as public deposits, lent, my lord, 702 crores, out of which it was alleged 402 crores have been given, my lord, to related parties. Therefore, my lord, ED, Enforcement Directorate, initiated proceeding, page 100. And, my lord, attach this property without you notice to me. If your lordships come to, my lord, running page, the property, my lord, which is the subject matter of, my lord, our mortgage, is, my lord, there 150, my lord, 150, entry 23.
Yes.
Nanjundaya. That, my lord, attachment was confirmed by, my lord, the adjudicating authority under, my lord, the PMLA. Then, my lord, the appeal was filed by the petitioner before the appellate tribunal. In the meanwhile, my lord, we issued notice under section 13(2) for initiation of, my lord, proceedings under the Surface Act. Now, my lord, the state government under the KPID Act, my lord, that protection of investors, depositors Act, they, my lord, issued an attachment in respect of this without even making me a party. My lords may turn to, my lord, page 285. They, my lord, attach this and then, my lord, go before the city civil and sessions judge. I am not made a party. And, my lord, this property, my lord, is brought for, if your lordships turn to, my lord, page 341, property, my lord, which is mortgaged in our favor, my lord, is brought for sale. We are not made parties. This is not a property of, my lord, the Credit Cooperative Bank. It is, my lord, personal property of Mr. Nanjundaya, which, my lord, even before he became, my lord, the director, my lord, of that cooperative bank, my lord, Credit Cooperative Bank, my lord, he had purchased this. This order, my lord, is now, my lord, challenged by us before your lordships. I am not made a party. Principles of natural justice have been violated. I am, my lord, I am, my lord, a person, my lord, in whose favor there is a mortgage, registered mortgage. Therefore, my lord, I am challenging this order because I am not even made a party. They were aware of, my lord, the sale deed and the mortgage. Yet, my lord, it's a registered mortgage under section 3 of the Transfer of Property Act, my lord. They know that, my lord, I am a person in whose favor it is.
Yes.
My lord, can you take page number 19, my lords, the prayer? Prayer A, my lords, page number 19 of the memorandum. Issue a writ, I'm able to point out, please, my lord. Issue a writ of certiorari or any other appropriate writ, order or direction, quashing the impugned common order dated so and so, insofar as it affirms an attachment of the scheduled property. So what essentially and substantially is in challenge before this honorable court is an order passed by the honorable special court under section 5(2) of the act. Your lordships have taken a view that any order passed against anybody and any person so aggrieved shall have to approach the appellate court, and writ is not the remedy. My lord, may kindly take note section 16 of the act, my lord.
But they're saying that they were not notified at all.
Please, Lord, I have got two humble submissions for that. But section 16 says any person aggrieved by any order. So even if at all it is a grievance of the petitioner that he has not been heard.
Correct. That is there, we'll consider.
My lord.
But what do you say regarding the submission that the
Yes, please, Lord.
confirmation of attachment is done in their absence?
Please, Lord. Section 10, kindly be seen, Lord. The act, my lord, provides for 3 mechanisms.
Section
10, my lord, may kindly take. The KPID Act, my lords.
Yes.
First, 12, section 12, my lords. Before 12(3), my lords may kindly take section 3, clause 3, my lords. But as far as pleading ignorance of the facts are concerned, my lords may first take section 3, clause 3 of the KPIDFE Act, my lord. So section 3(2) would speak of, my lords, the government passing section 3(2) order, the ad interim attachment order. 3(3) says the government shall notify the ad interim order made in the official gazette. But I will not find fault if somebody has not gone through the official gazette. Even I have, lords, perhaps not gone through. And 2 newspapers having wide circulation, and shall also cause to be affixed a copy of such order on some conspicuous place of the property so attached. So my lord, there is a constructive notice, my lords. My lords may now kindly take 12(3), my lord, 12(2) and 12(3) on for the specific contention that they have not been heard and hence, my lords, a violation of principles of natural justice. But 12 clause 3, my lords, may kindly take. Any person, section 12 clause 3, my lord, powers of special court regarding attachment 1 and 2, my lords, may kindly permit me to skip. Section 12 clause 3, my lords, may kindly appreciate. Any person claiming an interest in the property attached or any portion thereof, notwithstanding that no notice has been served upon him under this section, make an objection as aforesaid to the special court and at any time before an order is passed under so and so. So now, my lords, to come up and say that I have not been heard in the matter and hence violation of principles of natural justice is writ large, is not acceptable. In as much as, my lord, the constitutional validity of, my lords.
No, we are not on that.
Subsection 2, my lord, of section 12.
Correct. What I'm saying, even if the statute is silent,
please
suppose there is a public document. He's a person who has some interest.
Please, Lord, if he had any interest, my lord.
His interest is there.
He should have.
You have to notify him.
No, please, Lord. Kindly see section 12 clause 3. Section 12 clause 3.
Even if the act is silent.
ಅಲ್ಲ ಇಲ್ಲಿ ಬೇಡ ಅಂತ ಹೇಳುತ್ತೆ. ಸರ್ವ್ ಮಾಡದೆ ಹೋದ್ರು ಸಹಿತ ಅವ್ರು ಬರಬೇಕು ಅಂತ. Section 12 clause 3, my lords, may kindly read again. Any person claiming an interest in the property.
You read 12(2).
12(2), please, my lord. The special court shall also issue such notice to all other persons represented to it. If at all somebody were to represent before it.
The highly technical argument.
Under 7.
Now, suppose the encumbrance.
Please, Lord.
Now they are claiming that they have got the property. His property has been mortgaged.
Please.
Now the register of encumbrances has their names.
Please, Lord.
So then they must be notified.
Well, point 1, Lord. If it is not forthcoming in the revenue records.
No, it's there.
My lord, encumbrance certificate. I'm
Encumbrance.
giving my learned friend.
I have not been able to find that, but my lord, once the Lawrence Council says that it is there, I will not, my lord, you will see the document, my lord. Giving you
No,
the document
correct.
itself.
Now, we are only on the point.
Please, my lord.
Now, he has to be notified under subsection 2.
Section 12.
2, my lord, says any person who represents to the special court that he has an interest has to be notified. So this clause, my lords, may not be applicable. Kindly see, my lord, the special court shall also issue such notice to all other persons represented to it as having or being likely to claim any interest in the property, calling upon so and so. So 2 is not applicable, my lord. 3, my lord, will kindly see. 1, please, my lord. Upon receipt of an application under 5, the special court shall issue to the financial establishment and to any other person, if any, whose property is attached by the designated authority under 3, a notice accompanied by the copies of the application and affidavits and of the record of evidence, if any, calling upon them to show cause on or before a date to be specified in the notice why the order of attachment should not be made absolute.
So this is also absent.
Please, my lord, but 3, my lord. My lord, kindly.
No, 3 comes later.
Please, my lord.
3, 12, 1.
Please, my lord.
First, even before confirmation of attachment under section 5.
Please, my lord.
Before making it absolute, on receipt of an application for confirmation.
Please, my lord.
Special court shall issue to the financial establishment.
Please, my lord.
Now they have mortgaged to that financial establishment.
Please.
And to any other person.
Please, my lord.
So that has to be done procedurally.
In all humility, my lord, 12(1) is not the only section. If my lords were to read that, my lords, in all humility, it would be that my lords are not
We'll consider that, but this you can't attach and bring to sale a property.
Please, my lord. Section 3 is very
key. Is a different stage. 3 is preceded by 1 and 2.
Please, my lord. 1, my lords, if at all I file a 5-2 petition after section 3, clause 2, the court shall, my lords, hear or issue notice to the financial establishment or to any person whom the property belongs to. I'm afraid, my lords, the property does not belong to, my lords, the petitioner herein. And point 2, my lords, if at all I have not done so, the special court has not done so. If at all somebody were to represent before it, then he shall have to be heard. And 3, my lords.
1.
1, my lords, 3 is more of a proviso, my lords. Section 3.
We'll see. It requires
second submission, my lord.
Requires hearing.
Or second submission, my lord.
Requires hearing.
Second submission.
Now I can't do a final hearing.
Second, their entire, my lord, the right stems from the fact that under SURFACE, they have a first right. If my understanding is
no, there's a mortgage in my favor, registered mortgage.
So ultimately, SURFACE. Ultimately, my lord, SURFACE is going to be invoked. The Supreme Court said, Lord, the Supreme Court has held that the rights of, my lords, the first charge holders under SURFACE shall have to yield to the MPID Act.
Correct. So now that point will decide whether they have a right that you point out that Supreme Court judgment.
Because the difficulty, my lords, is this. I have already auctioned the property. Second time, I have a bidder. He has made a part payment. I also kindly see the judgment. Only 2 paragraphs of the Honorable Supreme Court judgment. I'll bring it to Lordship's notice. Lord. Ultimately, the question is whether SURFACE would prevail over KPID or vice versa. Or would be the some substance of this, my lord. My lord, for a minute, permit me to refer, my lord, to the judgment of the Honorable Supreme Court. Sir. Yes. My lords, may kindly take page number 2, my lords. Sir? Page illa, sir. Sir.
ಅಲ್ಲ ಅದಾಯ್ತು ಇಲ್ಲಿ ಪೇಜ್ ಇಲ್ಲ ಯಾವ್ದು ನಮ್ಗೆ ಅಟ್ಲೀಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳಿದ್ರೆ ಏನೋ ನೋಡ್ಬೋದು ನಾನು Para 1.
My lords, paragraph 1. The 2 prepositions, my lord, that the Honorable Supreme Court, my lords, posed. One was, if I'm permitted to read, my lords, whether the secured creditors would have priority of interest over the assets attached under the provisions of Prevention of Money Laundering Act and Maharashtra Protection of Interest of so and so by virtue of the provisions of SURFACE Act 2002 and RDB Act 1993. But this was one of the questions. And the Honorable Supreme Court, my lords, by virtue of a judgment dated 15th of May 2025 has categorically held that the provisions not MPID is pari materia with KPID, my lords.
That we have to decide that. We have to decide that, isn't it? Now, whether MPID is pari materia or not, we have to make an inquiry.
Plus, it may be taken up tomorrow itself, my lord. I have
No,
to produce a table.
No. We cannot take up like this. You complete your objections, we'll hear the matter. We'll see.
Plus, may I make one submission? That, my lords, the auction has already gone ahead. The auction purchaser, my lord, successful bidder has already paid part payment. So, my lords, may kindly permit me to go ahead, subject to the outcome of the petition.
No, that can't be done. It has to be decided at this stage. Prima facie, one procedure is not followed.
My lord, may I very respectfully bring
The
to
mortgage made in favor of the NBFC and they have a right, irrespective of the fact that KPID Act may have overriding charge, which is a matter with respect to which we have to still record a finding. This court has not recorded a finding.
But the Supreme Court has, my lords.
On which act?
Plus, MPID Act, my lords.
That inquiry, we have to apply our mind to that and see whether everything is the same and then pass a order that will settle that issue at rest. We'll see.
May I, my lords, may I be permitted to go ahead with the auction proceeding, subject to the outcome of the petition?
No, that can't be done. You'll have to put it on hold till this issue is decided.
I'm the safe hands of your lordships, my lord. I will leave it.
We'll see. Let us
please.
There's no judgment till now, is it, on KPID?
No.
Allah, Supreme Court, my lord, earlier, my lords, there were judgments of
Not
this.
your lordship, my lord court. No, now our court has no.
Earlier, my lord, there were judgments of this court which were held against me, my lord, on the ground that the central enactment will prevail over the general enactment. But this question fell for consideration of the Honorable Supreme Court. But there the question, my lords, was whether the provisions of MPID would prevail over IBC, SURFACE, RDB, my lord. But every state, save for the state of Assam, my lords, have same act, my lords. Only the sections may change, the numbering may change, but the sum substance of all the acts, my lords, is one and the same. In fact, my lords, in the Canara Bank matter, which your lordships have given a date, I prepared a table to show how exactly the sections of the MPID Act correspond with the sections of the KPID and also, my lords, the TNPID Act, my lord. So now the Supreme Court, on a categorical analysis, my lords, of the aims, objectives to section 254, clause 3. In fact, my lords, two grounds that were available have perhaps not been even considered, which would be in my favor. But once the Supreme Court says so, my lord, it's a gospel truth. At least still, my lords, the judgment is revisited by the Honorable Supreme Court, the larger bench. So as of now, my lords, is absolutely the only thing that my lords are entertaining the doubt is as to whether the provisions of KPID are pari materia with MPID. But that will not detain me for long, my lords. A short date may be given. In fact, the table is ready in some other matter. I'll be able to produce that before the Honorable Court, my lord, because several matters of this nature, my lords, are before different courts. What happens, my lords, is that though the Supreme Court, my lords, has given a go-ahead, we are not able to, lords, we are not able to reimburse the money. So, my lords may fix up any date, my lords. I am ready to assist the Honorable Court.
AG accepts notice for the first respondent. Learned Counsel Viresh Budhyal undertakes to appear for the second respondent. Then AGA for third respondent. Third and fifth.
Third and fifth.
Emergent notice to the fourth respondent. The petitioners have challenged the order dated 8/6/22 passed in miscellaneous petitions under section 5(2).
Yes.
Under section 5(2).
Please.
Of the KPID FE Act. It is the case made out by the petitioners that they have a registered, they have a mortgage by deposit of title deeds which has been registered, and the said transaction appears in the register of encumbrances.
Yes.
It is submitted that without notice to the petitioner who has initiated proceedings under the SURFACE Act, the attachment under 5(2) by the special court has been made absolute. Full stop. It's submitted that this would be in violation of section 12(1) of the Act. Full stop. Learned counsel appearing for the respondent. Competent authority submits
one indulgence,
that
because it is not the financial establishment, my lords, which is before this honorable court. But financial establishment would, my lords, in terms of the definitions, refer to, my lords, that errant financial establishment who has taken the deposit. It is not, my lords, the financial establishment.
Let us see, just 1 minute. Just 1 minute. The counsel Shri Veeresh Budhyal would submit that the procedure under 12(3) would do away with any prior notice or cure the defect of prior notice. Full stop. It's further submitted that the KPID-FE Act has been held, is to be held as superseding the SURFACI Act, and reliance is placed on the order passed in WP Civil 995 of 2019 in the case of National Spot Exchange Limited versus Union of India. Full stop. Next. It's also submitted that there is an appellate remedy available. Next. Must be noticed that no doubt normally the matters would be relegated to availing of substantive remedy, but the exceptions for exercise of writ jurisdiction are well settled. Prima facie, court is of the view that making absolute attachment without notice to an encumbrance holder would come within such an exception. Full stop. Matter requires consideration also as regards to whether the law laid down in National Spot Exchange Limited in the context of the which act was that? Maharashtra, is it?
Please go on. MPID Act.
Maharashtra Protection of Interest of Depositors within bracket in Financial Establishments close bracket Act 1999 could be extended to the KPID-FE Act as well. Full stop. Accordingly, subject to further consideration, the second respondent, there would be stay of
Order of auction, my lord, in miscellaneous case number 514 of 22. Only one lord. That
out of special court itself has to be stayed. Out of special court itself has to be stayed.
Stay of order at annexure.
514 is better.
Annexure K. Annexure
K.
Annexure K till the next date.
As far as the property of the petitioner is concerned.
So far as the property of the petitioner is concerned.
Please.
Relist the matter. The AGA, you will also have to take your stand. Relist the matter. The 10 days date.
29th.
Auction notice also has to be stayed. There's an auction notice which is
and
issued.
consequent auction notice
At annexure L.
At annexure L. Let us see, let that aspect be decided once and for all.
Please.
Just wait a minute. Then there's no auction. Aga, where is that judgment? You would this judgment he gave, no? He said he'll make
These two
page in
fresh matters. Serial number 1, Mahesh's.
Appear for the petition matter. Well, this matter arises out of an arbitral proceedings matters. The petitioner, petitioner is the claimant before the honorable arbitral panel, where respondents 1, 2, and 3, and 4 are the respondents panel. And the petitioner has sought for extension of the mandate matter under section 29A5 of the Concession Act.
29
5A. 29A5, sorry. Seeking extension, my lord, of the mandate for a period of 6 months.
My lords, you're appearing on behalf of respondents number 1 to 3, my lords.
Yes, 29.
My lord, to make it easy, they have no objections for extensions, my lord.
No, just
very well. 29A5.
I like it hard, the hard way. 29A5.
5 minutes.
Yes.
The extension of period referred to in subsection 4 may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. So, my lord, though this arbitral proceeding is a bit delayed, my lord, of a very rarely, my lord, of nearly 6 to 7 years for various reasons, my lord. It was delayed for due to COVID and for settlement, my lord. Nevertheless, the honorable arbitrator was kind enough to permit for extension, which was periodically granted. And this extension, which we sought, my lord, was for a period of 6 months. My lord, your lordship may kindly go to the impugned order. At page 54, my lord.
20.
Your lordship got it, my lord?
Reasoning starts at
Reasoning at 56, my lords.
59. 56, is it?
56, Avatar. May I read, my lord?
So those are contentions.
Contentions, my lords.
Reasoning.
Your lordship, I can see. Page 58, my lord.
Yes.
This court expressed its opinion that as the arbitration proceedings since continuing for the last years, if the applicant is allowed to wait for the orders of MFA and AA and thereafter giving an opportunity for him to argue on merits, it will be an honor on contingent circumstances. My lords, here, pausing for a moment, this MFA, what the honorable court is speaking about is, my lord, is that the learned arbitrator had passed to interim orders, and we have challenged it before the honorable high court, my lord, and stay is granted in this matter. Stay of the arbitral proceedings is already granted, my lord. Presently, it is pending the operation.
Okay, now what is the relief you are seeking?
My lord, relief is instead of 2 months, which the honorable court as commercial court has allowed, it should be 6 months, my lords.
Now, this order is not an appealable order.
No, my lord, directly it has to be approached this honorable court. That was we looked into it.
So now we were to stay this order. No.
Stay or your lordship can extend eventually after the disposal of the MFM, my lord, where the arbitral proceedings is presently
Still pending.
still pending. After the exclusion of that stay period, my lord, this will continue. Therefore, if your lordship is pleased to extend to 6 months, again approaching this honorable court with the same application would be.
My lords, we seek 2 weeks time to file our objections, my lord. I appear for respondent number 4, my lords. I'll also place my objections on record, my lords, in a week's time.
So then we'll have it after 10 days.
The minute to be statement.
Let us.
In the minute
Correct. But now, what will happen now to the arbitration proceedings?
Well, in the event if this MFA, which is posted on day after tomorrow, if I'm right, my lord, if it is disposed of, again I have to revert back to this order, and this order would expire because it is given effect from 9/1/25 for 2 months, and that would come to an end, my lord.
So let them take their stand. I'll have it next week, and then we'll see what is to be done.
Please, but in the meanwhile, I pray for a stay, my lord, but limited side, so the continuity will be in operation.
What do you say?
My lords, there is already a stay in the other 2 MFAs that have been filed, my lords.
what I have
Stay on the arbitral proceedings. I leave it to this honorable court, my lords. There is already a stay
Then
in
let us
operation.
see. If now
Granted in February
there's
this
a
year.
stay in the MFA, we'll have it. We'll fix a date. We'll see what happens to the MFA now. Now,
Whether
without-
it's allowed or not,
No.
my humble submission is, irrespective of the results of the MFA, I'm only on the continuity. My application may be allowed or dismissed. That is not the issue.
So just one, I want to clarify. Now, suppose we were not to stay this order.
Please, my lord.
What would be the consequence?
The consequence today with the last date of the mandate. Again, I have to approach this honorable court. Because of lordship, kindly see the
May I make a submission, my
order.
lords?
It is the application, the order, my lord, page 60.
Yes.
The application filed by the applicant under section 25A of arbitration concession is partly allowed. 2 months time is granted, extended from completion of arbitral proceedings for the date of receipt of this order. 9/1 is the.
Now, anyhow, according to you, there's a stay in the MFA. So even if we were to stay this order,
Nothing will.
Proceedings cannot go on till the MFA permits the proceedings to go on. I'll stay this and have it after 10 days.
Please,
You take your stand, we'll see what is to be done. Meanwhile, if
Very
something happens to the MFA, there ends the matter.
Please.
Certainly.
Yeah.
Wait.
Contentions made out. There would be stay of the order. Stay of the order passed under 29A of the Arbitration and Conciliation Act till the next date. Relist the matter on
Any date, Your Lordship.
23rd. It is noticed, one sentence, it's noticed that there is a stay of the proceedings before the arbitrator in MFA.
No, not before the, before, I mean, stay and operation of this impugned order, my lord. If that is stay, once in the writ petition, subject to the results of the writ petition.
MFA.
I'm sorry, it is writ petition, my lord. I'm placing the orders also. Two writ petitions. I'm sorry, it's not MFA.
Stay of?
Stay of the impugned order, my lord, under challenge. Because arbitral proceedings are already stayed. I have sought for two reliefs. One relief staying of the arbitral proceedings before the WP, which is already stayed, my lord.
Now this is in a separate writ, is it?
It's separate writ, my lord.
Then why this writ again?
This writ for the extension of the mandate, my lord.
It's one sentence, but it's already noticed that there is an interim order passed in WP 808 of 2025 and WP 566 of 2025 as against the very same impugned order.
No. As against the order passed by the learned arbitrator, my lord.
As against the order passed
in the arbitral proceedings.
As against the order passed by the arbitrator in the arbitral proceedings.
Please.
Accordingly, in effect, till such orders are vacated or modified, proceedings before the arbitrator would not continue. Relist on.
This order has to be stayed.
This I have done.
I
I only noticed that.
Very well. Notice, very well. Grateful.
Yes.
12th February, my lord. In
Serial number 2.
Bring the petition. This is, my lord, pertains to caste certificate, my lord. Pertains to cancellation of caste certificate by the validity. And appellate court also held, my lord, the validity order of the caste verification committee is proper. The issue is this, my lord. The case of the department is, my lord, by submission a report for denying the validity certificate that, my lord, the petitioner family is held, the migrated from Tamil Nadu. But, my lord, it is not that case, my lord. I have produced, my lord. My father was.
Let us see. We have to hear the other side.
One submission, my lord. I am not in employment, my lord. By already I am dismissed, my lord. I am not in department. The only apprehension, my lord, by virtue of this order, there are chances to register criminal case. That's my, to that extent, my lord, I may be protected. Because similar matter, my lord, is already stayed and pending, my lord. The prosecution may follow, my lord, certainly.
No, as against that order, you have appellate order, you have come in.
Yes, before this court. Annexure A is the order of the DCVC, my lord. The annexure B is, my lord, the order of the appellate court. Where, my lord, the concurrently it is held, I have not produced the document. The documents which are produced by me, my lord, not even referred. The number of documents which I have produced, my lord, I have already placed before this court. In every document, my lord, my caste, residence, and everything is shown.
The learned counsel Sri Gautam Devullal undertakes to appear for respondents.
All respondents.
All. For the respondents. In the interaction.
No, respondent number, my lord, 7 is KSRTC. Where I was appointed.
1 to 6.
Yes.
KSRTC. HR Renuka, learned counsel HR Renuka is directed to accept notice for the 7th respondent. In the interregnum, there will be a limited interim relief to the extent that the respondent authorities are not to initiate any criminal proceedings till the next date
Pursuant to it.
pursuant to the impugned order.
Yes.
Yes. We
Obliged.
serve copy.
Yes.
D. Samir SN, serial number 3.
My lord, in the tender notification dated 13/2/2025, I have participated and I was the lowest bidder. Subsequently, my lord, they didn't issue the letter of intent and they have issued the fresh notification, my lord. That is at page 12 to 49, my lord.
Now, on what ground you are?
My lord, I am the lowest bidder, my lord. Without
Correct. Is there any order cancelling it?
no, there is no order, my lord. They have called for the fresh bidder for the same purpose, my lord.
Where is it?
My lord, that is at page 12 to 48, my lord. That is, my lord, may kindly come to page 13.
No, where is your bid?
My bid, I have, my lord, they have called for my technical bid as well as the financial bid, and I have participated. Now, the
Under the KTPP Act, is there any provision if you are going to cancel, you have to give a reasoned order?
no, my lord, but without any reason, my lord.
There must be
If
some.
we get instructions, my lord, I got served a copy.
Huh.
Lordship, I have it tomorrow, my lord.
AG
I'll
accepts
make my
notice.
submissions.
Tomorrow is the last day for receiving the bids, my lord.
Respondents 1 to 3. Emergent notice to the 4th respondent. Zilla Panchayat Shimoga.
Manla advocate.
E. Nagarajappa is directed to accept notice for the 4th respondent. Is the matter in the same stage tomorrow?
Tomorrow, my lord.
Now, there must be, somebody was arguing there is some provision under the KTPP Act that if you're going to cancel it, it should be on ground 1 and 2 only.
13th, my lord, but I'll verify again. And
Release tomorrow. You also verify.
I'll
4.
One number. One number.
Yeah.
2303. Shaman.
It should go to local bodies. Roaster. Local body. No, we'll ask. Office to verify and list the matter before the appropriate roaster.
Lords, I'm appearing on behalf of the petitioner, my lords. My lords, it's a writ of mandamus seeking for police protection, my lords. My lords, the petitioner herein is a company which is involved in promoting residence for the lower income group, my lords. They're currently in the process of setting up a project in Kolar, my lords.
You are being threatened by whom?
My lords, these are unknown miscreants, my lords. At the first instance, they tell me they are on the behest of the erstwhile landowners, my lords. The land is absolutely held by me. There is no dispute with respect to title, my lords. And I've also produced the sale deeds and the power of attorney that was given to me, my lords. And even RERA approval has also been produced, my lords. My lords, the issue here is, my lords, these unknown miscreants on a day-to-day basis, my lords, produce photographs that annexed to H, my lords. They just come, my lords, and threaten saying, please give us some money, otherwise, well, the copy was already served in the morning as well. And
30 will get.
Let them find out.
Lords, in fact, the only apprehension is, my lords, my employees and my laborers on a day-to-day basis are not even able to come to work, my lords, by the threatened.
Tomorrow?
Tomorrow. Lords, until at least tomorrow, there might be a.
No ex parte order, nothing will happen. Now you telephonically intimate them.
Yes,
Telephonically intimate them. If there's anything, obviously they have to take action.
Yes, my lord.
We'll have it tomorrow, you get instant.
Tomorrow.
Lords, in fact, I just want to place on record a memo as well, my lords, in a
No similar, sir. No similar.
No,
These are all
just for-
no, these are all factual.
Please, ma'am.
Let them find out what is there as a precedent for interim order. AG accepts notice for the respondents. Relist the matter in the same stage tomorrow. You find out telephonically, you inform.
Yes,
if there's any occasion for them to be protected, they must take action.
Much obliged.
Petition this matter, my lord, I am challenging the press e-tender announcement dated 21/6/2025, my lord.
on first my lord, 14/10/2024 notification issued to dispose of a total 11 11 lakes my lord, for the year from 2024 to 25 to 2028-29 my lord. On 6/11/2024 my lord, I have paid 1,13,333 rupees for a undi my lord. On 4/1/2025, e-tender bid is confirmed and ordered the fishing rate of the Manigere water tank in favor of me my lord.
Annexure?
Annexure E my lord. Dated 21/6/2025 my lord. They have not given any notice to me my lord.
No, this
So I am ready to.
No, this e-tender is in, they have completed it. Have they
Yesterday is the last date my lord.
Huh?
Yesterday ಆರ್ಥಿಕ ಬಿಡ್ ತೆರೆಯುವ ದಿನಾಂಕ ಮತ್ತು ಸಮಯ 7/7/2025 11 ಗಂಟೆ.
Correct. Now
Kindly,
you are challenging it on what ground?
Yes.
On what
I am
ground?
the successful bidder my lord.
Where?
On 4 Annexure D, as per Annexure D my lord.
Annexure D.
Yes my lord. 4/1/2025. Kindly. Page number 44 my lord. Adesha.
Ekamatra biddar.
Yes my lord.
Only single means then it has to be
E-tender. Year my lord, the fisheries year commencing from my lord July 1st to.
No, correct. Under the KTPP rules.
Yes my lord.
When the single bid, then it has to go re-auction. They have done the re-auction.
But my lord, I am entitled to this year my lord, because of the January is not a fishing year my lord. As per.
You cannot do that. You participate in this. Have you participated or no?
Yes, I have participated.
You have participated. So let them, let us see.
No, this bid is not, I am not participated.
Why did
because
you not?
my lord, I have on January 1st 2025, the bid was ordered on me.
No council, that bid goes.
Yes.
It's invalid because it says single bid.
Yes.
So that bid goes.
So it was single bid.
Why didn't you participate in the tender?
But January 1st 2025, I am the successful bid holder. I have paid entire amount.
That bid goes because you are a single bidder. It's not valid. Then you should have participated.
But I have not commenced any fishing activities to my lord. I have paid 1,13,000 rupees to the government. But even
no, that they'll return. They are duty bound to return it to you. But you have no right. Single bid goes, and then they reopen it and they have done fresh. You should have participated in this.
Permit me parties.
Now how we can bid? Now let us see. You find out what is the status. AG accepts notice for the respondents. Relist the matter in the same stage on 11th.
Till date, my lord.
Let us see. Yes.
Release of vehicle.
Huh.
Identical circumstances are covered by plenty of judgment. Page number 17, my lordship, produce the judgments. Sought for release of the vehicle.
Just ಇನ್ನೊಂದು ಯಾವುದು ಇತ್ತಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ತಿದ್ದೀನಿ ರಿಲೀಸ್ ಆಫ್ ವೆಹಿಕಲ್ ಅಂತ ನೋಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
Page number 17.
Page
17. Identical sought for release of the vehicle. Application pending for the respondent office. Identical circumstances some courts are allowed and direct considered without institute of bank guarantee. Several plenty of judgment is produced.
Application is pending.
Huh?
He's filed an application for release of the vehicle. We'll consider it, your lordship.
It's still pending.
Still pending. In accordance with
You
law,
take note of these other orders of the coordinator. Petitioner is sought for a direction to the respondent to consider application dated 14/5/2025 filed seeking release of lorry bearing number so and so which was seized in connection with FIR
FOC number
in FOC number so and so rear A. It is the stand of the respondent state that still orders are to be passed on the 71 capital A application of the petitioner. 71 capital A
Karnataka Forest
of the Karnataka Forest Act. Full stop.
Page number 17.
Further, counsel for the petitioner submits that the normal practice of insisting on furnishing bank guarantee ought not to be followed in light of the orders passed in WP 11491 of 2025 and similar orders passed by this court. In light of the limited prayer, the application of the petitioner at annexure A to be decided expeditiously while keeping in mind law laid down in WP 11491 of 2025 and similar matters to the effect that the authority is not to insist on furnishing of bank guarantee while may impose other reasonable conditions. Accordingly, petition is disposed of.
Within 1 week.
The application of the petitioner at annexure A to be disposed of within
Within a period of 15 days.
15 days.
That much of.
Generally, we don't insist, but they preempt and come before this matter before.
Recreation club. Recreation club. Yes, next.
Much of it.
Plus petitioner. Plus challenging my lords annexure F1 my lords. Plus petitioners society my lords to carry out my lords fishing in the Nugu reservoir.
Yes.
Jilla Panchayat, my lord, is the guardian for this lake. They'll have to answer. I'll take notice, my lord, for 1 to 4. Panel advocate, my lord, may have to answer for 5 to 7. They're the ones who have passed the order.
Because now they were restricted my lords not to do fishing my lords. Even my lords they were allowed in the Kabini reservoir my lords saying that my lords there are tribe people are my lords doing the fishing. My lords in our society also my lords there are 68 members. Out of 68 my lords 25 are members are the tribes my lords. And my lords 2 from scheduled caste, 25 from.
Let us you take out notice. AGA accepts notice.
1 to 4.
1 to 4. 1 to 5.
1 to 5.
1 to
1 to 5, my lord.
1 to 5.
1 to 4, I'm sorry. 1 to 4, 5, 6 and 7, my lord, panel advocate.
1 to 4. Jilla Panchayat Mysore. Engineer. Third Council A Nagarajappa is directed to accept notice for 5, 6 and 7. List the matter in the same stage on. Serve copies.
I'll serve copies my lord. Tomorrow, day after tomorrow my lord. Because my lords they were restricted my lords they're not doing fishing activities.
Monday will have.
Friday at least. Friday or Thursday.
Friday reach agala.
Monday. The same stage my lords.
Thursday. Same stage.
Please.
On Thursday.
Thursday. Please.
9.
Petition.
Rajesh, yes.
I'm challenging the e-auction tail notice, my lord. Issued by the respondent back, my lord. Yesterday is the auction, my lord.
Auction is done, my lord. Today confirmation is being issued.
Sale confirmation is not done, my lord. Sale confirmation is not done, my lord.
But today they have paid, my lord, and 25%.
Property of the petitioners, my lord. So only properties belongs to them, my lord.
No, correct. No, what is the illegality now?
Total due is the 1 crore 50 lakhs, my lord, as per their sale notice, my lord.
Correct.
They are ready to deposit some amount, my lord.
Auction is already taken place, my lord. Auction is already done yesterday. Sale is being confirmed today.
Now, even in so far as LIC Housing Finance, DRT it goes.
Yes, yes.
DRT.
Yes, my lord. Let them approach DRT and.
Then you go to the DRT. Anyhow, by their sale certificate will take some more time.
Yes.
Roughly how much time for you to issue sale certificate?
15 days, my lord, from the date of auction.
15 days.
15 days. Today sale is being confirmed, my lord. So from today, 15 days we will be issuing sale certificate.
So you go before the DRT and within 2 weeks.
Protection may be granted, my lord. Within 4 weeks, I will approach, my lord.
No, correct.
Till then, my lord, protection may be given.
No, my lord, intimata may not be passed because sale is already being confirmed today. Purchase is ready with the balance 75% amount also.
So you move before the DRT within 2 weeks. Anyhow, 15 days it will take. 2 weeks, I'll say not to not to issue sales certificate.
3 weeks.
3 weeks.
Formalities are there, my lord.
No, I'll send him to DRT.
Okay.
I'll impose a condition 3 weeks. Don't issue sales certificate. Okay. Let him work out.
Because today sale will be confirmed, my lord. 25% they will be paying
Not
today.
coming in the way of that.
Okay.
Only saying sales certificate not to be issued.
Okay.
The petitioner has called in question the validity of the e-auction sale notice dated 3/6/25. The petitioner has raised various contentions.
Yes.
As regards the procedure to be procedural irregularities. Full stop. Petitioner has also sought for petitioner also submits that he is exploring the possibility of a one-time settlement with the bank. Next. Learned counsel, so and so appearing for the respondent, submits that auction that was scheduled on 7/7 was fruitful, and there is a successful bidder in the auction proceedings. It's further submitted that the petitioner may avail of substantive remedy by approaching DRT under section 17 if aggrieved. Repeat para 1 to 6. Para 4 ಅಲ್ಲಿ respondent bank para 4 ಅಲ್ಲಿ not to issue sales certificate for a period of 2 weeks from today.
3 weeks.
Or 2 weeks.
3 weeks from today, while clarifying there is no stay of the confirmation of sale option.
Confirmation of sale.
Objection first time, serial number 10, Srinivas V.
I appear for petitioner. I will comply with the office objection, my lord. In
I'll
a week's time.
undertake to file power mail. M. Mohammed Ibrahim undertakes to file power for the first respondent bank.
But in this case, we are challenging the sale certificate, my lord.
Wakalat.
M. Mohammed Ibrahim undertakes to file wakalat for the first respondent. My lord, they are already before the DRT, 3 essays have been filed challenging the same sale certificate, my lord.
I have avoided in the writ petition. That is,
Respondent
I
number
stated so in my writ petition also, my lord. Why I am before your lordship? If your lordship permits, I will say, my lord, the reason is, my lord, what is the amount when due was 1 crore 20 lakhs, my lord. Now, my lord, they have auctioned 3 properties, each for a sum of rupees 1 crore and odd. My lord, if one property is retained by them, auctioning, another 20 lakhs if I pay, they can release 2 properties. My lord, petitioner number 3 and 4 are purchasers from the borrowers. That is, all of them have been arrayed together as a petitioners in the instant case. All of them have filed different essays before the DRT. I made a submission even before the DRT also. If 22 crores, 22 lakhs, 24 lakhs is paid, my lord, let them retain one property, my lord, for auctioning. Let them give one property to the auction purchaser. Property which have been sold by the borrower, that is to the petitioner number 3 and 3.
During the
Let them
subsistence of
release.
mortgage, my lord.
Sir.
During subsistence of mortgage.
Just let
One
him
ನಿಮಿಷ. My lord, so 24 lakhs ನಾನು ready to pay. ಇವಾಗ 24 hours time ಕೊಟ್ರೆ 24 lakhs ನ ಕಟ್ಟಕ್ಕೆ ready ಇದೀನಿ ಸುಮ್ಮನೆ.
What is this 24 lakhs?
My lord, total auction amount was 1 crore 24 lakhs.
Auction.
ಒಂದೊಂದು ಫ್ಲಾಟ್ ಸೇಲ್ ಆಗಿರೋದು 1 ಕೋಟಿ 2 ಲಕ್ಷಕ್ಕೆ ಸೇಲ್ ಆಗಿದೆ. 3 ಫ್ಲಾಟ್ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ಅವಶ್ಯಕತೆ ಇದ್ದಿದ್ದು ಅವ್ರ ಲೋನ್ಗೆ ಒಂದು ಕಾಲ್ ಫ್ಲಾಟ್ 3 ಫ್ಲಾಟ್ ಅನ್ನು ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. 1 ಫ್ಲಾಟ್ ಅವಶ್ಯಕತೆನೇ ಇರಲಿಲ್ಲ, ಆದ್ರೂ ಆಕ್ಷನ್ ಮಾಡಿದ್ರು. ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಗಿಂತ ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಅಲ್ಲೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಬೋದಿತ್ತು. ನಾನೇನ್ ಹೇಳ್ತಿದ್ದೀನಿ, ಈಗ 1 ಕೋಟಿ 2 ಲಕ್ಷಕ್ಕೆ ನೀವೇನ್ ಆಕ್ಷನ್ ಮಾಡಿದೀರಾ, 1 ಪ್ರಾಪರ್ಟಿನ ನೀವು ಆಕ್ಷನ್ ಕನ್ಫರ್ಮೇಶನ್ ಮಾಡ್ಬಿಡಿ, ನಾನು ಅದನ್ನ ಚಾಲೆಂಜೇ ಮಾಡಲ್ಲ. ಐ ಡೋಂಟ್ ಲೇ ಚಾಲೆಂಜ್ ಟು ದಟ್ ಕ್ಲೇಮ್, ದಟ್ ಫ್ಲಾಟ್ ಅಟ್ ಆಲ್. 2 ಪ್ರಾಪರ್ಟಿ ನಾನು ಈಗಾಗಲೇ ಪೆಟಿಷನರ್ ನಂಬರ್ 3 and 4 ಮಾರಿದೀನಿ. ಅವರುವೆ ಬ್ಯಾಂಕ್ಗೆ 30 lakhs ಒಬ್ರು, 32 lakhs ಒಬ್ರು NOC ಕೊಡೋಕ್ಕೋಸ್ಕರ ಡೈರೆಕ್ಟ್ ಆಗಿ ಅವ್ರ ಅಕೌಂಟ್ ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಒನ್ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ. ಈವನ್ ದ ಬ್ಯಾಂಕ್ ನೋಸ್ ದಟ್ ಫ್ಯಾಕ್ಟ್. They have also transferred certain directly to my housing loan. Now, my lord, under these circumstances, I am ready to pay 24 lakhs upfront. ನಾನು ಇವತ್ತು ಅಂದ್ರೆ ನನ್ಗೆ ಇವತ್ತು ಕಟ್ಟು ಅಂದ್ರೆ ನಾಳೆ ಕಟ್ಟಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ ಸುಮ್ಮನೆ. ನಾಳೆ ಕಟ್ಟಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ. ಅದು 2 ಪ್ರಾಪರ್ಟಿ ಬಿಟ್ಕೊಡಿ ಅಂತ ನಾನು DRT ನಲ್ಲೂ ಕೇಳಿದೆ. DRT ನಲ್ಲಿ ಏನು ನೀವು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಡಿಲೇ ಇದೆ, ಡಿಲೇ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಆದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ. ಅಷ್ಟರೊಳಗೆ ಅವ್ರು ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾನು
The
ಬಿಫೋರ್
entire
ದಿಸ್.
issue is,
ದಟ್ಸ್ ಆಲ್.
it is not so simple, my lord. My lord, the property which was mortgaged, he constructed apartments, he sold during subsistence of mortgage. Earlier, the same petitions were before your honors. Your lordship said go to DRT. And then when sale was conducted, they filed 3 SS, my lord, which is pending adjudication now. Same relief they sought. How I can say that, I mean, a person who was sold the property which is mortgaged to me, should I listen to him, leave this property, leave that property? I've sold all the properties and balance amount is credited to his account. Sale certificate is issued. Possession is delivered, nothing remains. Same thing I have stated in the DRT. The matter, same matter is pending before DRT.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ, ವಾಟ್ ಎವರ್ ಇಸ್ ದ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ 24 lakhs ಏನಿದೆ, ನಾನು ಅಪ್ ಫ್ರಂಟ್ ನಾಳೆನೇ ಕಟ್ತೀನಿ.
ಸ್ವಾಮಿ, ಏನು ಬ್ಯಾಲೆನ್ಸ್ ಇಲ್ಲ, ತಮ್ಮ ಅಕೌಂಟ್ ಗೆ ನಾವು ರೆಮಿಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀವಿ. ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಸ್ ಇಶ್ಯೂಡ್. And can your lordship pass order without them? Already all the 3 sale certificates have been issued.
That is why I am before this court and even before the
And already DRT 3 SS are pending, my lord.
I have not suppressed the fact before this court that I am not before DRT. ನಾನು ಹೇಳೇ ಇಲ್ಲ, I am before DRT. I am
already DRT ಇದೆ, pending ಇದೆ. Let the matter be adjudicated there.
ಅಲ್ಲೂ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ, ಇವ್ರು ದುಡ್ಡು ಕೊಟ್ಟು ತಗೊಂಡು ನನಗೆ 2 ಪ್ರಾಪರ್ಟಿ
ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ.
ಮಾಡಿರೋದನ್ನ ನಾನು I have already sold. I was not the owner when this thing happened.
Anyhow, you go through it, get instruction. I'll have it next week. Who is the second respondent?
He is one of the purchasers. And out of 3 purchasers, they have made only 1 purchaser as a party.
ಅದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್, ಬೇರೆಯವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ ಸರ್. I will make
The petitioner is at liberty to implead the other purchasers as well. Emergent notice to the second respondent. So and so accepts notice of first respondent. Relist the matter on next
Need a, my lord? On 21st, my lord, next week.
My lord, if your lordship permit, may I amend here itself, my lord?
Yes, petitioner is granted on oral request is permitted to implead the other purchasers as well. Emergent notice to the newly added respondents also. Relist the matter on
21st ಬೇಡ ಸರ್, 21st DRT ನಲ್ಲಿ ಇದೇ ಮ್ಯಾಟರ್ ಇದೆ ತಿರ್ಗಾ. ಅದಕ್ಕೆ ಮುಂಚೆನೇ ಆಗ್ಲಿ ಸರ್, ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗ್ಲಿ ಸರ್.
15th.
15th much obliged.
But now you have to convince the bank.
No, but sale is taken, how we can?
No, correct.
The reason why I don't know why my friend is agitated.
But now
I am ready to pay the amount.
No, correct. They issued sales.
When OT was given, he refused to pay, my lord. When OT was given, he was refused to pay. When properties are sold, now they are making huge income, my lord.
Now, my lord, property is worth more than 2.5 crores. They have sold it for 1 crore 14 lakhs. And my lord, what is the necessary for them to action, my lord, when the reserve price itself was more than 87 lakhs per flat? Balance was 1 crore 23 lakhs. They could have auctioned only through properties, 2 flats. What was the necessity for them? It was a mala fide excess of power by the bank.
In the auction, the reason why they sell it for less is nobody is ready to come.
My lord, this is the 7th action, my lord.
Nobody
not one.
Nobody is ready to come. And the auction, usually their lordships keep granting stays.
11. Aruna,
I am for the petitioner, my lord. We have just done the compliance, my lord. My lord, this matter is regarding the DRT exceeding its jurisdiction and forcing me to
You
pay.
serve copies. Just only serve copies.
My lord, I will serve the copies, of course, my lord.
You serve copies.
My lord,
you must wear your uniform, isn't it? You may be doing it from office, sir.
Yes,
but
my lord. I'm sorry.
You must wear your uniform.
I apologize, my lord.
Now you serve.
My
Canara
lord,
Bank.
yes, my
Canara
lord.
Bank.
Yes, I will serve, my lord. My lord, only one point, only one submission I
appear for
have.
Canara Bank. Sandeep is.
Yes.
Only one humble submission, my lord. There is an e-auction on a sum which is not legally enforceable. I call the attention of my lord to the definition of debt under
Let
the
us see.
surface.
You serve, we'll have it tomorrow. You serve copies. Serve
tomorrow.
copies, we'll have it tomorrow.
Tomorrow, of course, my lord.
When is the
My lord,
auction?
may I request list one, my lord, in list
When is
one
the
first.
auction? When is the auction?
Auction notice is issued in 2023. We challenged it before DRT through an essay, but DRT also exceeded the limitation, my lord. When there is only a debt of 45 lakhs, I am asked to pay 3 crore 64 lakhs, my lord.
But you have to go to DRAT. How we can decide
I
now?
have done an essay, my lord. DRT is saying there is no such rule when it is clearly defined in debt.
No, no, then you
in
have
the
to go
surface.
to you have to go to DRAT. How I can decide here?
My
Anyhow,
lord,
I'll have,
there is a breaking of statute which through which I
let
can
us see.
invoke the
Let us
constitution,
see.
my lord.
So and so. No, no. Let us see. So and so
Please,
undertakes
my
to
lord.
accept notice for respondent. Relist next week date.
Next
How
week,
is it?
Swami, tomorrow, Swami.
No, no, no. Now already the auction is over long back. How we can now
My
stay it?
lord, auction was stayed by DRT, my lord. Let me clear my
No,
stand,
the
my lord.
correct DRT order is passed. You have to go to DRAT. How I can
DRT order was, yes,
intervene?
my
I
lord.
am not
Yes, my lord.
intervening.
Yes, my lord. My lord,
DRT order you have to challenge.
it need my lord's intervention because whenever there is a statute which is deliberately broken, I can knock the doors of this honorable bench, my lord, and I have done that only. There is a break of statute, my lord. They are trying to enforce
us
it
see.
out without the due process of law, my lord.
Let us
My
see.
fundamental rights is breached, my lord. And
Let
this
us see. Let
e-auction,
us see.
anytime they can start, my lord, unless my lord give me a short date or hear it today for a stay, it's going to be a big trouble for me, my lord. It's the only house I am staying.
No, that's a different
Me and
matter.
my,
You serve copies. You serve copies. We'll see.
I'm
Relist the
serving right away,
matter
my
on
lord. I'm serving right away. In 1 hour, it will be served, my lord.
Monday. Monday. Yes, Monday.
My lord, kindly tomorrow, my lord. List one, my
No,
lord.
no, not
My
tomorrow.
humble
Not tomorrow.
request, my lord.
No, we'll see what to do on the next date. You serve copies on the advocate.
Number 12.
Appearing for the petition.
Oblige, my lord.
The petitioner is hereditary Archakuras. Karagada Devaru temple of Bidrugupe Lordship is notified temple. It comes under Mujrai institutions. Whatever the dispute between the Archak or the Bhaktas or the other properties, it has to be decided by the deputy commissioner and the competent authority. But in this case, your Lordship, the respondent constituted a committee called as.
Yes, government. Yes.
So called as Karagadamma Kote Lakshminarayana Devasema Trust anta madkondo, they have filed an appeal before the Assistant Commissioner under the Land Revenue Act, that is Jilla Panchayat Act. Whatever the dispute that has been between the temple archaks or pujaris or the devotees, it should be decided by the Hindu Religious and Charitable Institution Act. It is a full-fledged act and they having its own appellate authority, revisional authority. Instead of doing so, Your Lordship, he has approached the Assistant Commissioner and thereafter I filed an appeal under section 299 of the Panchayat Raj Act. The Assistant Commissioner has passed the honor in page number 109, ink page number, Your Lordship, 29. Your Lordship, turn it to Your Lordship.
Page?
Ink page number 29. Annexure A. Deputy Commissioner, Assistant Commissioner as a Jilla Panchayat, sorry, as a executive officer of the Taluk Panchayat, he has no authority at all. It is only Hindu Religious and Charitable Institution Act has to be looked into. And on that basis, proceedings has to be conducted. Instead of doing so, with a malafide intention, they approached the Taluka Executive Officer and filed appeal, and they have passed an impugned order without looking into the statutory power. And though even he has no authority to entertain the appeal, it is only Deputy Commissioner has to decide because it is a notified temple.
The notified temple, there is a Rajya Dharmika Parishad.
Huh?
Commissioner under the Rajya Dharmika Parishad, Jilla Dharmika Parishad, then appeal to the Rajya Dharmika Parishad.
How the Rajya Dharmika or Jilla Dharmika Parishad, it has to decide it.
Under section?
20, yes, I will submit section 20, Your Lordship.
21 is the Jilla Dharmika Parishad.
Yes, Your
Now, now what is under section?
My learned friend is making an allegation that the act itself, they have initiated action, the Jilla Panchayat Act. Whereas if it is a notified temple,
yes,
the action has to be initiated on the Hindu and religious and charitable law.
Section 20.
The section is 20, Your Lordship.
20A.
Yeah, 20 is the Dharmika
20
Parishad.
20
20A
capital
is
A.
the power of the Rajya Dharmika Parishad. 20A, Your Worship.
Now
Yes, Your Honor.
here the
The
dispute is between whom?
dispute claims to be the dispute between the Archak and the devotees.
So then we'll stay this.
Yes.
The petitioner.
I don't have the file because copy is not served.
Observe, sir, because today itself I'll give.
So we'll have it tomorrow, have a look
Huh?
at it. AG accepts notice for the respondent number.
File ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
The government is not made a party here.
Government is not made a party.
You make the government as a party, they'll
Yes, I
also,
will implead him, implead Your Worship.
the petitioner is permitted to amend the cause title and array. Array the
Karnataka by Murza department. State of Karnataka by Murza department.
I will make it State of Karnataka and also Mujarai Commissioner will implead
array
both of them.
additional respondents. Full stop. Permission is granted upon oral request made. Necessary amendment to be carried out. Relist the matter tomorrow.
In the
Tomorrow we'll see.
much obliged.
13, Ravi Prakash.
My lord, I accept the notice on behalf of respondent. Copy of the petition served upon me, my lord.
Lords, the issue is, my lords, the auction sale is set down tomorrow, my lords. The outstanding amount, my lords, is 34 lakhs 15,000. We protected till I approach the DRT for two weeks, my lords. The auction may not, my lords, if the property is auction, sale certificate issued.
Lord, I have
And
one
this is a very
submission in
small
this-
property, 420 square feet. And my lords, the outstanding amount is only 34 lakhs and 15,000, my lords. I'll make the payment before the DRT, my lords. We protected for 2 weeks.
Yes,
I have
Let them
one
not go ahead with the auction sale.
I have one
Yes.
submission. My lord, sale is, my lord, indicate tomorrow. But my lord, earlier rounds of litigation, the petitioner, my lord, approached this honorable court in writ petition number, my lord, 8159 of 2023. Wherein, my lord, in that writ petition, he undertook within 2 months, my lord, he is going to pay the entire money. That undertaking, my lord, recorded in the writ petition, and writ petition got disposed on, my lord, 19/8/2024. My lord, in fact, he is not complied that undertaking. And my lord, now coming up with a one more writ petition before this honorable court. My lord, it is true, my lord, it is outstanding is, my lord, 34 lakh 51,000. In the earlier rounds of litigation, my lord, this honorable court given, my lord, stay and stay is operated more than 6 months. It is therefore, my lord, my respectful submission, my lord, it is not the first time they, my lord, approaching this honorable court.
Lords, apart from the merits of the matter, lords, the property is 420 square feet in NR colony. The reserve price is 44 lakhs, lords. This is the only property where I'm residing now. One opportunity may be granted so that I approach the DRT, my lords, and
Now, anyhow, if you were to, we will not stop the auction if any.
Please, my
Now,
lord.
if nothing comes, it goes there itself.
Goes there, true, my
Isn't
lord.
it?
Please,
So
my lord,
we'll
please.
protect him for 2 weeks.
Not
And,
to issue the sale certificate, my lord, my sale may go on. My lord, in fact, it is 2022 NPA, one of the old NPA in our branch. Sale may go on. I may, my lord, directed, my lord, not to issue the sale certificate. I will not issue sale certificate for in case sale taken place for a period of 2 weeks.
my lords, if they are willing to, my lords, not go ahead with the auction sale. Right now, today I will
My lord,
deposit 7 lakhs.
I would
my
have
lords, in the
not
bank.
objected, my lord. I would have not objected if the petition is the first time coming for this honorable court. His earlier
Out
occasion, he
of
approached this honorable
34
court.
lakhs, my lord, 7 lakhs I'll deposit today. For the
It
rest
is a
of it, I
question
will
of,
go before
it's
the
not a
to
question
prove
of
my
money, my
bona
lord. It's a
fide.
question of, it's a question of conduct.
I understand, my lord.
Vignesh Shetty accepts notice for the respondents. The petitioner has called in question validity of the auction tender cum auction sale notice dated 13/6/2025. The petitioner has raised various contentions regarding the undervaluation of the property, including regarding undervaluation of the property. Third counsel for the respondent bank submits that the petitioner has not come with clean hands insofar as undertaking to clear the loan account dues made in WP 8159 of 2023 has not been adhered to. Next, it's further submitted that substantive remedy is under section 17 of the SURFACE Act as regards the impugned action. Next. Repeat, para 1, 2, 1, 2, 3, 5 and 6. Para 4 ಅಲ್ಲಿ one ಬರ್ಕೊಳ್ಳಿ. It is made clear that though the auction stated to be held tomorrow is not stayed. However, in the event the auction is confirmed, no sales certificate to be issued for a period of
2 weeks.
2
2 weeks,
weeks.
my lord. 2 weeks.
3 weeks, my lord.
3
All right.
weeks.
No
3
issue.
weeks.
Grateful. Deeply applied.
14.
Appealing for the petitioner in this case, my lord. Office objection is made good. And with respect to office objection number 1, a counsel submission is made that registry is asking to make a DC as a party, which is not warranted. So counsel submission is made in that note, my lords.
You are challenging annexure A.
Annexure A, my lords, arising out of the order of an AC under Senior Citizen Act, wherein, my lords, petitioners are the sons of the respondent.
Why DC is a necessary party?
Not required, my
You have made the AC as a party.
Yes, my lord. AC is also not made as a party, my lords. There is a statutory authority who passed an impugned order.
No, correct. But practice is they're making you, I'll give you permission, you make it.
Oh, please, my lord. I will take it, my lord. I will comply, my lords.
Petitioner is permitted to array the assistant commissioner as an additional respondent. As it is the assistant commissioner has passed an order at an HRA which is challenged. In light of the oral request made and permission granted to implead the assistant commissioner, necessary amendment to be carried out. AGA accepts notice for the newly added respondent. Yes, what have you challenged?
My lord, I am challenging your order passed by the.
I make one submission, my lord. It may be taken up day after tomorrow, my lord. K-Waiter's counsel is, he has inconvenience, my
You
lord,
appear for the first respondent.
for the K-Waiter.
K-Waiter.
It may be
K-Waiter
taken
is
up day
long
after
been
tomorrow.
served and they are contesting parties.
Let
My
us
only
see.
concern is this, my
Let
lord.
us see. I'll pass some order. We'll have it day after tomorrow.
Day after tomorrow.
Let them undertake, my lord. They will not take perspective action, my lords, before the tribunal.
Now, what is the order now?
To pay 10,000 each from from the each petitioners. Situation is this, my lord. Respondents has abandoned the family way back in 2008. From thereafter, he never turned up, never been a responsible father, and all through his life, he been a drunkard. That petitioner had a very traumatic childhood. My lords, now, my lords, approaching the authority for maintenance, my lord, we are having due respect to the fatherhood, my lords. Now approaches the authority. My lords, please come to, my lord, page number 19, my lords, which is annexure B. My lords, where the respondent has given his bequeathed property to his brother, now staying his brother. All his earnings has been channeled to him. Now, my lords, approaching authority and harassing the petitioners. And petitioners are taking care of aging mother. She is suffering from age ailments. This has been another added trauma, my lords, by the respondent father.
I'll have day after tomorrow.
Day after. Meantime, my lords, I may be protected because they are taking perspective acting before
Nothing will happen by day after tomorrow. We'll see what will do. Keyword so and so undertakes to appear for the first respondent. He lists the matter on. These matters must be solved between yourselves.
Yeah.
Relist the same stage on 10th.
Obliged, my lord.
You see what it is now. Just see what.
No, I am not on record, my lord. Counsel, he has inconvenience, my lord. That's why.
List 1, serial number 22, Ravi Shankar K.
My lord, I challenge the annexure A and B, my lord, issued by the respondent police authorities, my lord. My lord, petitioner is a practicing advocate, my lord. He defeated candidate in the last assembly election, my lord. My lord, as per annexure B, my lord, he referred case number 1, 2, 3, 4, my lord. No way concerned to the present petitioner, my lord. Except case number 2, my lord, the said case was acquitted in the year 2013 itself, my lord. Unnecessary, my lord, the rowdy sheeter has been.
Let us see.
Please.
You take out notice. AG accepts notice for the respondents. Petitioner to comply with the office objections forthwith. Relist the matter on
Next week.
date.
16.
Same stage, my
Yes.
lord. Fresh matters list, my lord.
Same stage.
Please.
23.
But the sixth respondent, my lord, did not register the complaint of the petitioner, my lord.
Office objections to be complied with forthwith.
And the
To take notice.
EGA accepts notice for the respondent.
only consideration of the
Relist
representation.
relist the matter in the same stage on. You find out, let us see.
16.
If action is to be taken, take and report it. Yes.
24.
Time for the petition.
Yes.
Challenge annexure E, my lord.
Annexure?
Annexure E.
Yes.
Tender notification issued by the first respondent.
Lake.
Yes, tank my lord. As per annexure C,
Ah.
first right was given to the fishing cooperative societies, my lord. The petitioner are the president and secretary of the Maruti Fishing Cooperative Societies. Ignoring the legal position, they have called for tender.
Is it a lift irrigation or other?
No, it's not a lift irrigation, common tank.
All tenders will be through portal now. So now, my lord, he is coming and challenging the notification for tender.
No, correct. But if there's only one society, then you have to give. Find out. AGA.
Allah, next as per annexure C, my lord.
Huh?
As per annexure C, typed page, serial number, page number 16, my lord. ಜಲಸಂಪನ್ಮೂಲಗಳ ಮೊದಲು ಅರ್ಹ ಮೀನುಗಾರರ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಅರ್ಜಿ. First preference was given to the fishing cooperative society, my lord.
Now you are the only society, is it?
I am only societies.
Only society.
Yes, my lord.
Find out. Relist the matter. Relist the matter on
Last may have it on Friday, my lord.
Friday.
Till
the
then,
same stage.
Till then, the same.
Let us see.
Yes, till then, same because the tender has been opened tomorrow. Annexure E.
Annexure.
Tender ಅಂತಿಮ ದಿನಾಂಕ so and so. ಟೆಂಡರ್ ತೆರೆಯುವ ದಿನಾಂಕ 10/7 ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
11th is the last date. Day after tomorrow, any action taken by the respondent would be subject to orders to be passed. Release the matter in the same stage on 11th.
25.
I appear in this case. Petitioner is challenging the applications made by the life convict, that is respondent number 4 and 5, for premature release for remission, your lordship. The main contention of the petitioner is the husband of the deceased, the convicted of a murder of a woman, and
there is the
husband of a deceased, your lordship. Husband of a deceased is challenging the application made for premature release. They have made application before completion of actual imprisonment of 14 years. The actual imprisonment goes to show that 12 years, 6 months and 23 days, your lordship.
Now, on what grounds you can object? What does the apex court order say?
Apex court orders, your lordship, the actual prerequisites for making an application for remission, that actual imprisonment of 14 years must be completed for application as such to be made to the state authorities.
Okay, find out.
Lord, can you come to page number 500 of his petition?
Page
500. Paper book.
Horizontal pages. Yes. 500 is
500. Horizontal pages. Column number 68. Horizontal pages.
You have to redo all this. Yes. Column
68.
Yes.
The number is 12917. It is the petitioner, my lord, Manjunatha Tande Govindegowda. Lord, may see on the right hand side column, ಸರ್ಕಾರದ ಮಾರ್ಗಸೂಚಿ so and so ರಂತೆ ಬಂದಿಯು 12 ವರ್ಷ 6 ತಿಂಗಳು ವಾಸ್ತವಿಕ ಶಿಕ್ಷೆಯನ್ನು ಮತ್ತು ಮಾಫಿ ಸೇರಿ 14 ವರ್ಷ 4 ತಿಂಗಳು 16 ದಿನ ಶಿಕ್ಷೆಯನ್ನು ಪೂರೈಸಿರುತ್ತಾರೆ. So the requisite, my lord, is 14 years. I don't dispute with that at all.
That is what time and again the Honorable Supreme Court has told.
That is correct.
Actual
But
imprisonment without considering parole, your lordship. Actual
Not parole.
imprisonment should be.
Sorry.
Remission.
Remission is different from parole.
They have some
Without
It is
considering.
earned remission.
Here the actual
Remission is different.
Here actual imprisonment undergone by the applicant is 12 years 6 months, your lordship.
Correct. The practice they are following is apart from the actual imprisonment, they are entitled for remission, good conduct, etc.,
Yes, sir,
etc.
sir.
under the
Earned
prison-
remission, that is.
Earned remission. They tag that along with the actual one and do. Anyhow, let them take. You'd accept notice.
No, I should have actually produced the imprisonment certificate, my lord,
Correct.
which I have not produced.
Correct.
I will secure it, my lord.
And
It
also,
may
your
be taken
lordship-
up next week. I will secure it and.
EG accept.
One more submission, your lordship. The office objection stated 3, 4, 5 may be overruled for the reason that I've made an application under RTI, but I could not procure the proceedings of the district advisory committee.
3, 4 and
3, 4 and 5, your lordship. All are connected to the proceedings of advisory.
Once the certificate is produced, it suffices.
There may be
There
call
ends
for
the matter,
records. There may be call for records.
Okay, whatever others you comply.
Others I'll comply during the course of the day, your lordship.
Office objections to be complied with. Office objection at seal number 5 is kept in abeyance for the present. EG accepts notice for the respondent. Learned Additional Advocate General CS Pradeep Kumar appears on behalf of the state. Relist the matter on
15th or 16th.
One request, your lordship, until the next date, the application made by the
No, correct.
may be kept at.
They are not so efficient.
The oral order before this honorable court was made, your lordship, to keep the applications at stay.
We'll see on the next day. Now, it doesn't work as efficiently as you say. On the next date, we'll pass orders. Let them give whatever. Let us see.
Grateful, lordship.
No, the date.
16th.
Grateful.
Grateful.
26. Bharat, okay, 26.
But I appear for the respondents, my lords.
Lords, your lordships had passed an order to place this matter along with WP 18745 of 25, which matter was there yesterday, my lords, but that matter again has been posted to 21st of July. Lordships have already passed an order. I think by mistake, the matter didn't come up yesterday. 21st, your lordships may direct. I'll also ensure, my lords, that it is posted on 21st along with the other matter.
Just along with WP number.
I just
45 of 2025.
make one submission, my lords.
Yes.
On the last date, my lords, I had conveyed apprehensions, my lords, that these matters may not be clubbed for the reason, my lords, that this petitioner has, my lords, no connection with the impugned order. Lords may kindly see the impugned order at Annexure A. It is not, my lords, the order passed under Section 5. It is, my lords, an internal communication of the respondent department which directs its officers to give effect to the order. And, my lords, if my lords may kindly permit, may I just pass on, my lords, the main order pursuant to which may I just kindly pass on, my lords. Sorry. Court officer, sir. Lords may kindly see.
I'm sorry to interrupt, my lords. This is one thing which I have been observing of the statutory authorities, which your lordships may regulate. Lords, either the government or the statutory authorities, without filing an affidavit, comes with the pieces of papers like this and passes across the counter. It's not good practice.
Lords,
They have to
that's-
play because read rules requires that anything which is to be placed on record should be placed at least along with a memo on a prior copy, my lords, being served on the petitioner's counsel or the respondent counsel as the case may be. You should place it on record in a manner known to law so that we will have an opportunity, not that they can pass it across when the hearing is taking place.
Let them have a
Now
look
that
at
your lordships has already
Lords,
taken the
may I
other
just-
matter, my lords,
may I
there
just-
cannot be a deviation from what, this is not correct.
Lords, may I just submit, that, my lords, is the actual impugned order. There's an office objection on
That
this
they have
point
brought it
as
to our
well,
notice, we will take
which was
we'll
not
take
overruled
steps.
till date, my lords.
Let them have a look at it. Please.
Lordships.
Counsel for the respondent files along with memo. Order passed in ERL case number 8 of 2024. Relist the matter along with WP number
18745 of 2025.
18
18745 of 2025.
18745 of 25.
On 21st.
Respondents not to take precipitative actions till the next date.
Please, my lords.
Let us see.
Lords, quote the petitioner, that may be kindly clarified because their
clarified.
schedule is for 4.5 acres.
Clarified that the interim direction is insofar as the petitioner's interest is.
Lordships.
Yes.
27. Serial number 27.
The petition
For the
number 3,
respondent
my lord. Yesterday filed wakalat, my lord. The NOC wakalat filed for petition number 3, my lord. The respondent number 4, my lord, the matter is settled. In respondent number 5 is concerned is pending. Some time may be granted for settle the issue between the respondent number 5 is only. 4 already filed.
Almost 15 years for reporting settlement.
Your colleague previously was taking time. Now something must come out of it. isn't
Lord,
it?
in fact, my lord, the board took a decision, my lord, the matter was placed before the, my lord, KDA board. The board took a decision. Their, my lord, compromise petition has been, my lord, prepared and it is signed by, my lord, a few of the petitioners and the respondent 4 and 5 also 5. But one of the petition is not signing on it, my lord. Then, my lord, matter has to be taken, my lord, and merits and matter has to be decided on merits itself.
2012 matter.
Yes.
Now the order sheet is like the petition.
Lord, I've also placed, my lord, the memo of compromise petition, which was, my lord, placed before the board, before this court, my lord, and a memo, my lord.
I thought this is the
The
petition.
respondent number 5 is concerned. What is
Petition copy.
So far as compromise petition, we have already filed between the petitioners and respondent number 4. The respondent number 5 is some settle ಆಗಿಲ್ಲ. ಅದರಲ್ಲಿ compromise petition ಗೆ respondent petition number 4, 5, 6 have already signed. 3 is ಸ್ವಲ್ಪ difference ಇದೆ. Now
is
Lord,
I will convince the client, my lord, the petition number 3.
Lord, I heard that, my lord, they have filed a suit between them, my lord, because of their, my lord, issue, my lord, it should not. He case, merits ಮೇಲೆ ತಗೊಂಡ್ಬಿಟ್ರೆ ಮುಗಿಸ್ಬಿಡ್ಬೋದು.
Request to take it on merits.
I'll have it next week on merits. By then what you do is do.
Yes, please.
You relist the matter on.
2 weeks time.
10 days
Date
time.
may be fixed for 2 weeks, my lord. We
I
will settle the issue.
10 days time. 21st. Same stage.
28. Shashikant Prasad.
Hearing the respondent back, my lord, I think the matter. I'm filing a memo, my lord, what has been challenged is the CMM order, my lord, which was passed in 2022. And the interim order during that period has not been complied. But subsequently, the account was regularized and upgraded. But again, once again, it is slipped into NPM, my lord, and so we are constrained to issue fresh measure. But what has been challenged is the CMM order in 2022. That does not survive for consideration. So it may be disposed of if nothing survives.
The order of the magistrate.
Yes, ma'am. Because anyway, we have to issue fresh, we've already issued fresh demand notice and all measures will have to be issued afresh. For that,
Just one minute, let me understand. You're saying that the earlier order was not put into effect because of regularization.
yes, ma'am. No, the
That's
earlier
your sub-
order- yes, ma'am. We did not-
So the earlier order passed under 14
Yes.
at Annexure B because of subsequent regularization.
Regularization, yes, ma'am. It got upgraded.
So it-
Now, after 2 years, he's again slipped and defaulted.
No, that's a different matter. That's not a subject matter here.
No, madam.
So we dispose of this.
Yes.
You file a memo.
I've already filed it. Just now I filed. I've served a copy.
The council, the petition. the petitioner had challenged. The order pass of the Principal Senior Civil Judge and CJM Dakshina Kannada passed in Criminal Miscellaneous 78 of 2022 relating to application filed under section 14 of the SURFACE Act. Full stop. Learned counsel for the respondent files a memo which reads as hereunder. Next, it is thus apparent that the impugned order was not put into execution in light of the subsequent events as reflected in the memo. In light of the same, petition is disposed of as not calling for adjudication while keeping open all legal contentions between the parties open. Yes.
29. Take.
Well, file this application for vacating the stay. What is thought to be challenged is annexure B.
Yes. There is an application for amendment that we had filed, wherein Reserve Bank is made a party. There are certain violations of Reserve Bank guidelines by the bank. That amendment, your Lords may elevate.
My question is, preliminary objection is regarding maintainability of a writ petition against the bank, where we have sought annexure B is a legal notice, where invoked. The jurisdiction is in New York, There was nearly 1,063 crores, and Bank of Baroda, New York, has given the money. Your Lordship, may kindly see, give me that. Now, what is the annexure B? Maybe
if your Lordship take this judgment of the Supreme Court, where they say that even against a bank, a nationalized bank, writ is maintainable if they violate the RBI guidelines. In this case, what has happened is $22 million was to be they in my account. They transfer it contrary to the order passed by your Lordship's court. In fact, there's an order passed by your Lordship's court stating that you will maintain status quo. After the order is passed, they transfer $22 million of mine from my account, which on which they have no right at all. And Reserve Bank guidelines specifically mandate that they can't transfer this against the norms of the Reserve Bank guidelines which I have placed. Therefore, one application I have filed for amendment.
Kindly hear my vacating stay, all that application can be considered. Here, my lords, your Lordship may kindly see this is a method to adjourn the matter, my lords. Your Lordship may be able to demonstrate how the writ petition is not maintainable. And my lords, by virtue of the interim order, my lords, we are not able to proceed. Nearly 1,063 crores is liable to be paid by them, my lord.
Lord, in this case, I don't owe them any money. What has happened is, they, my lord, my account, they, my lord, transfer, my lord, 22 million to my subsidiary in USA. I mean, we don't even know where they have sent, not even to the subsidiary.
Your Lordship may kindly say just a brief note. Your Lordship may permit.
Can you give me a copy, please?
Kindly give a copy. Your Lordship may just kindly take the.
Please.
Your Lordship may kindly take this. This explains the whole case,
my petition.
My vacating stay application is pending. I'll just explain.
It is come up for preliminary hearing. All right, you argue. I'll point out.
Your Lordship may kindly see, my lord, a restructure agreement was taken, my lord, under which nearly 163 crores was taken by the by MVP Group, my lords, from Bank of Baroda, New York. Matters pending in between the New York branch of Bank of Baroda and MVP, the main borrower in New York, my lord. During that pendency, my lord, the total amount due is actually 1,371 crores. Now, my lord, the petitioner has given a guarantee, my lord, that is dated 9th February 2023. Under the guarantee, my lord, the total amount guarantee given is 55 million, my lord, that is comes up to 472 crores. Out of which, my lords, we have only taken 22.2 crores. Balance 283 crores is to be paid by them yet, my lords. Now, by virtue of an interim order, my lords, we are not able to recover that money. While taking money, my lords, RBI guidelines is not violated. Only while giving back, my lords, all these RBI guidelines is violated. And all these agreements, my lords, there's an agreement under New York. Not even one document, my lords, which is relied upon by the petitioner as jurisdiction in India.
And the person who has given the money, Manoj, Bank of Baroda, New York, is not made a party at all. Only Bank of Baroda, India is made a party. Manoj, this is clear, nothing but abuse of process of court, matters of the year 2023. 2 years, Manoj, now last week, after 2 years, they seek to file an amendment saying RBI guidelines is violated. They have already taken interim orders violated, assuming it 2 years back, Manoj. They don't move the matter. Now, after we move an application for vacating the stay, Manoj, all this question arises, Manoj.
28/7/2023, my lord, I filed the application for amendment. They, my lord, RBI is made a party. RBI, my lord, does not even come before your lordships. Please come to my lord. My learned friend says, my lord, this court does not have jurisdiction. Please come to my lord. If your lordships turn to my lord, page 143, the guarantee that I have given.
No, but what is being challenged is annexure B.
Correct.
Yes, my lord.
That is only a communication.
Correct.
Correct, my lord. Correct. And my lord, in my amendment, I am also, my lord, seeking, my lord, certain other prayers. In fact, my lord, when we filed the petition, money had not been sent. Thereafter, my lord, they sent the money, contrary to the Reserve Bank guidelines. And that's why, my lord, we have made that application for amendment. If your lordships come to, my lord, page 143, it's the, my lord, non-exclusive jurisdiction. Your lordships have the power, my lord, and the competence to, my lord, entertain.
No, but what is challenged is only a communication.
Correct, my lord. Absolutely, my lord. That is against, my lord. Please come to, my lord, my amendment application. Please come to, my lord, the application that we have filed for amendment. Page 15 of my amendment. Issue a writ of mandamus directly responded to return the amount of $22 million and accruals therein remitted from the petitioner's account on March 30. MVP, my lord, what they have given, my lord, is not these people have not given. New York, my lord, bank has given. I have, my lord, I have not, my lord, received that money. Please look at, my lord, my application for amendment. And I have specifically said Reserve Bank guidelines have been wholly violated, my lord, when they remitted this amount. And therefore, my lord, I have sought for this amendment.
Just both of you make a list of dates.
All right, we'll do that.
I'll have it on Monday.
Please,
Monday, beda. 16th agboda. Monday, some.
Both sides to file.
Hala,
List of dates and synopsis.
17th, my lord.
In the same stage on
Please.
17th. On
Please.
17th.
17th. Grateful to you. Interim order, whatever is there, my lord, to continue.
Modern observation is extended to the next day.
Please.
Can I request one more connected matter is there, my lord, the WP number, where they have taken a contention in that writ petition. We have invoked the bank guarantee. We have invoked the personal guarantee. They say this court, we don't have jurisdiction because it arises in New York. Your lordship may kindly see WP number. I'll just give it to the court officer, my lord.
That has got nothing to do with.
No, it has got, your lordship may have.
All right. I don't know.
I'll point out, my lord, two contrary stands have been taken. In that case, very same petitioner says that New York court has jurisdiction.
All right. I don't know. I'm not even.
The WP numbers.
I'll just give it to the court officer.
Yes.
30.
Avinash BC, CS number 30.
Petition. Lordship, I appear for both the respondents. Respondent number 2 is an ARC. Respondent number is 1 is the bank which extended the loan. So it is assigned to respondent number 2. Usually it is respondent number 2 who will be defending the matter. But here what has happened is they have raised certain issues which is prior to the assignment date, saying that NPA was declared without conforming to the standards.
Yes, regarding alternative remedy, what do you say?
No, my lords, I appreciate. It is a decision of, it's a consistent decision that when a NPA date has been impugned, please, my lords, this honorable court has jurisdiction. If that NPA has been declared violating the norms of the RBI, then this honorable court, my lords, kindly pass.
That aspect also DRT can look.
Absolutely, Lordship.
My lords, may kindly see this judgment, please, my lords.
For that, Lordship has to come to the view that it is violated.
Supreme Court judgment on this point. That's all covered. NPA, there is a judgment directly on the point.
And the reason being,
no, there's a judgment directly on classification of NPA is a matter
Please.
that
And here,
DRT will look.
the reason being, my lords, if I may make my submission. My lords, here the case is, my lords may kindly see prayer A. All I have asked is the declaration of the non-performing asset, which is undertaken by the respondent number 1 bank, is to be, my lords, held as, my lords, wrong. The reason, maybe kindly see, my lords, and the rest of the other prayers are all consequential in nature.
Directly covered.
Lords, may kindly have page A, annexure A for a moment, please, my lords. For a moment.
This point is directly covered. Even classification of NPA you have to raise before the DRT.
My lords, the reason being, my lords, if the classification of NPA, if it is a gross non-application of mind, my lords, include, my lords, gross non-application of mind, my lords may kindly see, I am not challenging the law for the matter. If they have, my lords, overlooked even the minimum required standards for declaring me as an NPA, it will, my lords, the jurisdiction will lie before my court, this honorable court. I'll just demonstrate, my lord. I'll just take not more than 60 seconds.
Now you place what the latest position of law regarding classification of NPA and jurisdiction. Have it on Monday.
It may have.
I'll have it on Monday.
Tuesday.
Matter-
My lords, may kindly.
Same. I have consistently.
It may be had on Monday or Wednesday, please. My lords.
Wednesday.
16th.
I've
Interim order may be extended.
I've consistently not relegated matters there. You get a point, this judgment on the point.
Further, I'll make one submission, my lords. Wednesday, please.
Yes.
31.
I'm per the respondent.
Narayan Swami.
Subsequent to the present writ petition, I initiated the proceedings before NCLT, my lord, wherein they undertaken to settle the dispute on 25th April 2025. And the prayer of this petition is to direct the respondent to consider the offer. So the matter is capable of decide themselves, it's my lord, because 2011 is the last payment they made.
You are going to settle them at what is it?
That is what their submission before NCLT.
My lords, with regard to the submission, my lords, made before the NCLT, my lords, I'm not aware. I'll just take instructions on this, my lords. I'm not representing the petitioner before the NCLT. The lordship may kindly have it next week in a date, my lords. I'll take instructions.
The prayer is to direct the respondent to consider the representation. Let them make any representation for settling the dues. No, nothing can prevent them.
Relist the matter on
any date, my lords, next week. By then I'll take instructions.
Then counsel for the respondent files a memo and produces copy of the order dated 25/4/25 passed by the NCLT. Same is taken on record. For the say of the petitioner regarding the same, relist the matter on
17th.
Yes, next.
32.
Obliged.
Preliminary hearing list.
Same list, same stage.
Appearing for the petitioner in the above case, my lord. My lord, here the petitioners are bona fide purchasers, my lord.
I
The
beg
matter
to
can be
appear on
referred
behalf
to
of respondent.
mediation, my lord.
I appear for the auction purchaser. I'd oppose this request for referring it to mediation. Your lordships had heard it. Your lordships noted that they had already approached the DRT. Suit was also filed. A submission was made. They have gone before the DR80 Chennai. They were to place the appeal number before DR80 before your lordship, so they could be permitted to pursue that remedy. For that limited purpose, it was adjourned, my lord.
Your lordship, they are
After
bona fide
hearing.
purchasers, my lord, and they're willing to pay the money also to the bank, my lord. And even if there are any stamp duty charges that has been suffered by the purchasers, they are willing to pay the money, my lord. If the bank is only for recovery of money, my lord, and the purchasers are, and they are being in possession, if it can be referred to mediation, my lord, I request.
No, I'll just point out, my lord, two aspects before this honorable court. I beg to appear on behalf of first respondent. My lord, pursuant to my mortgage, my lord, subsequent to my mortgage, my lord, they are the purchaser. They are claiming, my lord, they are the purchaser of the property. And my lord, I put the property for auction, I sold it. And thereafter, my lord, they approached the DRT in SA under section 17. They suffered an order. My lord, that order also, my lord, they assailed before the civil court. My lord, they are seeking some declared relief against him, my lord, they are the landlords. And last occasion, my lord, this matter heard at length. And they made a submission before this honorable court. We have already approached, my lord, DR80 pursuant to, my lord, order passed by section 17 by the DRT. My lord, they supposed to, my lord, produce the, my lord, order, my lord, and DR80, my lord, case number. For the limited, my lord, purpose, my lord, matter is posted, my lord, next date, today. Therefore, my lord, either, my lord, they have to pursue the matter before the DR80, or, my lord, here, my lord, nothing will survive because they are already suffered an order before the DRT.
Have you gone before the DR80 or no?
I'll just verify on that part, my lord.
No.
Please, my lord.
Tomorrow.
I request.
Tomorrow.
In fact, the council made a submission before this honorable
Yes,
court,
yes,
petitioner council.
yes.
Please,
Yes,
please.
sir. Tomorrow,
Grateful.
same stage. Specific submission was made that we have gone before
I'll verify,
DRAT.
my lord. I apologize. I will verify.
23 appearing for the petitioners, need be adjourned by a week, my lords.
My lord, I appear for the pleadings have been completed. His matter has to be heard, my lord. He has obtained an interim order with suppression.
Interim order has been suppressing. This is a very simple question, my lords, wherein they are a non-governmental organization. The respondent department has invited tenders for the purpose of appointment of field-based NGOs, my lords. Now, my lords, without providing them appropriate opportunity, they terminated their services on the basis of a third-party complaint, who happens to be a rivalry contendant, my lords, for the same tender. Now, my lords, the interim order has been operation, and their tender tenure itself is coming to an end within 2 months, my lords. Therefore,
Let us list week after next.
much of it. Interim order to continue, my lords. In
Interim
both the
order and
matters.
operation is extended till the next day.
Much of it. So,
34.
Affect the state in the matter. A very short question involved, my lord. Certain trees were cut and removed and transported to the government belonging to rosewood category and firewood and bullets and timber. Some payments were not made is what the petitioners claim is. By virtue of an odd payment in 2023, my lords, I'm just producing it to indicate 2 crores 2 lakhs was paid, although he has also acknowledged it in a way. I just wanted to bring it on record to say that we have paid. What is the methodology we have arrived at payment? My lords would permit me to read page 10 of my statement of objections. We have stated how we calculated this. My only request is if my learned friend can give us the difference between his calculation and my calculation, we can work it out is one thing with regarding to the major payment of rosewood is concerned. My lords. The others, as per his own thing in the writ petition itself, he has indicated ಎಲ್ಲ 8-10 ಲಕ್ಷದೊಳಗಡೆ ಬರ್ತದೆ. ಅದಕ್ಕೆ my officers are yet to do the calculation. It is billets, firewoods and timber. ಒಂದು 2-3 ವಾರ ಕೊಟ್ರೆ I will get the calculation done.
No.
And then my learned
Just
senior
one.
friend can.
We fix a meeting between both the parties at your office, and let it be sorted out mathematically.
Please.
Remaining will decide. Within 3-4 days, you fix a meeting.
Yes,
Let
Lord.
both
Next
of you
week
sit and you sort it out.
By Monday, let them have that, man.
Ah.
For the 3 years, my lord, they have
No, we'll solve it.
they have
solve it.
appropriated by money.
No, we'll
And
solve
now
it.
they have come up in a story.
No, we'll solve it now. You have a joint meeting
Please, my lord.
and see what happens and you file a report. I'll ask them to file a report of that meeting.
Let them give the details, my lord.
Next Monday or Tuesday convenience to my learned
Yes.
senior
My lord,
friend.
it's a
Speak to them.
legal issue, my lord, where the
No, factually, we'll see what happens.
factually
And then we'll decide.
they themselves have given us the calculations, and that was well sold. Auction sale proceeds have been taken up by them, kept with them, and only portion of that is released. Now they say what they say 2 crores is a portion of the amount. The other thing they admit in the petition statement itself that they have yet to calculate.
Let us see.
All that for the last 3 years they are making me to run here and there.
The matter,
This is not a recovery
the
court.
mat-
My learned
the-
senior friends want me to say
just, we'll try to solve it.
Please.
The nature of dispute is such that a meeting between both the parties to sort out the differences, factual differences, may be necessary before the court takes up the matter for adjudication. In light of the same, upon say of both the sides, meeting to be convened between the parties on
15th, if my learned senior friend agrees.
on
Next Tuesday.
Even before that, my lord, 15th, let the 15th matter may be listed before the court. Otherwise, I will argue the matter, my lord.
no when do you want for the meeting?
15th is my choice of
No,
date.
let it be there on 14th itself, 15th, let the matter be posted, my lord.
On 14th.
14th.
Monday.
14th.
Or Friday itself, they'll let them have the meeting. And they can't make, because bank is on me, my lord.
Some inconvenience.
I have borrowed money and
Inconvenience on 14th.
I have been issued
Could be on
notice.
15th is what my officer.
On 15th. Relist the matter on 18th.
18th, please, my lord.
Public.
Meeting.
14 ಸರ್ ಮಂಗಳವಾರ 15 ಸಾರಿ 15.
For the petitioner, please.
Respond number 5.
Impleading application is filed. Ministry of Road Transport, Union of India is sought to be made a party because the guidelines are framed by the Union of India, Ministry of Road Transport. The allegation in the writ petition is I am for the petitioner. Within the restricted, David, please, please.
Plead it, let us see. You're ready.
If he is ready, I am ready.
There is no prayer against the Union of India. And neither the guidelines is challenged before this honorable court. We are not proper necessary party to answer.
Let us see.
And my lords, I have submitted last date of hearing, I have submitted on judgment, my lords. The petitioner has no locus, my lords, because it's a trade, my lords, rivalry. My lords, he is challenging the license issued.
No,
in
if he
favor
is
of
ready
me,
on
my
merits, I am ready, please.
lords.
Just wait.
Vacating stay would be disposing the writ petition.
No, let us see.
Since 1 year, my lords, stay is granted, my lords, my shop, the business is stalled, my lords. And my lords, I have, there is 10 lakh liters of diesel, my lords, in the petrol pump, my lords, that also stop. We cannot able to, my lords, to do the business.
Yes.
My lords, as per that judgment, my lords, I have submitted to the court, my lords, the petitioner have no locus standi to challenge the, my lords, trade license issued to the, my lords, trade rivalry.
Paragraph?
My lords, my lords, this honorable court has passed an order, my lords, considering the paragraph 7, my lords, considering the judgment in the Nagar Rice was Flour Mills versus Tikappa Gowda and brothers, my lords. In that judgment, my lords, they cannot. Para number 7, my lords.
9.
Para number page
7,
number 17,
7.
para 7.
Yes, read.
My lords, the issue whether any grievance can be considered on the hands of the rival operator and rival operator shooting from the prisoner's shoulders need not be detained this court for long and develop deep into the matter. The apex court in so and so, my lords, the apex court in paragraph number 9 has extracted, wherein, my lords, section 8(3)(c) is merely regulatory. If it is not complied with, the appellants may probably be exposed to the penalty, but the competitor in the business cannot seek any prevent from the appellants from the exercising their right to carry on the business because of the default. Nor can the rice mill or the appellants be regarded as a new rice mill. Competitions in the trade or business may be subject to such restrictions as are permissible and are imposed by the state or by law enacted in the interest in the general public under Article 19(6), but a person cannot claim independently or such restrictions that another person shall not carry on business or trade so as to the effect his trade or business adversely. The appellants complied with the statutory requirements for carrying on the rice mills operations in the building on the new site, even assuming that no previous permission was obtained. The respondents would have no locus standi for challenging the grant of the permission because no right vested in the respondents was infringed. This is the, my lords, finding given by Supreme Court in the case of, my lords, Nagar Rice and Flour Mills versus Tikappa Gowda and other brothers, my lords. Considering this judgment, my lords, this honorable court has passed an order saying that, my lords, the petitioner, the rival businessman or, my lords, rival the trade, my lords, they have no locus. No, my lords, since 1 year, my lords, because of the stay, my lords, I could not able to carry out, my lords, the business. My lords, even my business already established.
Para 8.
My lords, para number 8. Coordinate bench of this court in identical circumstances following the aforesaid quoted judgment in the case of Prakash versus so and so holds as follows. Having closely perused the guidelines which is prescribed as a distance 300 meters between the adjoining fuel station as also the requirement of the fuel station on the opposite sides on the road which requires to be and contention of the counsel for the petitioner that the since distance between the two stations would be 300 meters would be a bar to the grant of no object certificate cannot be sustained. The bar is with respect of fuel filling stations sustained adjacent to each other and not to the stations which are the opposite sides of the road. This is also applicable to my case, my lords.
Now, what are you challenging?
He's challenging the please.
Leave it to me, I am challenging the permission granted to the by the first respondent to third respondent for establishment of fuel station on National Highway number 75.
Who are you?
I am an existing petrol bunk owner.
What locus standi you have to challenge?
Lordship may kindly see, this is the apex court ruling. Apex court, all the rulings relied upon by my learned friend. Different view has been taken by Supreme Court. Lordship may kindly see page 65. Page 65. aggrieved person. In recent, Lordship got 65. He is relying, in recent cases, the Supreme Court has shifted from the earlier strict interpretation regarding locus standi adopted in Nagar rice flour mills and Jasbibhai Motilal Desai cases, and much wider canvas has been adopted in the later years regarding the person's entitlement to move the High Court involving writ jurisdiction. In the light of the expanded concept of the locus standi and also in view of the finding of the divisional bench of High Court that the order of the excise commissioner was passed in violation of law, it would not be proper to nip the motion out solely on the ground of locus standi, and also such a order to remain alive and operative on the sole ground the person who filed the writ petition has strictly no locus standi. So the contentions requires to be considered on merits. Now the problem here is, earlier they have rejected his proposal. They have rejected his proposal.
How are you aggrieved?
Millards,
How are you aggrieved?
Millards, I am aggrieved because it is 1 kilometer distance should be there. No. I'll convince your lordship on. I am an aggrieved person because my business is being adversely affected.
It cannot be a ground. That's not
No, that is the ground, please, Millards. I will argue on merits, please. I need some time. I will argue on merits. If,
No,
if
Millards,
he is
since
ready,
one
I will argue on
Millards,
merits.
since 1 year, this
It
is
may
the-
take some time.
I'm hearing only on the vacating stay. I'm not going on the merits.
Yes, on merits.
Vacating stay.
Lordship may kindly see, if stay is vacated, it is as good as
No, that's a
disposing
different matter.
disposing the writ petition.
No, that we'll see.
Yes.
Now you tell us.
Yes.
On what basis interim order you have taken?
Yes.
And my lords, in the interim order also said my lords, if the petrol pump is not established, my lords, already in my case, my lords, already established.
Just give this.
We'll have it at 2:30.
Yes, please. I am ready, please.
If you're a rival business owner.
Yes, rival. Subsequent rulings of the Supreme clearly said, if your business is being adversely affected.
Now, where is the violation of the interim order?
As far as my submission
There is
is,
a violation of interim order. Who's preventing you?
No, there is status quo order.
No. If the bunk is not already established.
Established on the
Bunk is not established at all.
Then how are you restrained by this order?
My lords, my lords, they have to the IOC and also my lords, the other department has.
Who's preventing you now from doing it? Only if bunk is not established. If it's established, where is the restraint?
That has to be clarified, my lords, because
Bunk
the
is not
IOC
established.
2:30 you come. 2:30.
Please.
I am ready.
Only on the vacating stay. I'm not
Yes.
taking on the merits.
Milords, one submission, Milords. Milords, petitioner have been employed in Dubai, Milords. Because of the LOC, Milords, he couldn't resume back to his work, Milords, despite having been granted with bail, Milords.
Tomorrow.
11th is the last day.
Tomorrow. You serve the central government standing council in advance.
My lord is serial number 108, some inconvenience stated.
At 2:30 you mentioned. Otherwise you tell the court officer.
ಒಂದು 83 ಏನಾದ್ರು ವರ್ಜನ್ ಆಗಿದೆ ಸರ್.
ಅವ್ರ ಅಪೇರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊನಾರ ಕೊಡ್ಬೇಕು.
ಸರಿ ಸರ್ 83 ಏನಾದ್ರು ವರ್ಜನ್ ಆಗಿದೆಯಾ?
$107 adjourned.
Lord, I am here for the petition. Serial number 140, my lords. 140, my lords, is a writ of mandamus. There is a violation of the racing condition by the Mysore Race Club. So we are just asking for a mandamus for government to consider our representation and pass suitable orders. My lords had directed on the previous occasion, let notice go to the race club and come. As notice has gone to race club, they have appeared. Matter is not reached in the last 3 occasions. Difficulty is that end of July, the racing season will get over, writ will become infructuous. Is it possible, my lords, to take it out of turn?
Let us see at 4 o'clock. You just see it.
I'll come at 4 minutes. Most obliged.
Serial number 22, second list, my lord. I filed a memo for withdrawal, my lord.
20?
22 in the second list, my lord. Yes.
13953.
Yes, my lord. 16489, my lord. 16489. Second list.
22. AP Lokesh.
For the petitioner, I filed a memo which reads as hereunder. In light of the same, petition is dismissed as not addressed.
My lord, the serial number 113, my lord, 113. In past 3-4 vacations, the matter was not got reached, my lord. It surfaced the matter, my lord. The petitioner already approached the bank for OTS, my lord, but they failed to repay. Bank rejected it, my lord.
Let us see. You make a mention at the end. We'll put it in the fresh matters list.
Lordship.
The end you make.
Lordship, list 2, serial number 23. It is defreezing the bank matter, Lordship. It's not reaching from past 4
We
occasions.
reach today. Reach again. Reach again.
List 2, serial number 23.
Let us see at 4 o'clock. You come.
Much obliged, my lord.
My lord, serial number 71 tender matter, my lord. From the last date, 2 dates, it is not reaching, my lord. It is at the final stage. State government has filed the affidavits, my lord.
Let us see today if it reaches. 4 o'clock we'll see.
How many matters are there in
What matters?
143 plus 20.
Lordship, I have one submission. I have one submission, your kind permission. Morning I have given a memo, but unfortunately it's not reached the office. Kindly take me.
It's all connected to one matter. If it collapses, then
My lords,
GMCPC.
small submission, my lords. I've been moving the memo from last 2 days. It's not been listed. It's a senior citizen's property, my lords. It's on the verge of alienation. Senior citizen's property, gifted property.
and then he sent the
Senior citizens gifted property, my lords. It's on the verge of being alienated.
Fresh matter is it?
Fresh matters, my lords.
Tomorrow.
Tomorrow, my lords, tomorrow.
Fresh matter.
Kindly oblige.
Pass over matters. Next one, serial number 5. 4 o'clock.
4 o'clock.
18. Serial number 18. Mithun.
Appearing to the president.
P. Anand.
Petitioner.
Appear for the respondent number 3 in this matter. I advise the state unit
18.
to consider the representation submitted by the district unit. They agreed and they're planning to convene a meeting on 20th of this month because the composition of the committee is 79 across the state members, executive committee members. So the minimum 7 days notice has to be issued. And 20th they'll convene the meeting to consider the representation and the resolution
In terms of the bylaw.
adopted in accordance with the bylaw.
So you file a memo, we'll record it and close it. Nobody has any grievance, isn't it?
No, because a proposal has been given, I have produced your lordship's.
No, correct. Now.
That by district association,
Correct.
if
Now-
they are ready to consider that
correct.
as per 10O, then everything will be.
Yes, we'll do that.
So we'll have it tomorrow, you file a memo. Or today you file a memo.
I'll file.
Pass over. Pass. Yes.
35. Chandrasekhar. 35.
I will be more patient now after lunch. After lunch, the judge is more patient.
I understand.
129, between 125 and 130, it's difficult time. Yes.
I understand. I understand. My lords,
Yes.
before commencing this thing, arguments and merits, with abundant caution, this petitioner, when the documentation of processing of petrol bunk was in progress, this very petitioner has instituted a writ petition before this honorable court in 2366 of 2024. 2366. I have given this thing.
Yes.
Copy of the interim order in that.
Yes.
In that writ petition, please, my lords, this is the thing. This is the writ petition. Prior to this writ petition was filed. In that writ petition, please, my lords, the prayer is, Lordship may kindly.
What has happened to that writ petition?
Lordship may kindly, I'll come to that. I'll come to that.
Pending.
No. It is, I have withdrawn it because of this reason. In this case, please, my lords, earlier writ petition, I have sought for stay of processing of the proposal submitted by the third respondent, that is Indian Oil Corporation, to respondent 1 and 2 for establishment of retail outlet. This is the interim prayer I have sought. Lordship may kindly see the interim prayer granted. Next page, page 13. Page 13.
Yes.
Till such time, there shall be an interim order of stay as prayed for. This was granted on 14/2/2024, please, my lords. 14/2/2004, not to process this very Indian Oil Corporation's application. Now, Lordship may kindly see, on the very day, third respondent issued NOC. On the very day. It's at Annexure B, page 30.
Respondent number 3 was IOC. Maybe they were not served in that.
To demonstrate my bona fides with abundant caution. Now they are saying we are put to loss, that, this and all. Now, my lord, my first submission is the writ petition is petrol bunk on, this is the dual carriageway, please, my lords. Dual carriageway, Bangalore Highway number 75. The Ministry of Road Transport Corporation, Ministry, has formed guidelines regarding issuance of permission to petrol bunks. It's at page 44 annexure D. Page 44 annexure D. This was on Lordship got.
Yes.
Lordship got that. That's on 26th June 2020. In that guidelines, Lordship may kindly go to page 56. What should be the distance between location norms? Page 56. Page 56. Lordship may come down to norm 2.2. In norm 2.2, serial number 6. Distance between two fuel stations. Undivided carriageway is 300 meters. Divided carriageway is 1000 meters. That is 1 kilometer. That's one aspect. Page 56.
Yes.
Page 56.
Yes.
Norm 2.2, serial number 6. Undivided carriageway is 300 meters. Divided carriageway is 1000 meters. Now the violation of the guidelines which I am enforcing these guidelines. That is the reason your lordships have viewed that presence of Union of India is necessary. Therefore, I filed implementing application. I am enforcing this. This is within 550 kilometers. Then before that, please, my lords, very this thing, safety of the public. Serial number 2. Distance of any intersection with any category of road and median gap should be 300 meters.
On this ground, their earlier application was rejected. I have produced that also. On this ground only, their earlier application is rejected. Lordship, may kindly go to page 99. Page 99. Their earlier proposal during the year 2023. Page 99, D, paragraph D. The marked circular so and so, dated so and so, page 23, serial number 3. Retail outlet in rural stretches has stated that the distance from the intersection of any category of road made an opening should be minimum 300 meters, whereas we have observed that Tavrekere village road exists at kilometer so and so, our calculation about, which is 65 meters away from the proposed retail outlet. Photographs from the site are enclosed for reference. Hence, it is herewith requesting you to resubmit the proposal along with revised drawings and checklist during the meeting of the meeting. On this ground that it is within the restricted area, there is an intersection within a distance of 65 meters. Their earlier proposal is rejected. Then also the road was there. Now also the road was there. Road is there. I don't know how National Highway authorities will come over this situation. How they will come over this situation. Intersection of the road. Now, please, my lords, I have given this thing. It's good. Lordship, may kindly see the drawing. Intersection of Tavrekere road I have indicated.
Yes.
To the west of my existing petrol bunk, their proposed petrol bunk I have drawn in red ink, please, my lords. Mine I have shown in green ink. To the east. Intersection is 65 meters, admitted fact by the National Highway Authority. That is the main reason for rejection of their earlier application. On this ground, it is rejected. Where is the question of resubmitting it? Lords, the guidelines, the object of the guidelines, please, my lords.
Their petrol bunk opens into Tavrekere road.
No. Highway only. To the highway only. To the highway only. What they have done is, near their petrol bunk, it is already asphalted now. Near their petrol bunk, they prevailed over the local authority and they prevented it from putting this thing, tar on the road.
Is there a service road?
No, there is no service road. There is no service road. I have the photographs. There is no service road. If there is service road, there would be an exemption, please, my lord, for them. 1 kilometer distance, there is an exemption. There is no service road. I will produce the photograph. Recently taken photographs. No, please, my lords. No, please, my lords. The point is, other side is mainly relaying that you are only an agent. You are only an agent. In view of the ruling of the division bench of this honorable court, an agent cannot challenge the permission granted to a rival trader. Lordship, may kindly, I have searched this in Google. I am not an agent of Naira, this thing. I am a franchisee. Lordship, may kindly see the difference between agency and franchisee. Agency, agent.
Locus standi will go later. Let us. We'll go to locus standi.
Maintainability, they are come. Yes.
That will
I'll
go.
come to that. Lordship have posed me a question. How you are agreed by this?
So that will come to that.
Yes.
How you are saying that it's within 1,000 meters.
Within 1,000 meters. There should be some special reason for giving permission to the petrol bunk within 1,000 meters. No, that special reason is forthcoming in the order. That apart, the main thing is intersection of Tavrekere road. It will create lot of traffic junction, traffic jams, vehicular accidents. That is the reason 300 meters different distance should be there from the intersection of the road and any existing petrol bunk.
Yes. Who appears to?
Now, one more.
Really? I thought I'll ask them.
No, what, 2 minutes, 2 minutes, only 2 minutes I will take. Other side is much arguing on the locus standi. The recent decisions of Supreme Court, which I have relied, a paper book, stitch ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ. I have stitched it and given it. Page 73. This relates to shifting of a video parallel, please, Millets. It's of 2005-3 SCC. Lordship may kindly go to D, head note admil, after the head note. Page 73, head note. The appellant was running a cinema hall. He filed a writ petition before High Court challenging the order passed by the commissioner, wherein the commissioner has set aside the order passed by the district magistrate, cancelling the license given to respondent number 3 to run a video parlor. The main grievance of the appellant before the High Court was that the video parlor of the respondent number 3 was situated within 350 meters from his cinema hall, and hence no license could be granted to respondent number 3 to run a video parlor under UP so-and-so regulations. It was also submitted that the grant of license in favor of respondent 3 was in violation of the provisions contained in so-and-so, so-and-so. Lordship may kindly come to the operative portion order. The appellant herein, who was the writ petition before the High Court, filed the writ petition in the High Court of Judicature of Allahabad. The commissioner had set aside the order passed by the district judge, cancelling the license given to the Prakash Palace video parlor respondent number 3 to run a video parlor. The main grievance of the appellant before the court was that Prakash Parlor video parlor respondent number 3 was situated within 350 meters from Sri Chalchitra, and hence no license could be granted to respondent number 3 to run a video parlor under UP so and so. Then Lordship may kindly go to para 4, page 74. Learned single judge before whom the writ petition came up for hearing dismissed the writ petition on the locus standi of the appellant to file the writ petition without going to the other question of law. It was observed that the appellant could not raise a grievance against his rival in the trade, particularly when the rival in trade, as in the instant case, was exhibiting cinematograph films much before the appellant was granted the license. It was held that the appellant has not been denied or deprived of his legal right to exhibit films, and therefore he had not sustained any legally protected interest. It was also observed that the order of the commissioner did not operate as a decision against the appellate so and so and so. Then this is the finding, para 5. After hearing the learned counsel for the parties, we are of the opinion that the High Court clearly erred in dismissing the writ petition filed by the appellant on the ground of locus standi. The appellant, being in the same trade as respondent number 3, has a right to seek cancellation of the license granted to respondent number 3 being in violation of the acts and rules. The same situation is here. They have been granted. Their earlier proposal was rejected. Thereafter, I don't know what transpired between National Highway Authorities and Indian Oil Corporation. Thereafter, after 2 years, they grant it. The road is still there. Then another ruling, please, my lords. My learned friend referred to two rulings. That is, Nagar Rice and Flour Mills and Justibai Modi, Desai. Supreme Court has taken a different view, please, my lords, afterwards. Page 69. Page 69. That's it, got page 16. Para 12. Para 12. In this context, we notice that the court has changed from the earlier strict interpretation regarding the locus standi as adopted in Nagar Rice and Flour Mills versus N.T. Kappagowda and brothers, and Jasbai Motibai Desai versus Roshan Kumar, and as much wider canvas has been adopted in later years regarding the person's entitlement to move the High Court involving the writ jurisdiction. Then para 14. This is a case where, please, my lords, a liquor license was granted to a particular person, and to another person some other area was allotted. You sell liquor in that area. That person was not satisfied with that site. He wanted an order from the commissioner to shift his liquor trade business within my area, which was allotted to me. In that context, para 15, para 14, page 70. Page 14, page 70, para 14. In the light of the expanded concept of legal locus standi, and also in view of the finding of the division bench of the High Court that the order of the excise commissioner was passed in violation of law, we do not wish to nip the motion out solely on the ground of locus standi. If excise commissioner has no authority to permit liquor shop owner to move out of range for which auction was held and have his business in another range, it would be improper to allow such an order to remain alive and operative on the sole ground that the person who filed the writ petition has strictly no locus standi. So we proceed to consider the contentions and merits. So basically this is the argument of the other side that I have no locus standi is one aspect. Second aspect, please, my lords. Lordship may pose me a question. How you are aggrieved by this? How you are aggrieved by this? My submission to your lordship is the guidelines itself, in the form of guidelines, there is a promise to me that if you establish a petrol bunk, no other permission will be granted to other petrol bunks within a range of 1 kilometer to your left side, to your right side. It amounts to a promissory estoppel, which I am entitled to enforce. In that regard also I have produced ruling. And I have filed an amendment application, please, my lords, demonstrating how I am aggrieved by this. Amendment application is ordered to be heard along with the main petition. In the amendment application, I have clearly said.
Let us see. Yes.
As far as respond number 1 is concerned.
You appear for?
Respond number 1.
The corporation.
That National Highway Authority of India. That annexure A issued by respond number 1 to respondent number 3, Indian Oil Corporation. Annexure A. As far as my learned friend's argument is concerned, page number 56, Lordship may kindly see again. Page number 56. My learned friend read 2 lines. I may permit it to read further lines.
Yes.
Page number 56, serial number 6. Undivided carriageway 300 meter, divided carriageway 1000 meter. Next line. However, this restriction shall not apply in case access egress for such all fuel stations are provided through common service road of 7 meter width and not directly to NHA. Now, there is no direct access to NH. They have to approach through service road to reach that fuel station.
I mean, so far as the service station of his, there is a service road.
Yes.
Now, what about the
next
respondents?
Lordship may kindly see.
No, what about the respondent? There is no service road.
Service road is there. If there is no service road.
Lordship may kindly see that this is the photograph which recently taken.
My submission is that in case, if there is no service road also, that is his responsibility to make a service road to access to NH. Now, Lordship may kindly see page number 23, Annexure A under challenge.
Page?
Annexure A. Page number 23 onwards. My submission would be, my lord, that is not the final license to operate a petrol bunk. That is only a permission to conditional provision permission to access NH. Our authority will give only access to petrol bunk to NH. Only that is my permission. Lordship may kindly conditions. Page 1. Page 23 starting point. Page number 24, last paragraph. The proposal has been examined and based on your recommendation, the in principle approval of competent authority is hereby conveyed subject to the following conditions. Oil company shall construct 7 meter wide service road from chain H 103 to 102 plus 817 for a length of 613 meters. Page number 25, my lordship got it. And further 5.5 meter deceleration and acceleration lane for and length of 70 meter and 100 meters respectively. The access to the retail outlets is with service road only and not with the main carriageway. The issue of final formal permission, including issuance of signed second sense deed, would be subject to the certificate by the project director NHA PAU Hassan that the construction has been carried out in compliance with the provisions of approved by the highway administration. Hence, it is directed to submit the proposal for completion certificate after construction of access road as per approved proposed layout plan. It is like, my lord, for forming a layout, we have to apply for commencement certificate. After completion, we have to apply for occupancy certificate. This is the annexure A, that is the permission, initial permission. After completion of everything, including establishing petrol bunk, he has to apply again. Thereafter, one more inspection will be there with the respond number 1 and 2. If there is a violation, they will not issue permission to access to NH. At present, they have, based on this license, initial license, they have invested certain amount for getting the approval, and they have started construction. They have constructed also. Only thing is, because of this interim order, they cannot apply for final approval, final license. If they apply it, again inspection will be there. After that only we'll give consent or not, subject to the guidelines. As far as guideline is concerned, he says that 300 meter and 1000 meter. Moreover, this particular petrol bunk not from the adjacent side, it is from the opposite side. As far as judgment of coordinate bench of this honorable court, that guideline also not applicable. Moreover, guideline is not mandatory. Moreover, based on the public demand, even internal company also establishing petrol bunks. That also government undertaking. That is my submission as far as annexure A is concerned.
Layout plan is saying, there is no service road. Plus, there is layout plan issued by the IOC.
I have given the photographs. I have given the photographs. The lordship may kindly see the present situation.
So they are saying it's still at the initial stage.
No. The
At
thing
page
is,
23, annexure A, condition is they have to form a service road.
Only access to NH.
Lord, that's there is an exemption for that. How do
No.
they overcome this 65 meters intersection road?
That they'll have to
That is
answer.
there.
That they'll have to answer.
They have to answer that.
So that they'll have to answer.
Having rejected it earlier. And this is the present situation of this thing.
No, that we'll see. It's only a formal, he has to comply. What do you say about the intersection?
65.
That is, my lords, between the intersection, it's not a, my lords, national highway or state highway, my lords. It's only a, my lords, road. It's a mud road, my lords. It's not comes under the state or
Village.
national. It's a village road, my lords. I have submitting the endorsement. After seeing all these, my lords, the IOC has issued a certificate, my lords. Simply, my lords, misrepresenting, saying that not intersection roads are within 65 meters, but it's a mud road, my lords. And that road also left by the respond number 5. It's each land, my lords. There are, my lords, survey number also mentioned.
Let there.
Respond number 5 land, my lords, that is belongs to the respond number 5 land. He left, my lords, to reach the village. That's the mud road, my lords. Can you see the endorsement issued by the?
Not a public road.
It's not a public road, and it's a mud road, my lords. It's not come to the village road, my lords, left by the respond number 5.
Let there not be false submissions.
It's not a state highway.
It is a lordship may kindly go to page 107 of writ petition. I have produced the photographs of the road. Photograph of the road, annexure K. And this Pattan Panchayati Bellur has formed this road. Page 107 annexure K, please, my lords. ಆ ಹೈವೇಗೆ ಸೇರೋ ಹತ್ರಕ್ಕೆ ತಾರ್ ಹಾಕ್ಬಾರ್ದು ಅಂತ ನಿಲ್ಲಿಸ್ಬಿಟ್ರೋದು ಇವರು. Annexure K, this is the photograph. That is the highway. Next page, your answer may kindly go to see. Annexure L, page 108, Thar Road. ಆ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಹತ್ರ ಹೈವೇಗೆ ಜಾಯಿನ್ ಆಗುವಾಗ ತಾರ್ ರೋಡ್ ಹಾಕ್ಬೇಡಿ ಅಂತೇಳಿ ನಿಲ್ಸಿರೋದು ಒಂದು 40 ಅಡಿ. And the guideline says any category of road, it may be mud road or any category of road. And this is asphalted. And he contends that this is a private road. I have produced annexure J stating that who has formed the road. Town Panchayat Bellur has formed this road. Annexure J, endorsement.
IRC guidelines, my lord. I appear for IUCN. IRC
Indian
guidelines itself is held by this court and apex court. These are not statutes. These are only recommendations or guidelines, whether it could be done. But it is in the best interest of just to control the vehicular movement. That is all what it is there. It is not to be followed.
So
Or
anyhow, this is only a form, still final approval is not considered.
My lords, he is
Final
proceeding.
approval is not yet.
No, the thing is, he is proceeding with the construction of the petrol bunk.
No, correct.
Yes.
Final approval.
Then if he constructs, he will plead.
He cannot construct without final approval.
My lords, it is their internal, it is their internal. How can they permit for establishment of the petrol bunk now? How can they permit it now in violation of the guidelines?
He is still to take final approval.
No, my lords, he will establish the petrol bunk and
Final
thereafter
approval.
he approaches for petrol, this thing.
No, he cannot establish it without final approval.
He is establishing now.
That will put him on terms.
He should not now.
That will put him on terms.
Other things, Lordship may kindly see, the object of this thing, guideline is enabling smooth flow of traffic, minimum interference from vehicles entering the right of way of national highway, safety road users. And why they have already rejected his proposal 2 years ago on this ground, 65 meters.
The final proposal may still be rejected. We don't know.
could be.
Could be.
Final proposal may still be rejected.
No. Earlier proposal itself is rejected.
Annexure A may require.
It is not so plain as my learned friend is putting it across.
No.
It is final permission to establish the petrol bunk.
No way.
Page
Conditional
25.
provisional permission for access only.
Just page 25, Roman 2.
Yes.
25. Yeah.
Then pass that, then we'll see.
The issue of final permission, including issuance of sign so and so, subject to certificate director. My lords, I am pointing it out that this very initial permission itself is illegal.
That will
I am
see.
aggrieved by that. Therefore, stay this.
If formal is rejected, there ends the matter.
My lords, by that time he will construct the petrol bunk and
That's
plead
his risk.
equities.
That's his
He will
risk.
plead equities.
That I'll put him on terms. That will put him on terms.
That's when apparently
Commencement of business would be subject to the approvals
when
of the.
my lords, when apparently on the face of the record that this permission is granted in violation of their own guidelines, and this is not the guideline for internal administration of National Highway Authority. Union of India has passed this. Ministry of Road Transport Corporation has passed this. My respectful submission is presence of union government is required, please, my lord. That is why I have filed an impleading application.
That we'll see now. We'll not pass any final order. We'll only say that it's subject to the formal order. I keep open all contentions. If formally it's approved, then you can come back. He will not plead.
If stay
He
is
will not
vacated,
plead.
if stay is
No, I'm
vacated,
disposing it off, saying that he cannot commence without a approval in terms of Roman 2 of page 25.
my lords,
And at that point, if there is anything, you can come back.
what happens is, it is an investment of crores.
That's his risk.
2.5 crores is the basic investment.
His risk.
Thereafter, he should not come and plead equities before this honorable court.
That condition I'll impose.
And in the light of the fact that in the earlier writ petition itself, the processing itself is stayed. The processing itself is stayed in the earlier writ petition. How they have processed it, and grant
Let us see.
permission.
The petitioner has sought for issuance of writ of certiorari to quash the approval granted by the first respondent in favor of the third respondent for establishment of a retail fuel outlet by the side of National Highway number 75, Bangalore-Mangalore at kilometer 103.385 to 103.430 in survey number 41/7, Tavarekere village, Bellur Hobli, Nagamangala Taluk. Full stop. Petitioner has also sought for quashing of the no objection certificate at annexure B given by the fourth respondent. It is the case of the petitioner that the petitioner is a
Franchise.
franchisee.
No, but he is filed under the individual matters. Petitioner filed in the individual capacity filed matters. On that ground also,
Just one minute. Petitioner is a franchisee of fuel outlet. On the which road that is? National
Highway number 75.
75. And that the proposed fuel outlet of respondent number 5. You are 5.
yes, I am
He
fine.
is 5.
I'm in favor.
He's through Indian Oil Company.
Indian Oil Corporation is R3, please.
Respondent number 5 is in violation of Appendix 1 to the notification of Ministry of Road Transport and Highways relating to guidelines/norms for grant of permission for construction of access to fuel stations. It is submitted that on an earlier occasion, the
On 29/9/23, Annexure A, page 19.
on an earlier occasion,
19.
the National Highway Authority of India on 29/9/2023.
No, I'm sorry, please. There is some, this thing. I will point out. 27/3. 27/3/2023, Annexure E, page 98.
On an earlier occasion, page
98. Page 98. The reason is page 99.
On an earlier occasion,
Para D.
the National Highway Authority of India had rejected the proposal for opening of an outlet of the fourth respondent on the ground that distance from the intersection of 300 meters was not maintained in the present case. It is submitted that despite which present annexure A has been passed with no change in circumstances. It is pointed out that in terms of norm number 2.2, the twin conditions required in the facts of the present case is 300-meter distance from any intersection.
Yes.
1. 2. That the distance between two fuel stations on a divided carriageway is 1000 meters and undivided carriageway is 300 meters. Full stop. It is submitted that in the present case, it's divided carriageway or undivided?
Divided.
In the present case, the carriageway being a divided carriageway, 1000-meter distance between the petitioner and the fourth respondent proposed outlet is not satisfied, as also the distance from any intersection of 300 meters is also not satisfied. Accordingly, the present petition has been challenged. Various contentions have been raised, including regarding locus standi of the petitioner to file the present petition. It would not be appropriate at this stage to enter into the merits of the contentions, taking note that annexure A is only in the nature of a provisional permission.
Yes.
Full stop.
Conditional provision permission to access to NH. Permission for access to NH.
Provisional
Permission for access to NHA. NH Road, National Highway 75.
Provisional permission is in the nature of access of national highway, access to the national highway.
Yes.
Full stop. Point number 2 of annexure A makes it clear that the recommendation by the national highway is only an in principle approval of the competent authority, subject to conditions mentioned in the said communication. Full stop. Point number 2 of the condition would mandate that final formal permission is required to be obtained, which is subject to certificate by project director NHAI PIU Hassan, to the effect that the construction has been carried out in compliance with provisions approved by highway administration. Full stop. Further, it is clear that a proposal for completion certificate after construction of access road as per approved proposed layout plan is to be made. Full stop. Point number 1 at para 2 would indicate that the fourth respondent is directed to carve out access to the retail outlet only from the service road and not from the main carriageway. Full stop. Next. It is to be noticed, that the fourth respondent,
Five minutes. Fifth
respondent, that the fifth respondent is still to complete his project before completion certificate may be granted in terms of annexure A. While it would be premature at this stage to intervene in the matter, insofar as annexure A being only issued at a very preliminary stage of the project. All contentions raised by the petitioner are still to be tested by the authorities after the fifth respondent obtains approval by the highway authorities in terms of the conditions at annexure A after forming the service road as indicated in the said letter of approval, letter of provisional approval. Needless to state that the fifth respondent cannot claim equities in the event the final approval is not given by the highway authority as contemplated in the document at annexure A. In the process of granting approvals, the highway authorities as well as the company, respondent number three, is to bear in mind existing regulations, nature of their effectiveness and binding nature, and take a stand specifically after taking note of the contentions raised by the petitioner in the present petition. It is made clear that the fifth respondent cannot claim equities in the event of any adverse order being passed by the authorities. Both the objections raised by the petitioner as noticed in para so and so are matters to be taken note of by the authorities while granting completion certificate as well as by the National Highways Authority. Accordingly, petition is
One
disposed
submission.
of.
One submission. Lordship may kindly indicate the earlier rejection on the ground of 65 minutes. Let them take that note also. 60, annexure F, annexure E.
That we'll see. Let them now see. If it is in order, then there ends the matter. If it is not, it's open. We'll see.
Great.
Yes.
36. Mahendra,
Respond in this case, my
Ajay
lord.
Kumar,
Yes.
The last date of hearing, my lord, they were not appeared. It was noted in the order sheet, the pertaining to the Surface Act. Let them go to DRT, my lord.
Now, what have they challenged?
They have challenged the possession notice, the sale notice, my lord.
The
Sale notice.
What has happened after that sale notice?
It become infructuous.
Respondent, petitioner has challenged
Yes, my lord.
the validity of the sale notice dated 30th July 2024. Learned counsel for the respondent bank has filed a memo and submits that pursuant to the sale notice, the sale did not progress to an advanced stage and sale could not be held due to absence of bidders.
No, my lord, because of this time, my lord.
Because of the interim order passed in the present
Yes,
matter. Next, it is further submitted by learned counsel for the respondent that the substantive remedy available is before the DRT in terms of section 17 of the Surface Act. Next, no representation on behalf of the petitioner despite the order passed on 30th July 2025. Full stop. Taking note of the existence of a substantive remedy, it would be appropriate to relegate the petitioner to avail of substantive remedy. Repeat para 1, 2, 3, 4 beda, 5 beda, 6. 1, 2, 3 and 6. The counsel for the respondent submits that they would take further steps in accordance with law. And in the event petitioner is so aggrieved, he may approach the debt recovery tribunal under provisions of Surface and not approach this court in exercise of writ jurisdiction. Adana mail barbidi, the last mail. Accordingly, petition is disposed of.
Within the period, my lord, within 3 weeks. In 3 weeks, they have to approach, my lord.
No, now
Yes, ma'am.
your sales certificate
Yes, sir, infructuous.
goes.
Yes.
So when you
Yes,
do your,
fresh.
when you initiate fresh,
Yes, my lord.
we have said you have to go to the.
Yes.
37.
In this matter, my lord, for the respondent,
So the petitioner in this
they have
case,
challenged the possession notice and the order passed by the CGM under section 14.
Yes.
in this case, my lord,
Now you have to go before the DRT. Will protect you for the time being. You can go there and.
loan amount is only 5 lakh, 5 lakh 6,000 loan amount.
Ah.
Already we have paid more than 5 lakh rupees.
What can we do now?
Moreover,
The
loan
interest of-
tenure is still 29
Huh?
January. Loan tenure is still 29 January. We'll make arrangement within 6 months to make payment of all the due amount.
No, but have you been paying your EMIs?
Yes, my lord.
For closure of the loan, my lord, they have to pay 6 lakh 8,000.
Huh.
For upgradation of the loan, they have to pay 3 lakh 61,000 rupees.
He says he's ready.
Like if they want to pay, let them pay, my lord. I have no objection for that.
Within 6 months, if time, 6 months time granted, we'll make arrangement
6
to
months,
settle the
well.
entire matter. Full amount, full settlement.
It is very difficult, my lord. Another 6 months, sir.
Because
But
property
the
is
3
more than,
lakhs, just 1 minute. The 3 lakhs
Yes,
for upgradation.
within
Let
1
him-
month.
No, just 1 minute. How much time you will pay that 3 lakhs
3 lakh 61,000.
3
for
months,
upgradation?
this 3 months time may be granted. Because his mother is ailing from some,
No, but you find out first Now you are saying, but your client must also agree to that.
Yes.
I'll have it tomorrow.
Next week. Next week.
I'll have it on Monday.
Next week.
Monday. You find out if the 3 lakh for upgradation you are ready to pay within 2 months. And then we'll see what can be. Relist on Monday in same stage. You convince your client. At least upgrade, then the remaining you can take your time. Yes.
38, Sagar B.
Lord, if Lordship permits, I just have one preliminary submission, Lord. The writ petition, just for faster disposal, subject to what my learned friend agrees, my Lord. Writ petition number 16251, my Lord. Petitioners have challenged the preliminary notification issued under section 4, my Lord. Now, in the meanwhile, my Lord, there is a forest settlement officer who has been appointed, and he has issued notice. Petitioner has approached and filed his claims before the forest settlement officer, my Lord. Now, his claims have to be adjudicated by the forest settlement officer, my Lord. Now, therefore, my Lord, the subject to the claims which are to be adjudicated by the forest settlement officer, my Lord, we will not precipitate or take possession insofar as 5 acres of land which has been, they say, granted in 1924 and he has purchased it in 2016, my Lord. Anyway, petitioner has submitted himself, has responded to the forest settlement officer's notice, and he has put forth his claim, my Lord. That can be clarified. If that be the case, then question of adjudicating this writ petition, my Lord, can be, his rights will have to be now adjudicated by the forest settlement officer, my Lord. Till his claims are adjudicated, our order passed under 64A, we will not execute. That's my first submission, subject to what petitioner's counsel. That's only in this writ petition.
On that note, I'll seek instructions, but the issue, my Lord, is.
So let us see. Please. Then what is the next one then?
The next one is, my Lord, where the application for regularization has been rejected, my Lord. He is in possession of nearly 9 acres, apart from 5 acres, which he has purchased. 9 acres, his application for unauthorized occupation is rejected, and there is a 64A proceedings order passed against him, my Lord. That can be decided because he cannot approach the FSO with the claims.
That is WP 29656.
19980, my Lord.
19980. Now his application for regularization is rejected.
Rejected, my Lord. And he is in unauthorized occupation to the extent of 9 acres. For that, we have passed 64A order, my Lord. And he has challenged that order directly here without taking recourse to the appellate remedy, my Lord.
What is the appellate remedy?
64 A3, my Lord. He has to appeal to the CCF.
Forest Act.
Yes.
64?
Yes. 64A 3, my Lord, provides for an appeal against the order. (64A), my Lord. 3 says, any person aggrieved by an order of the forest officer under subsection 1 may, within such period and in such manner as may be prescribed, appeal against such order to the state government or to such officer as may be authorized by state government in this behalf, and the order of the forest officer shall, subject to the decision in such appeal, be final. So there is an appellate remedy available, my Lord.
That application for regularization rejected has attained finality.
He has subject to, Lord, they
Filed an appeal is pending, Lord.
Appeal against the
rejection, Lord. It's rejected basically on the ground, Lord, that this is there is an order of eviction, etc. There's an appeal that is filed, it is pending.
Appeal pending before?
That's what it is pending before the assistant commissioner, Lord. I think I've filed a memo.
Different from this regularization.
Correct.
It is pending, Lord, before the assistant commissioner.
I'm told that's dismissed.
No, it is pending is
5, that's dismissed this. So therefore, my Lord, in the first writ petition where they claim to have purchased under 2016 sale deed, my lord. Now, if lordship quickly takes the Forest Act, my lord, section
But it
4
is
is
my
the.
petition. I would request,
No, no,
Lord, that
just
I
to
be
sub-
heard first because,
No, let us see. I'll come to you.
Lord, may I make one submission, Lord? I've been able to, Lord, lay my hands on, Lord, there is a report that is prepared by the Assistant Commissioner, Lord, which is a voluminous book, Lord, which I've been able to lay my hands on. This is the report that is prepared by the Assistant Commissioner and submitted to, Lord, the Deputy Commissioner, Lord, Hassan District. Lord, I would request, Lord, let not the government place this on record, because what has happened is, Lord, the government is not acting upon a notification of the year 1920 in the year 2020 or 2023 rather. Lord, 1920 notification is issued, Lord, under the provisions of the Mysore Forest Regulation 1900. And Lord, that regulation, Lord, there is no question of not invoking the powers under Section 4 of that Act and continue the proceedings now after 100 years. But therefore, my lord, what happened was not the entire, my lord, there was a report.
No, correct. In so far as your regularization, just find out if it's.
But I'll verify, my lord.
Because if it's attained finality, then how you can continue?
Not I'll verify because not now my learned friend has given me a copy. This is dated 5/6/2025. But I'll verify from my client if it is not any orders passed. But the fact will remain, my lord, if it is a forest land, then, my lord, yes, they can invoke the powers not under 64.
When you're seeking for regularization, it's not as a matter of right.
True,
Land
Lord.
grant, even
No,
under
no,
the,
I bowed on.
even under the Land Revenue Act,
Please.
we can't say it's a matter of right. There
But
is
yes,
one-
Lord.
So insofar as that you may have to yield to the state. Remaining we can consider.
But I'll verify, my lord, as to what has happened.
You find out.
Please.
We'll have it on Monday. We'll have it on Monday.
Yes.
Relist the matter on Monday.
There's only urgencies with that 9 acres, my lord.
Correct. That only.
I
We'll
understand
take
so
up
far
that.
as other petition is concerned, my lord, they have challenged the preliminary notification.
That
Lord,
let
all
him-
may have to be heard together, my lord.
No, let us see. Regularization will take it up first. Remaining you see.
Yes.
Lord, it will have a Lord bearing. The reason is this, Lord.
Government
If-
land, even if you are make out a perfect case for regularization, there's an element of discretion. They need not grant to you.
No, Lord, I bowed on, Lord. I'm not saying no, Lord.
So
But
even
if
if
I
it's
am
revenue-
targeted, Lord,
No
there are not
targeted.
hundreds of people.
Not targeted. That will issue direction. That will issue direction. Relist on Monday.
Lord, can it be on 16th, Lord, instead of 14th, Lord?
16.
Grateful. Lord, the interim order may be extended, Lord.
Modern application.
Please.
My lord, I'm told there's a heavy board on 16th.
Every
There
day
are
will
other-
be, but you take a chance. If you are free, you take it with.
Yeah, I'm free.
Let us.
Please.
Yes.
39,
Grateful.
Satish A.
Lord, I'm for the respondent number 11 in this matter.
Petitioner by me, my lord.
With respect to State Bank of India, I am filing a memo regarding the amount, my lord.
Sir. Sir.
This is a case of lien, is it?
Lien, my lord. Defreezing it. They are asking for the.
In this matter, my lord, initially we have deposited, we invested the amount, 3,75,000. Then after 15 days, my lord, in our account, we found that 4,43,500 rupees. Out of that only, my lord, after 5 days, my account was freezed. Immediately, I approached the bank. Then I come to know that as per the directions of the respondent police, my account was freezed due to the multiple transaction without knowing to my knowledge. Then, my lord, we have filed the complaint before the concerned police in respect of fraud taken place with me as well as in my account that fraudulent amount was deposited.
No, just 1 minute. Now, R11.
My lord, I'm for the.
R11. So
HDFC Bank.
according to you, the instruction to freeze is 6,84,896, isn't it?
Yes, my lord.
That is that is the sum total of all instructions to freeze.
Yes, my lord.
Okay, then you appear for
For R12, my lord, State
R-
Bank of India.
R12. So insofar as R12,
Total, three amounts were asked to be freezed, my lord. The total of 6,08,000. So subsequently, my lord, there was a request placed by respondent number 3 for releasing. So with respect to 4,50,000, it was released, my lord. Presently, 1,58,000 has been freezed, my lord.
who's R3?
R3 is central.
Huh?
The state by North Central Crime Police Station.
So now,
Yeshwantpura.
so there's a lien of 1,58,000.
58,000, my lord.
How much more is remaining in his account?
My lord,
That has been lifted already.
the pending is 1,58,000, my lord.
Except that the rest could
The rest
be,
has been released, my lord.
has been released or can be released.
My lord, subject to the outcome of the trial court, maybe.
No, correct. So now,
My lord,
now
my
R11,
R11 is concerned, my lord. the
correct,
total
R11 and R12 have filed their memo. We'll defreeze the amount beyond this.
Yes, my lord. 2,27,778 is available for them to transact.
So we'll defreeze it to that extent.
Yes, my lord.
Remaining, you see, what is? We cannot enter into that. Separately. So then you file a rejoint, correct? Then you make another request to them. They will consider it.
My lord, we cannot, the direction of the state,
Pass
my lord,
the police, correct?
Yes, my lord.
That depends on the police investigation being concluded.
Yes, my lord.
A submission is that, my lord. My lord, the accounts have been freezed in under a crime, my lord. That is being investigated, my lord. My submission is that, my lord, under the BNSS, my lord, the procedure is that, my lord, it is considered as the movable property, my lord, that has been seized by the police. My lord, they have to go before the trial court, my lord. Under section 497 of the BNSS, my lord, they have to seek for the interim custody of that particular movable property, my lord. The trial court will be having all the information about the crime also, my lord, and the seized materials also, my lord. The trial court will consider their request, my lord, and an order will be passed upon that, my lord. That is the proper procedure, my lord.
But then these all are old attachments even before BNSS.
Even under CRPC, my lord, the provision was there.
451.
451 and 457, my lord. Whenever any movable property is seized by the police, my lord, under a crime, my lord, the proper procedure is that to, my lord, go before the magistrate for the interim custody of that, my lord. Hence, my lord, the writ petition is not maintainable for this relief, my lord.
But then no writ petition can be filed for debit freeze then. Now
That is the procedure
So-
there.
so
if
let
it is freezed under a crime, my lord, then it will become the movable property seized
correct.
under a crime.
Insofar as what has been frozen,
Yes.
that they cannot take it.
Yes, my lord, until
Unless
the
they go.
investigation is complete.
Correct.
And
Beyond that,
my lord,
we'll only pass order beyond that.
Yes,
We are not going to touch that amount. So we can dispose it off with
Yes,
respect to your other grievance in terms of 497
Yes,
of
my lord. Yes,
BNSS.
Yes.
We leave it open for you to go before the
Trial.
trial court and seek for relief. Now only two of them.
Yes, my
Huh?
R11 and R12.
The petitioner has called in question. Huh? Yes, that I leave it up. BNSS code. The petitioner has sought for issuance of a writ in the nature of a direction to respondent 1 to 9 to defreeze the account bearing so and so maintained with 11th respondent
11 and 12.
and account number so and so maintained with 12th respondent. The prayer really the account numbers. Full stop. Upon notice, the memos are filed by on behalf of R11, which reads as hereunder. Full stop. Next. The memo filed by on behalf of respondent number 12 is to the effect that lien continues with respect to an amount of 1,58,000.
Obliged, my lord.
Full stop. Taking note of both the stands of respondent 11 and 12, it would be appropriate to dispose of the writ petition as follows. Insofar as account number dash maintained with 11th respondent, there would be a direction to defreeze the account above the amount of 6,84,896.
Correct.
Full stop. Next, insofar as the order freezing the balance with respect to account number so and so maintained with 12th respondent bank, the lien would continue with respect to 1,58,000 only, and the petitioner is at liberty to utilize funds above the same. Accordingly, the petition is disposed of, while keeping open contention of the petitioner insofar as amount with respect to which lien continues to be raised in terms of section 497
Yes, ma'am.
of BNSS before the court, before the trial court. Before the trial court. Accordingly, petition is disposed of. Yes. Respondent number? No, now we have lifted it.
Yes, ma'am.
I lifted the, except for that amount beyond your.
It's like 84,000, whatever is there, my lord, over and above.
Above that you can utilize. No,
That relief cannot be granted you.
that is only insofar as the amount. The rest is the matter for before the court. No, I can't make such a. I have nothing to do with the prosecution. You get a discharge in the criminal court, there ends the matter. I can't do it in reduced. Let us see. That you take appropriate steps. Yes, next.
Obliged, my lord.
Serial number.
All other contentions regarding validity of
Yes.
pending criminal proceedings is left open to be raised by the petitioner before appropriate forum. Yes.
Vinod Kumar M. Chandrasekhar. Connected matters.
Please. 40 point.
Respond number 5, my lord.
40.3.
Now what has happened?
We are for the impleading applicants, my lord, there is an interim order regarding the tender conditions, my lord. We are aggrieved by that, my lords. Because of that, the process won't proceed ahead, and the tender conditions left to the authority to decide what the tender condition, unless it is totally unreasonable, my lords, and impermissible in law. The court cannot decide these policy conditions, how the tender conditions should be there, unless it is made held to be malicious or some ulterior motive is attributed, in which case the pleading should be there, and who is the authority who has that ulterior motive, etc. should be mentioned. Simply stating that such a condition is not suitable for us, my lords.
No, correct. Now you make a synopsis
Both the sides also.
of all the you have filed.
No, not fine.
File a synopsis.
Please.
Each matter, who are these people, petitioners, and then on the legal grounds of his attack, you give, let him also give. Next date we will hear and dispose.
Yes.
So, my lords, in a short point, my lord, wish to canvass. There is also an appeal, generally also in the statute, and also page 41 also provides clause number 31. They can appeal to the commissioner within 5 days. Page 41. Tender notification itself provides, my lord. Internal mechanism is provided. That ink page.
Now since 22. So now let us dispose it off. What is their attack? On what ground you are saying that attack cannot be considered in jurisdiction, as well as whatever legal contention you have.
Yes.
And then you make it, we'll hear and dispose it.
Right, it is appeal provision is
No,
there.
in the meanwhile, of course, we are grateful now that your lordship is taking, otherwise the fear is this, my lords. By lapse of time, my lord, they would enjoy.
No, correct. I'll have it next week. Please get ready one by one so that there's no confusion.
Please.
Whatever all the writs
I'm
are.
appearing if the applicant, applicant 40.3, my lords.
40.5.
40.3.
Now each one,
Please.
government is the answering respondent.
Yes.
So you assist them in making whatever list of dates.
Yes.
Then let the government address on each of the matter. Common contentions, let there be a common note on the attack of the petitioner. And then you prepare your synopsis on what ground you are challenging it. And you appear in how many matters? One matter.
40 point.
Huh?
matter, my lord, is 40, my lord.
So on behalf of the petitioners, you make one common synopsis of all the matters. We'll have it next week.
Yes.
The
In some of the
petitioners
matters,
and
madam,
respondents
one submission, your
to file common synopsis listing the list, having a list of dates, grounds of attack as regards particular clauses in the tender and legal basis for such challenge. So we'll have it next week and we'll dispose it.
Please, my lord.
All the tenders relate to the same tender condition. Huh?
some more matter, my lord, is to be
My
listed.
lord, in fact,
Related matter, my lord, some more
different
matter.
tenders, the honorable court, my lords, thought that the question itself is same, therefore let all the matters. But one problem may submit, my lords,
It's
it
not
cannot,
possible.
it's not possible, my
We take
lords.
one by one.
One by one, your lordship, kindly take, my lords.
Common better. So
Common better.
synopsis to be filed by each.
Please.
It
My lords, once it's listed as a series, the problem is it never happen. But one of us will say no.
Individual synopsis to be filed by individual parties. Each writ petition will be taken up one after the other.
And posted also separately, my lord, so that you
Let us see, we'll
decide.
take it one
In
by one.
40,
As my lord.
If we can do one or two on that day, we'll do on one or two.
Please.
No clubbing. It's not a single tender.
No,
My lord, similar, my lord, it is
Question is same.
similar tender
Yes.
regard to supply of food grains with respect to different districts. Now their claim is that certain districts have different tender conditions.
Ah.
But in principle, the tendering authority is the same, the
No,
government.
so we'll do one or two.
Yes.
Yes.
Will follow.
Yes, will.
here, my lord, 40.1, your lordship, that is in regarding the 22 tender notification, it become an infractions, your lordship. 40.1.
That's why Mr. Hegde is doing Galata.
No, that is, he is not party in that, for this one, my lord. This is 22, in the year 22.
40.1.
40.1.
The
my lord.
memo filed by petitioner
This
is
memo-
taken on record.
Public submission.
In light of the same, petition is dismissed as having become infructuous.
Then, my lord, if
40.1 is delinked and disposed of, delinked from the present batch of matters and disposed of.
Serial number 40, my lord.
Order may be.
NOC Vakal is filed, madam, my name is not shown.
Seal number
40.
40.
Sir, list is there.
For respondent number,
Respond number 5, my lord.
40.1.
office to show the name of learned counsel so and so as appearing for R5.
R5, my lord.
Interim order may be.
Interim orders in operation extended till the next date.
And also, my lord,
My lord, 40.7. Similar matter is in order, my lords. It could be disposed of.
Sir, Nande,
40.7,
40.1.
7, my lord, the same thing.
40.1.
Infructuous.
Not infructuous, my lords. It's disposed of on the ground that I hold a APMC trade license, so I cannot participate in the technical.
There's a
It is
bar.
already, that's a bar, my lord. And it's been
Paragraph
13, my lords.
1.3.
1.3, my lords.
That is 16723.
One of
16723.
the conditions that was.
Now the condition is that you should,
Condition was I should not be having a APMC license. My lord.
where is that condition?
My lords, tender
Under
condition.
conditions.
Sir, list is correct.
condition number 5.
Condition number
5, my lord.
My lords, that's,
Subclass 3, subclass 4, my lord,
First
sorry.
matter, page 28, my lords.
Just hold on. Now that is 40 point. Now you are a holder of APMC license.
It is a covered matter.
Covered.
Covered.
Mane, that's the same matter.
matter was remanded back. So that was the finding that was given. Based on that, the petition was dismissed.
It was remanded in that matter.
Back for fresh consideration.
Ah.
And during the investigation, they found out that I have a license. So based on that, the writ petition was dismissed. Similar writ petition.
The petitioner.
Kindly say the
40.7
bottom page
is
number
dealing.
11, my lords, page
Dealing.
numbers, bottom ಅಲ್ಲಿ ಇದೆ, page numbers, my lordship, please to. ಹೌದು, ಅದರೊಳಗೆ
Petitioner.
clause number
3, 4.
4 ನೋಡಿ ಸರ್, ಅಲ್ಲ 5 ಅಲ್ಲ ಅದು.
Clause number
5 ಅಲ್ಲಿ 5 ಅಲ್ಲಿ 5. The employees of so and so related agent and their relatives should not participate in tender, and also bidders and their family members should not be owning fair price depot, APMC food grains
No,
traders, wheat flour mills,
no,
etc.
that is at Roman.
Small Roman number 5, at the bottom page number is shown as 11. In the tender notification, bottom page number, printed page number 11. ಅದೇ ಅಲ್ವಾ?
5 ಇದೆ.
ಅದೇ
Yes, yes, 5.
ಬಟ್ ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು ನಮ್ಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
Page 24 tender notification.
ಅಲ್ಲ ಅವ್ರದ್ದು ಎಷ್ಟು?
ಅದೇ ಅವ್ರದ್ದೇ.
ಅವ್ರದ್ದೇ?
24 my lord, page number. As per
Ink
tender
page
notification
24 my lord.
Should not be owning fair price depot.
Yes. Comma APMC food grains traders.
Now you have
APMC food grain license.
you have a APMC food grain trader license.
This is
The petitioner. The petitioner has called in question the validity of order at annexure F. It was contended that the rejection of the petitioner's bid was not in accordance with law. It is noticed that the tender document has a condition at 5 Roman 5. 5 Roman 5, which is a condition of eligibility and provides that those having APMC food grain trade license will not be eligible to participate. And this is a disqualification. The counsel for the petitioner fairly submits that petitioner has incurred such disqualification. Peruse the order passed in WP 7094 of 2025 as regards the same petitioner, in which a similar attack as in the present case has been rejected. Noticing that petitioner was holding a license to sell APMC food grains. In light of the same, petition is rejected, taking note of the disqualification. Yes.
One more matter, my lord, is connected to the same, my lord. Maybe posted along with this, my lord. One more matter is 2790. This is also respect of the same, my lord. It may be connected to this also.
Yes, next.
Memo, your lordship.
Date for next week.
Earliest possible so that.
17th. Interim order in operation is extended till the next date. Yes.
Grateful.
Okay.
41 for petition. A committee has been constituted, my lord, for the administration of the temple. Or it is a A-grade temple. And my lord, under the act, your lordship is well aware, my lord, it has to be constituted by Rajya Dharmika Parishad. But the temple is, my lord, A-grade, fourth respondent.
It's a notified temple.
Pardon?
Notified.
Notified, A-grade. Notified A-grade, my lord. There is no dispute about it. My lord, in fact, Rajya Dharmika Parishad has to constitute the committee. My lord, they have adopted a very novel method. Kindly see, my lord, annexure A. Annexure A, in page 15. Can I just read it?
No, what is the now challenge now? Challenge is to?
this constitution of committee of management, annexure A is challenged. Temple management committee.
Okay, so what you're saying, the procedure is not followed, or what is it?
No, it is void according to me, because my lord, Rajya Dharmika Parishad has to constitute the committee. Now, they have adopted a novel method. What I submit is, but they have seems to have passed a resolution. My lord, this committee has passed a resolution empowering its president to appoint the committees. That resolution, they say, was made in January, and therefore, my lord, the president of the committee goes on appointing the
resolution.
Committee. Kindly see annexure A.
Resolution by
Rajya Dharmika Parishad on 30th January 2024. My lord, I will just read it, my lord. Your lordship will get it. Annexure A. ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಪುತ್ತೂರು ತಾಲೂಕು ಪುತ್ತೂರು ಟೌನ್ ನಲ್ಲಿರುವ ಶ್ರೀ ಮಹಾಲಿಂಗೇಶ್ವರ ದೇವಾಲಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆ ಪ್ರಾವರ್ಗ ಎ ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆ ಆಗಿರುತ್ತದೆ. ಈ ದೇವಾಲಯಕ್ಕೆ ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿಯನ್ನು ರಚಿಸಲು ಆಸಕ್ತ ಭಕ್ತಾದಿಗಳಿಂದ ಸಾರ್ವಜನಿಕರಿಂದ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಿ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಹೊರಡಿಸಿದ ಪ್ರಕಟಣೆಗೆ ಸ್ಪಂದಿಸಿ ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ 39 ಅರ್ಜಿಗಳು ಸ್ವೀಕೃತವಾಗಿರುತ್ತವೆ. ದಿನಾಂಕ 30/1/24 ಕೈಂಡ್ಲಿ ನೋಟ್ ಮಾಡಿ. ದಿನಾಂಕ 30/1/24ರಂದು ನಡೆದ 4ನೇ ರಾಜ್ಯ ಧಾರ್ಮಿಕ ಪರಿಷತ್ತಿನ 2ನೇ ಸಭೆಯ ನಿರ್ಣಯದ ವಿಷಯ ಸೂಚಿ ಸಂಖ್ಯೆ 5ರಲ್ಲಿ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖಾ ವ್ಯಾಪ್ತಿಗೊಳಪಡುವ ಎ ವರ್ಗ ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳಿಗೆ ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿಗಳನ್ನು ರಚಿಸುವ ಅಧಿಕಾರವನ್ನು ಅಧ್ಯಕ್ಷರಿಗೆ ನೀಡಲು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. So that committee has passed a resolution. You do it, and the president is the minister. This is the Rajya, and he goes on doing it.
President of the
further.
President of the Dharmika Parishad is the minister.
Endowment minister. Third para. ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿಗೆ ಸದಸ್ಯತ್ವವನ್ನು ಕೋರಿ ಸ್ವೀಕಾರವಾಗಿರುವ 39 ಅರ್ಜಿಗಳ ಬಗ್ಗೆ ಸತ್ಯಾಪನೆ ಮಾಡಿ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಹಾಗೂ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರು ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಮಂಗಳೂರವರು ಉಲ್ಲೇಖ 3 ಮತ್ತು 4 ಸತ್ಯಾಪನಾ ವರದಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ದಿನಾಂಕ 3/1/24ರಂದು ನಡೆದ ರಾಜ್ಯ ಧಾರ್ಮಿಕ ಪರಿಷತ್ತಿನ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಪುತ್ತೂರು ತಾಲೂಕು ಪುತ್ತೂರು ಟೌನ್ ನಲ್ಲಿರುವ ಶ್ರೀ ಮಹಾಲಿಂಗೇಶ್ವರ ದೇವಾಲಯಕ್ಕೆ ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿಯನ್ನು ರಚಿಸುವ ಬಗ್ಗೆ ಈ ಕೆಳಗಂಡಂತೆ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ.
Now, under what section the appointment?
25.
One?
Section 25. Endowment Act. And he goes on appointing politicians.
No, just point out now under 25.
Section 25.
Yes.
Section 25, the Hindu Religious and Endowments Act.
Yes.
Can I just? There shall be constituted in respect of one or more notified institutions by the Rajya Dharmika Parishad. Kindly see, Rajya Dharmika Parishad, if the gross annual income of the notified institution exceeds ₹25 lakhs, and the Zilla Dharmika Parishad, if the annual income does not exceed ₹25 lakhs. A committee of management consisting of not more than 9 members. So this committee, rest is the matter. And disqualification, your lordship may kindly see.
No, but who is to constitute this committee?
Rajya Dharmika Parishad, my lord. There shall be constituted in respect of one or more notified institutions by the Rajya Dharmika Parishad.
So now the Rajya Dharmika Parishad consists of?
Section 20.
No,
section 20. Your lordship may kindly see section 20.
Yes.
Rajya Dharmika Parishad, what does it mean? Section 20. The state government may, by notification in the official gazette, constitute the Rajya Dharmika Parishad consisting of the following members: Minister in charge of the Hindu religious institutions and charitable endowments, chairman. Then Secretary to the government in charge of Hindu religious institutions and chairman endowments. Then Commissioner of Hindu religious institutions and charitable endowments, ex officio secretary.
No,
Then
just 1 minute. This is the constitution of committee of management.
Yes.
20 capital A.
Yes.
2 Roman 1.
No, my lord. Your lordship may kindly see section 20. Basically, what is Rajya Dharmika Parishad?
No, you go to the 20 capital A.
20A. Yes.
Functions of Rajya Dharmika Parishad. Then go to subsection 2.
Yes.
Roman 1. May constitute a committee of management.
Yes, may constitute a committee of management.
So this is the function of the Rajya Dharmika Parishad.
Correct. It is very clear by section 25 itself.
Yes, government.
But, and there is a stay, and my lord, they have passed a predated resolution and goes on functioning.
Let us see. Now the only point is the order itself appears to indicate that by resolution, power was given to the chairman.
Sure.
But under the scheme, it's a function of the Raja Dharmika Parishad to constitute committee of management under 20A2. So that has to be done by the Dharmika Parishad and not by the chairman.
That's all the point. And it is covered by a decision.
These are the proceedings of the Dharmika Parishad itself.
Correct,
The
but-
Dharmika Parishad meets and delegates the power.
No, that cannot be done. It must be done by, that cannot be delegated. It has to be done by the Dharmika Parishad.
Yes, sir.
It cannot be delegated to the chairman.
I will convince this court, my lord, the procedure has been followed. I'll get the file, entire file proceedings of this meeting.
The resolution
Yes, my lord.
by which you are giving to the chairman is prima facie impermissible.
I will produce the file, my lord.
I'll have it on Monday.
Yes, sir.
The learned counsel for the petitioner submits that the order of annexure A is required to be set aside on the sole ground that the power ought to have been exercised to constitute committee of management by the Rajya Dharmika Parishad and could not have been delegated to the chairman as is evident from annexure A. Full stop. Reliance is placed on section 25, 20, 20 capital A, subsection 2, Roman 1, full stop. For say of the state. This is the matter on Monday, the same state.
Must the interim order to be continued.
Interim order continue till the next day.
Yes.
Yes. Now there can be high command, but not high command above the statute.
Yes.
Root matter, Vijay Prasad, KGA.
Huh?
Lordship, the report says that his father is dead.
Ah.
Leave it to your lordship, and 15 days emergency parole.
Within the format. The petitioner has sought for being released on emergency parole in light of the death of his father, so as to perform the religious ceremonies. Next. The petitioner has been convicted by virtue of proceedings before the Sessions Court. Which clause of that manual just check?
Lordship,
So it is submitted that the father of the convict, the petitioner is the mother, is it? Or who is the petitioner? Petitioner is the convict.
Who's the
Petitioner is the wife of the convict, my lordship.
First in Barjidreli.
Emergency parole.
The petitioner's one nimsha. The petitioner is the mother, is it?
Petitioner is the wife of the convict, my lordship.
So petitioner, first sentence is the
637 Roman 2.
The the petitioner is the wife of the convict and has sought for being enlarged on emergency parole in order to perform the ceremonies relating to the death of his father. Convict was sentenced for offence under section 302 and other offences. It is asserted that the convict's father passed away on
30th of June, my lordship.
30th of June 2025. Full stop. Accordingly, present petition has been filed. Clause?
No, your lordship, 643, your lordship. 643. 643, your lordship.
1A.
1A.
It is Learned AGA submits that they are verified regarding the death of the convict's father. In light of the same, taking note of 643 Roman 1A of the Karnataka Prisons and Correctional Services Manual 2021, petitioners entitled to be released on emergency parole for a period of 2 weeks.
No, 2 weeks.
15 days.
15 days. But here, one submission, your lordship. He has not moved for any application. He could have done it, they would have given. Any death or if the convicts, family members, if there's any death, generally they give them emergency parole. But in this case, he has not filed an application, but nevertheless, 15 days parole may be granted, your lord.
15 days. Good stuff. As rightly pointed out by Learned AGA, petitioner could have approached the prison authorities itself and sought for relief under the manual as referred to above. However, in the facts of the present case, looking into the factum of death of the convict's father, it would be appropriate to enlarge the petitioner on emergency parole for 15 days. No, but Annexure C is...
No, C is the police report. Rather than they could have, before they passed an order, he has come before this honorable court.
Accordingly, the petition is allowed. In part, mandamus is issued to the respondent prison authorities to release the convict so and so on emergency parole
no emergency
for a period of 15 days. Next, Roman 2. The convict shall mark his attendance once in a week in the jurisdictional police station throughout the period of parole. Next, the jurisdiction police to ensure his surrender after completion of period of parole. The chief superintendent of the prison concerned may stipulate other conditions as may be necessary. Accordingly, petition is disposed of. AGA accepts notice for the respondent. Yes.
Grateful, my lord.
Pass for matters list 1, serial number 5. Shanti Bhushan.
There are two clarifications.
Please, madam.
One, the passport number in the sealed cover.
Please, madam.
With respect to this petitioner, you just take that. So the petitioner's passport number.
Please, madam.
He has given along with the statement now what counter he has filed. Now just go to that counter.
Page 13, my lord.
annexure H of his counter.
Please, my lord.
At the bottom, it says passport number,
Please, my lord.
isn't it? Now that number is A11 so and so.
Please, my lord.
But here in this, what you have produced,
Please, my lord.
the passport number differs.
The passport number is AB 859343, my lord. In page 13, my lord.
Page 13 of?
Page 13 of my counter, my lord. Lord, all that my contentions are this, my lord.
No, you had made a submission.
Please,
that his passport number actually belongs to somebody else.
A Tanzanian lady, my lord. It's there, my lord.
Correct. So what I'm saying, his passport number,
please,
you go to page 15 of his counter affidavit.
Please, my lord.
Annexure H.
A11651384, my lord.
Correct, isn't it?
Please, my lord.
So now what is your...
The original passport is here, my lord.
Of his?
Yes, my lord. It was in the college.
So he doesn't have the original passport.
He was in possession.
Just wait. Just have patience.
He was in a possession of that passport, my lord. When he was appended by the Atinagar police.
This other one.
Please, that belongs to Tanzanian, my lord. The sealed cover, my lord, the first document, it belongs to that lady, my lord. Insofar as his visa is concerned, if your lordship may kindly turn to page 14, annexure R4 of my counter, my lord.
R4.
Please, my lord. Page 14, my lord.
Yes.
My lord, this visa, my lord, belongs to a person of a Sri Lankan national, which I have placed it in the sealed cover again. The original visa is here, my lord. Sorry, sir. In the passport, it is stamped. So it both, my lord, the passport and the visa, which does not belong to the petitioner, first petitioner.
So yeah, you are saying that he possessed this, which is an offense by itself.
Please, no, my lord, is his passport.
Just wait. Now, do you have your original passport?
My lord, that is with you, my lord. That's what he has given you.
No, which is your original passport?
That is what he has given you, my lord. That is my passport. I have no other passport. That is my visa.
This one?
Yes, my lord, my passport and visa. Because you ask a question, my lord, where is his original passport? That's what I was telling you that time, that is this the one in his hand.
Just one. But this appears to be his only.
My lord, all that my contentions are this, my lord. When he was appended by the Atinagar police,
correct,
he was in wrongful possession and a forged passport which he had produced.
This one?
No, the one which I have placed in page 13 and 14, my lord. 13 and 14 of my counter, my lord.
My lord, it will be my turn now because the allegation has continued for a long time.
He's not finished anything. You just wait.
My lord, is the same allegation.
Until I am convinced, I am not. I have to be convinced. Let me understand. Yes, Shanti Bhushan.
Please, my lord, if your lordship would kindly turn to my lord, page 13.
Page 13
of my counter, my lord.
Filed on 17/6.
Please, my lord.
Yes.
Please, my lord.
That is R4.
Please, my lord. If your lordship could see, my lord, this was when the police appended the foreigner. And upon inquiring with regard to the passport and visa, he was in the possession of this. He produced this. We verified it. When we verified it, the passport number belongs to a Tanzanian lady, my lord, Tanzanian national, my lord, which I have placed it in the sealed cover. Not that one, my lord. If your lordship could compare the number of the passport here in my lord in page 13 and the sealed cover, sir. Sealed cover open.
This was found with him.
Please, my lord.
The origin, no, not the original, only
Not
Xerox.
the original is with the college. We bought it, my lord. The officer bought it from the college.
Which one? This.
Please, my lord.
My lord, I request you.
Just wait, just wait. Yes. So now what was found with him?
Was a forged and a fabricated.
But where is that original one that was seized from him?
There's no original seized. This was the one which was seized. The one.
The Xerox.
Please. You have the original? No.
Just find out if they had collected the. Was he having that original with him?
This passport is with you? No. It was just a paper, my lord.
Paper. But then have you drawn any mahazar? Or after for having seized?
That the
have
police
you
have
drawn,
to have.
have you drawn? Just find out any proceeding has been drawn?
No, the police on that day when they apprehended them, these are the passports.
Huh? Your passport. Oh, no. No.
If your lordship may kindly hear me.
You shouldn't talk till I give you permission. You wait.
Lord, it was not them, Lord.
What's running in my mind?
Please, my lord.
Now, what was seized was a Xerox of a passport which you say is forged.
Please.
Isn't it?
Please.
But his original passport and visa is this with
Please.
the college authority.
Please.
But that there is no discrepancy.
No, there's no discrepancy with that. What the instructions are this, my lord. The original is with the college. The forged and fabricated is with him in his possession. Upon the police inquiring about the passport and visa, this has been produced.
Correct, but you should have followed some procedure if you are going to seize something like that, even if it is Xerox.
All that, my lord, the police ought to have done. To be fair to the court, my lord, all that the police ought to have done is to register an FIR. If he was registered, if an FIR was registered, my lord, absolutely the next thing would be, my lord, he would be in the bars for having a forged and fabricated passport.
But again, that's a Xerox, isn't it?
That's a Xerox, my lord, which the police have.
The modus operandi is this before the police. What happens is they create this documents. They carry the Xerox with them. They did not apprehend that they will be sent to the FRO. What has happened is when the offence was committed, when they were found, what police has done is the verification has to be done by the FRO. So what the police does is instead of keeping them, they send him to the detention center. So we have handed them over to the detention center because he's a foreigner. Now, my lord, if at all an FIR has to be registered, then he will have to stay here and he will have to, then we will have to book an offence under narcotics, which he cannot leave because he said he's a student to be verified by FRO. After verification, the FRO has to recommend us. Now they have given them an option to leave the country. Otherwise, if an FIR is registered, my lord, then they will have to face the entire trial and they'll be stuck here.
Permission to speak, my lord.
Now, is it, what do you say? You answer to the questions.
Yes, my
What
lord.
do you say regarding their allegation that, regarding their assertion that you had copies of this with you?
False and frivolous. And may I kindly show this honorable court that all these things are evolution of their allegations in order to circumvent this writ petition. My lord, if this document was with the petitioner at the time that he was arrested, my lord, may I kindly refer you to the reply given to my lord, kindly see Annexure R1. Because this is a made up thing just to show that, and by the way, the question before this honorable court is not.
Annexure R1.
Yes, my lord, page 8 of the counter affidavit of the respondent number 1. Here, my lord, the respondent number 2 writes this letter to the respondent number 1. can see, my lord, making an allegation of of not having visa and passport. That's the heading. I'm relying on the translation, my lord. However, my lord, in all the allegations made, there is no mention of any forged passport or fake passport. It's not here, my lord. The submission that the respondent number 2 counsel, the Land Council for the respondent number 2 is submitting, cannot be taken on the face of it. If the police finds any fabric, my lord, is an offense under section 335, I believe, 335 of BNS. It's punishable with up to 2 years imprisonment. And the police saying they found this, and okay, my lord, let's assume they found it. And my lord, you come to, kindly please come to annexure. Annexure. This is provided again by the respondent, my lord. That is a annexure R7. Is it R7? Yes, my lord. Annexure R7. This is, according to the respondent number 2, saying is a request letter given by the respondent number 2. Respondent number 1 is saying page number 37, my lord. Page number 37, my lord. Annexure R7. I don't know if the numbering is the same with what your lordship is having.
Yes, yes.
This respondent number 2, who is now contradicting himself, writes a letter saying that they have conducted an investigation. Nothing is found frivolous with these petitioners. So either they say that they found this, the respondent number 2, they found this thing in my possession, or they didn't find it. If they found it in my possession, then on what basis are they giving me, a clean sheet? Is there anything, did I give them any favor to write a clean sheet saying there is nothing that they found with me? That is to show your lordship the evolution of these allegations. And now you see the same respondent number 2, who originally gave me clean sheet, now colluding with respondent number 1, who is serving who, my lord. Again, my lord, if you may kindly turn to this next annexure, R8. This is allegedly given by NCB. Is it an CCB? As per the submission of the Learned Counsel for the respondent number 2, my lord, it is said that this CCB arrested the petitioners on that day, but because they don't have jurisdiction, they handed them over to the police, the respondent number 2. So this same person who arrested me made a wide allegation of all manner of things, but never was it mentioned that I am having any forged document. They said that there was no drugs because, according to them, they said that they suspected me of involving in narcotics. But this CCB said no drugs, though no drugs were recovered from me, though they found some activities in my phones showing that I am selling drugs. They made all these allegations. There is no mention of recovery of anything from me. And my lord, if you see annexure A of the writ petition, my lord, annexure A, I'm sorry, my lord, for taking you to different places. Annexure A should be at page number 13, my lord. Yes, page number 13. The respondent number 1 denies receiving this document. Now, I am expecting the counsel for the respondent number 2 to address this, but instead of speaking on what he has issued in favor of me, he is speaking against it. Again, in this place, my passport number is mentioned. There is no allegation of possession of anything, my lord. So to show, my lord, that all these things are evolution. And my lord, if the respondent number 2 and number 1 are saying that they recovered from me, my lord, isn't it a procedure under the BNSS of recovery of arrest, seizure of documents? under section 103 and 105. What is the document showing that I was searched according to procedure? My lord, whatever they are saying is proving to the fact, my lord, what I've been saying, that my right has been violated beyond measure. I am treated not like a human being like by these respondents. Today they can say something else, tomorrow they will say something else. If they recover something from me, from where? On my body or in my house? If it is in my house, where is the provision of section 103? Which is showing that you have to produce evidence, witnesses. Where is the signing of the evidence? And if it is on my body, where is a copy showing to me? There has to be a copy given to me of the items recovered from me. My lord, where is that copy? And my lord, not only recording of these things, there has to be a videographing under section 105 of BNSS. Where is that? My lord, if such document exists, then it's going to show that I was arrested on the 21st. If it exists, and then they had me from 21st to 23, which is beyond 24 hours without authority, showing your lordship that my right is violated. And if it does not exist, my lord, and they are claiming that they recovered something from me, again, it shows a violation. Whichever one they choose, I don't care what they choose, my lord. Let them choose anyone, but each of them shows to this honorable court that my right has been violated beyond measure. My lord, it is a settled principle of law that the Indian Constitution did not give us Article 21, that is right to life and liberty. It is said that the Constitution recognizes this because it is an inherent right in every human being. It is a natural right, and that is why Article 1 of the Universal Declaration of Human Rights, 1948, which India is not only a signatory, my lord.
Just 1 minute. Now, insofar as the first petition is concerned, now the police have goofed up. That you couldn't have put it at that point itself. You should have told him, "I'm going to register an FIR. You please leave." You have sent in writing saying that there is nothing against him.
What had happened was, my lord, the jurisdictional police, the arrest at the raid was conducted by the CCB, my lord.
There is no arrest in this case. There was no arrest on the ground that he possessed a forged passport. What was recovered was a Xerox, 1. 2, you have not followed any procedure of recovering or taking action of filing an FIR on recovering of that forged document. And that's only a Xerox. So you have given a letter that there is no adverse report in the police station as on that date. So you can't now contradict it.
No, my lord. Now, my lord, the CCB also is a party to this proceeding. We will secure the records of the CCB.
If your lordship may make one submission.
Yes.
If your lordship could
Now, what is the other ground?
For a moment, my lord, if your lordship could kindly turn to page 39, Annexure R8. Of my counter, my lord. Please, my lord. May I just read it out, my lord? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯರು ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ದಿನಾಂಕ 23/12/24ರಂದು 3 ವಿದೇಶಿ ವ್ಯಕ್ತಿಗಳು ಮಾದಕ ವಸ್ತುಗಳ ಮಾರಾಟ ಮಾಡುತ್ತಿದ್ದು ಹಾಗೂ ಯಾವುದೇ ರಹದಾರಿ ಪತ್ರವನ್ನು ಹೊಂದದೆ ಅನಧಿಕೃತವಾಗಿ ಬೆಂಗಳೂರು ನಗರ ಆರ್ಟಿ ನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ ಚಾಮುಂಡಿನಗರ ವಾಸವಾಗಿರುವ ಬಗ್ಗೆ ಬಾತ್ಮೀದಾರರಿಂದ ಮಾಹಿತಿ ಬಂದಿದ್ದು ಆ ಮಾಹಿತಿಯಂತೆ ದಿನಾಂಕ 23/12/2024ರಂದು ಸರಹದ್ದು ಅಪರಾಧ ಮೇಲೆ ಆರ್ಟಿ ನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರಿಗೆ ಠಾಣೆಗೆ ಹೋಗಿ ಮಾಹಿತಿ ಬಗ್ಗೆ ತಿಳಿಸಿ ಅವರ ಜೊತೆ ಬಾತ್ಮೀದಾರರಿಂದ ಬಂದ ಮಾಹಿತಿ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಕೆಳಗಂಡ ಆಸಾಮಿಗಳು ಬಾತ್ಮೀದಾರರ ಮಾಹಿತಿಯಂತೆ ಸದರಿ ವಿಳಾಸದಲ್ಲಿ ವಾಸಿಸುತ್ತಿದ್ದು ಪರಿಶೀಲಿಸಿದಾಗ ಅವರ ಬಳಿ ಯಾವುದೇ ತರಹದ ಮಾದಕ ವಸ್ತು ದೊರೆತಿರುವುದಿಲ್ಲ. ಆದರೆ ಅವರ ಮೊಬೈಲ್ ಪರಿಶೀಲನೆಯಿಂದ ಅವರ ಮೊಬೈಲ್ನಲ್ಲಿ ಮಾದಕ ವಸ್ತುಗಳ ಮಾರಾಟಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾಹಿತಿ ಇದ್ದು ಹಾಗೂ ಬಾತ್ಮೀದಾರರು ನೀಡಿದ ಮಾಹಿತಿಯಂತೆ ಇವರು ಮಾದಕ ವಸ್ತು ಮಾರಾಟದಲ್ಲಿ ತೊಡಗಿರುವುದು ಖಚಿತಪಟ್ಟಿರುತ್ತದೆ. ಸದರಿಯವರು ರಹದಾರಿ ಪತ್ರ ಹಾಗೂ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿ ಸದರಿ ಕೆಳಕಂಡ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಅವರ ದಾಖಲಾತಿಗಳ ಬಗ್ಗೆ ಸಮಂಜಸವಾದ ಉತ್ತರ ನೀಡದೆ ಹಾಗೂ ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸದ ಕಾರಣ ಸದರಿ ವಿದೇಶಿ ಪ್ರಜೆಗಳನ್ನು ಮಾನ್ಯ FRR ಅವರ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿ ಸೂಕ್ತ ಕ್ರಮಕ್ಕೆ ಕೈಗೊಳ್ಳುವಂತೆ ಆರ್ಟಿ ನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಕೋರಲಾಯಿತು. This is on 21/5/2025.
The requisition made by the RT Nagar police was on 10/4/2025. This is much later, my lord. Initially, my lord, the RT Nagar police said, no, of course, my lord, what is there, my lord. RT Nagar police said, I don't know why there was such a intimation to the FRRO, my lord, saying that page 39, your lordship got that, my lord, page 39. ಸದರಿ ಮೇಲ್ಕಂಡ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಮಾಹಿತಿಯನ್ನು ಠಾಣೆ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ವಿದೇಶಿ ಪ್ರಜೆಗಳ ಬಗ್ಗೆ ಠಾಣೆಯಲ್ಲಿ ಯಾವುದೇ ಪ್ರತಿಕೂಲ ವರದಿಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಸದರಿಯವರನ್ನು ಆಸರೆ ಸೆಂಟರ್ ನಿಂದ ಬಿಡುಗಡೆ ಮಾಡಲು ತಮ್ಮ ಅಭ್ಯಂತರವಿರುವುದಿಲ್ಲ ಎಂದು ಮಾನ್ಯರಲ್ಲಿ ತಮ್ಮ ಮೂಲಕ ತಿಳಿಸಿದೆ. This is on 10/4/2025. The CCB on 21/5/2025 has intimated the FRRO that, Lord, they are involved in the activities as stated therein. So therefore, my lord, based on this, Lord, we have restrained their movement by an order, my lord. If your lordship may kindly turn to my lord, page 10, annexure R2, my lord. Order dated with order, my lord. May I read it out? With reference to the request letter dated so and so, the police inspector RT Nagar Police City Foreign Registration as FRRO in persons of MHA Government of India notification dated so and so hereby impose the following restrictions under clause E of subsection 2 of subsection 3 of the Foreigners Act 1946 and under para 11(2) of the Foreigners Order 1948 in the following foreigners with immediate effect. Lord, admittedly, my lord, this order passed by the FRRO is not under challenge before this court. Neither in the petition nor in the counter, in the rejoinder what my learned friend has filed.
I have in the rejoinder, I have challenge because your lordship mentioned to file rejoinder.
I'll come back to you, just.
Okay.
But as on 23/12/24, there was no adverse report in the police. As on 23/12/24,
with reference to the request letter by 23/12/2024, Lord, the first line of the police inspector RT Nagar, Lord, that request was made. Based on that request, this order was passed. Lord, that request has to be produced by my learned friend, or I'll produce it, my lord. There is absolutely no problem with regard to that.
My lord, on the basis of
just wait.
Lord, it's produced, my lord. It's produced at annexure R1, page 8, my lord. I'm sorry, my lord. It's produced. May I read that, my lord? Annexure R1, page 8, my lord.
Yes.
ವೀಸಾ ಅವಧಿ ಮುಗಿದರೂ ಕೂಡ ಅವರು ಅನಧಿಕೃತವಾಗಿ ವಾಸಿಸುತ್ತಿರುವ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ತಮ್ಮ ಮುಂದೆ ಹಾಜರುಪಡಿಸುವ ಬಗ್ಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಮತ್ತು ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯರಲ್ಲಿ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ RT ನಗರ ಪೊಲೀಸ್ ಠಾಣೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸೋ ಅಂಡ್ ಸೋ 22/12/24 ಸುಮಾರು 17 ಗಂಟೆ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ವರದಿ ನೀಡಿದ್ದು, ಸದರಿ ವರದಿಯಲ್ಲಿ ತಾವು ಮತ್ತು ತಮ್ಮ ಸಿಬ್ಬಂದಿಗಳು ಸೋ ಅಂಡ್ ಸೋ ಚಾಮುಂಡಿ ನಗರ ಸೀತಪ್ಪ ಲೆಫ್ಟ್ ಸೋ ಅಂಡ್ ಸೋ ವಂದನೆ ಮಾಡಿ ಮನೆಯಲ್ಲಿ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಅಕ್ರಮ ಚಟುವಟಿಕೆಗಳು ತೊಡಗಿರುವ ಬಗ್ಗೆ ಸಿಸಿಬಿ ಘಟಕದ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ಮತ್ತು ಅವರ ಸಿಬ್ಬಂದಿಯವರು ಒಂದು ವಿಚಾರಣೆ ಮಾಡುತ್ತಿದ್ದಾಗಿ ಮಾಹಿತಿ ಬಂದಿದ್ದು, ಆಗ ಗಸ್ತಿನಲ್ಲಿ ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಅವರು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ಸಿಸಿಬಿ ಘಟಕದ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸೋ ಅಂಡ್ ಸೋ ಅವರವರು ಚಾಮುಂಡಿ ನಗರ ಸೀತಪ್ಪ ಲೇಔಟ್ ರಿಜ್ವಾನ್ ಅವರ ಮನೆಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಅಕ್ರಮ ಚಟುವಟಿಕೆಗಳು ತೊಡಗಿರುವ ಬಗ್ಗೆ ವಿಚಾರ ಮಾಡುತ್ತಿದ್ದು, ನಾನು ಸಹ ಅವರೊಂದಿಗೆ ಜೊತೆಗೂಡಿ ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ ಒಬ್ಬ ಮಹಿಳೆ ಇದ್ದು ಆಕೆ ನೈಜೀರಿಯಾ ದೇಶದವರಾಗಿದ್ದು ಸದರಿ ವಿದೇಶಿ ಮಹಿಳೆ ವೀಸಾ ಅವಧಿ ಮುಗಿದರೂ ಕೂಡ ಅನಧಿಕೃತವಾಗಿ ವಾಸಿಸುತ್ತಿರುವುದು ಬಂದಿರುತ್ತದೆ. ನಂತರ ಸದರಿ ವಿದೇಶಿ ಮಹಿಳೆ ಹೆಸರು ಸೊ ಅಂಡ್ ಸೊ ನಂತರ ಈ ದಿನಗಳಲ್ಲಿ ಅವಳೆಯಾಗಿದ್ದರಿಂದ ಮಹಿಳೆಯನ್ನು ರಾತ್ರಿ ರಾಜ ಮಹಿಳಾ ನಿಯೋಗಕ್ಕೆ ಠಾಣಾ ಮಹಿಳಾ ಸಿಬ್ಬಂದಿಯೊಂದಿಗೆ ಕಳಿಸಿದೆ. ಈ ದಿನ ಬೆಳಿಗ್ಗೆ ವಾಪಸ್ಸು ಠಾಣೆಗೆ ಬಂದು ಕರೆಯಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ನಂತರ ಈ ದಿನ ಮತ್ತೆ PSI ಅವರು ಸದರಿ ಮನೆಗೆ ಹೋಗಿ ವಿಚಾರಿಸಿದ 3 ಜನ ಇವರು ನೈಜೀರಿಯಾ ದೇಶದವರಾಗಿದ್ದು ಸದರಿ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ವೀಸಾ ಅವಧಿ ಮುಗಿದರೂ ಕೂಡ ಅನಧಿಕೃತವಾಗಿ ವಾಸಿಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತೆ. ನಂತರ ಸದರಿ ವಿದೇಶಿ ಪ್ರಜೆಗಳು ಹೆಸರು ಸೊ ಅಂಡ್ ಸೊ. ಈ ಸದರಿ 4 ಜನ ವಿದೇಶಿ ಪ್ರಜೆಗಳು FRR ಕಚೇರಿ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಹಾಜರುಪಡಿಸುವಂತೆ ಪೊಲೀಸ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿದ್ದು ಸದರಿ ಮಾಹಿತಿಯನ್ನು ಅವರ ನನಗೆ ಕೂಡಲೇ ತಿಳಿಸಿ ಈ ಬಗ್ಗೆ PSO ಅವರು ವರದಿ ನೀಡಿರುತ್ತಾರೆ.
This is no, the petitioner's visa was still valid.
Petitioner visa, my lord.
That's correct, my lord. That's correct.
Insofar as the first petitioner, my lord, it was till 26/4/2025. The order was made. Please, insofar as the first petitioner, my lord, visa was valid. Insofar as the second petitioner, my lord, was concerned,
The first petitioner's visa has been cancelled, is it?
now it is cancelled, my lord.
By order dated?
By order dated, my lord, order dated visa cancellation. Visa cancellation order.
Known order.
When? 4th June, my lord. It's cancelled on 4th June. 4th June. Huh?
After the filing of the writ petition, my lord.
After filing?
Yes, my lord. If your lordship may, I'm sure, my
lord,
lordship,
the instructions is that
I have the documents, my lord, to show. If your lordship permit me.
On 4th of June?
Yes, my lord. My lord, in my counter affidavit, I have shown that the petitioner applied for visa extension, my lord. And if my lord may kindly see annexure 15, that was the application.
Page?
Page number 15 of the reply, my reply to the counter affidavit. So it was on the 24th of April because his visa was valid till 26th. So this is the application, my lord. If your lordship may kindly turn to the next annexure at page number 18. This is a bona fide, my lord, given by the college, page number 18, annexure J, given by the college, certifying that he is a bona fide student. And it's mentioned that he is also not appeared in exam, first semester and second semester exam, because he is kept in the detention before. And my lord, kindly see annexure K1, my lord. This is the communication, email communication given by the respondent number 1 at page 20, my lord.
When did you file the writ petition?
On 27th of May.
On?
27th of May, my lord, before the vacation bench. So, my lord, if you see at page number 20, this is a communication given by respondent number 1 to the petitioner number 1, saying your application is under process. My lord, if your lordship has seen that, your application is under process. This was on May 2. So this application was still in process until filing. And my lord, if you may turn the next page, you will see K2. That is on June 3. That was after filing of the writ petition. Then they wrote an email. Visa extension for foreigner service has been closed. No reason assigned. It's a counter to my writ petition. And my lord, one more document I want to show you. I mean, I got this document after my filing of my reply. This was a communication given by the respondent number one and telling the petitioner number one that his visa has expired, my lord. If I may kindly give your lordship. My lord, this was given by the respondent number one, reminding him, he said, Mr. Miss Okafo Obinna, that's the first petitioner, national of Nigeria holding passport number, is hereby informed that as per records available in our system, your visa extension has expired on 26 April 25. Please visit the nearest FRRO office for regularizing your stay in India, or leave the country as you are violating the Foreigners Act 1946.
What was the order of your detention?
My lord?
What was the order of your detention or sending to the?
The order, my lord, is as per annexure R, I think R8, R1, I think.
What is the date?
23 December 23. This is annexure R3, my lord, at page 12.
What was the date on which you were sent to that center?
On the same date, 23
Of
December 2023.
24.
Sorry, my lord.
That page 10, annexure R2.
What is the date?
23/12/2024.
24. Yes, my lord.
But as on that date, visa was not cancelled.
Visa was not cancelled.
Let us see
The cancellation of visa, what my learned friend referred in page 20 of annexure K1, is an auto-generated message. The process of cancelling his visa started on 28/5.
28/5.
The order is here, my lord. Cyber Torsi.
May I have a copy?
Let us see, we'll continue.
Please.
My lord, if I may show one thing, just only one thing, one point, my lord. If you may kindly see the synopsis of petitioner respondent number one. My lord, if you see page number one.
Synopsis.
At page number one, he saying proposing my writ petition. My lord, kindly see the submission at
Synopsis.
At para number two. At para number two, my lord,
yes,
of that he said, submissions. The petitioners are not entitled to be released due to the following reasons. One, petitioners are illegal migrants for the reason mentioned in page 4. So they have said they are opposing this because I'm illegal migrant. And that means if it is shown that I am not illegal migrant, my lord, then this objection fails. And my petition is entitled to succeed, my lord.
But you have not challenged formally the order by way of amendment of your petition regarding their order sending you to that camp.
My lord, in the rejoinder, I have done that. It's part of my prayer, my lord. If you may see the prayer in, not only in, but at para number 4.
No, but you may have to seek for amendment of the petition to include that prayer.
No, my lord, see, that the question is whether he has an authority to detain someone who has a valid passport and visa. That is the question this honorable court has to, I have visa, I have passport. What is the rationale? If an order of a civil authority is found to be unjust, to be arbitrary, it has to be set aside immediately without seeking for any amendment. And by the way, my lord, I didn't know about this order until after filing the writ petition. In fact, this again shows the arbitrary and high-handedness of respondent number 1. They cannot be, the order cannot be unreasonable.
We'll consider. Now, there are two parts of it. One is your detention.
Restriction.
Restriction.
Not under 3.
Actually, it's detention, my lord.
One is your restriction. Even if that were to be set aside, now how do you get over the cancellation of your visa.
Because that's what I have submitted, my lord. There was no rationale, no reason for them to cancel my visa. I am a valid student. The sovereign,
You're correct, but insofar as you are sending a restriction imposed, we'll consider. That's one part of it. But now your cancellation of your visa.
even they have not produced an order canceling the visa. My lord, see, the thing is, there has to be. See, my lord, I referred one judgment. The petition, the respondent number 2 is precluded from acting in an arbitrary and unreasonable manner.
Just one. Cancellation of visa is as per annexure.
As per annexure. No, that is not placed, my lord. That is
Place
not
it,
placed.
place it on record, please. Yes, relist.
No reasons may be assigned.
Correct, but there must be some order at
Yes, my
least.
lord. I'll produce it.
That you have to place it.
Please, please.
But it looks like the date of detention appears to be not in accordance with law.
May make one submission and one suggestion to my learned friend, my lord, since it's heard. My lord, at the best interest of the first petitioner, in the event if lordship's considering it, at the best, my lord, he could go back and come on a visa, because now the visa is cancelled. Apply for a fresh visa and come back.
The consequence of that is if he goes, he will be blacklisted. And there is no reason for that. My lord, kindly see, I'm filing this, only one para in this, para number 17, to show that the ground that they are urging cannot be acceptable. Para number 17, my lord, kindly see.
Let us see.
The same submission is made. Only one para, my lord, I'm reading. I'm not reading too much. Only one para 17. He said, this was a similar case. He said, he's a foreigner and his visa was cancelled also. This is by Bombay High Court. Please. At para number 17, he said, the learned counsel for respondent had also contended that the petitioner had no rights and therefore cannot invoke the jurisdiction of this court under Article 226 of the Constitution of India. This court is not persuaded to accept the said contention, while the petitioner, being a foreign citizen, may not have certain rights, but nonetheless, he is entitled to the protection under Article 14 of the Constitution of India. It is well settled that Article 14 of Constitution strikes at arbitrariness in state action. Thus, notwithstanding that the petitioner is not a citizen of India, the respondents, being state, are enjoined to act fairly and to follow principle of natural justice. In everything, my lord, nothing, no opportunity was given to me. Every action was unjust. It was unreasonable. It was arbitrary. Why? Because he said, I am a foreigner and then I have no right.
Relist the matter on.
Lord, that judgment, what my learned friend is referring, is with regard to an OCI card holder, not with regard to a foreign national.
Cancellation of visa is a foreigner. OCI card holder is a foreigner, my lord.
Relist on Monday.
Great.
Same stage.
Great.
You place the visa cancellation.
Please, please.
18, Mithun.
Passed over.
Lord, filing power, my lord, on behalf of respondent 3 and also the memo, my lord.
Put it.
14.
Yes.
So in this memo, my lord, the respondent number 3 in the above petition shall call for its state executive meeting on July 20th, 2025 to consider the representation submitted by respondent number 4 seeking permission to fill up vacancy to the president post at the respondent number 4 Assam District Committee in accordance with 10O of the bylaws. In view of the same, writ petition may be disposed of and the impugned order at annexure A of the writ petition or directing to hold the elections will not arise. Hence, the same may be taken on record in the interest of justice.
We will dispose it of in terms of the.
Please. Yes, ma'am.
Two submissions, Your Lordship. Till then, annexure A should not be given effect to, that will not survive.
No, that correct.
That annexure E, that will not survive for.
Correct.
The other development which has taken place in the interregnum period is that on 3/5/2025, resolution was passed by respondent number 4, district association seeking permission from this state association. Since no action was taken by the state association, on 10/3/2025, a resolution was passed by the district association nominating respondent number 5 as the president, and thereafter a letter was sent on 12/3/2025. Your lordships, yesterday I have furnished that copy.
That will have to go now.
Correct. That, no,
Have
that
to be
needs to be.
redone. It will be redone in terms of 10O. Now,
Correct.
in terms of the permission granted, now you can proceed further in terms of 10O. Also,
Correct. On
developments to
5th
the
March, my lord,
contrary will have
immediately
to
on tendering the resignation, they submitted representation.
No, all that will have to be
That we
ignored.
will place it before the, my lord, committee for its consideration on 20th July.
But till then, that annexure A should not move.
And
Annexure
your-
A does not survive. Now it has
Correct.
to
And
go.
your action without getting the permission of the state committee.
Yes.
Whatever is done also will go.
It's also contrary, my lord.
Now, in light of the permission, you can proceed in accordance with 10.
Now resolution was passed and request is made. Let them consider from that state,
Yes.
giving permission.
Yes, my lord,
to nominate.
5th March, they have submitted representation along with the resolution, but that will
From that
consider.
state, let them.
That will
The
consider.
petitioner has sought for issuance of writ of certiorari to set aside direction dated 26/6/2025 at annexure A, whereby the Deputy Registrar of Cooperative Societies had disposed of the proceedings, directing the parties to approach the civil court.
No, it is not disposed of, your lordships. A direction was given to hold election.
Hold election.
Annexure E was passed by respondent number 3 here. That was set aside and a direction was given to hold election and to give the report. That is not disposed of.
Again, but
That will be subject to result of the suit, but that is not relevant here.
Hello, 26/6/25 at annexure A, full stop. It is noticed that in terms of 10O of the bylaws, in the event of any vacancy, the district society, district association is directed to proceed further to fill the same after obtaining permission from the state body. Though certain action was taken by the respondent number 4.
3 years.
4. Respondent number 4. It is an admitted position that even respondent number 4 had not taken permission from the state body.
Yes.
Memo filed by respondent number 3, which is a state body, reads as follows. Full stop. Further submitted that the state body would now consider the requisition made by respondent number 4
On 5/3/2025.
On 5th March 2020.
on 5th March 2025 in accordance with the bylaws and law. Full stop.
The annexure E.
Learned counsel for the petitioner submits that the legal grievance would stand addressed if procedure as per bylaw is followed. In light of such stand by both the sides, annexure A is to be set aside.
Annexure E also. which is
Annexure A?
A and E, my lord.
A and
E.
both.
ಅಲ್ಲ, E ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ, they are not challenged.
No, that's okay. That's okay.
Because annexure E is the order passed to respondent number.
Annexure,
3,
under annexure E, my lord.
nominating the petitioner.
Annexure A and E are set aside. Full stop. All action taken by the fourth respondent to give effect to 10O with respect to their representation, which still has not received approval of the state committee, would also not have any legal standing.
Yes.
In light of the stand of the state body as reflected in the memo which is in consonance with the bylaws, petition is disposed of, setting aside A, E, as well as action of the fourth respondent referred to above. Needless to state that the filling up of the vacant post would have to continue once the state body decides in its executive meeting on July 20th, 2025, full stop. The further process would be strictly in accordance with the bylaws. Accordingly, petition is disposed of.
Yes.
Serial number 123, time was given.
123.
123.
May I make a mention? 103,
123.
Now it's, yes, what state?
103, there was direction to deposit the amount.
Just 1 minute, just 1 minute.
101.
Yes, just 1 minute. State
123.
123.
Yes. 123, 123.
123.
We have raised a preliminary objection. In respect of the impugned order, my lord, there is a right of appeal. Section 63A of the Act, my lord, provides for appeal, statutory appeal to this very honorable court. There are 3 judgments, my lord, on that regard.
No, they have appointed.
May just pass on, my lord.
There is a
because maintainability
recommendation.
has to be. This is
There
one
is
of
a
the
recommendation made
judgments.
by
Appeals for
certain
the-
political persons.
Okay,
And
same.
the very same
Open
recommendation, print and ink becomes the appointment. And there are totally
Two more.
150 applications pending.
Consistently, my lords, may I just pass on this, the other 2 judgments, my lords, where appeal is entertained and orders are passed. Because appeal is maintainable only on a
It is not a
substantial
bar.
question of law. Appeal is maintainable under section 63A only on a substantial question of law. Lords, in respect of most of the appointments which is made under section 25, one of which came before my lords a coordinate bench very long time back. After the amendment of 2012 to the Act, lords, this honorable court took the view that its appeal is maintainable. Considering that the writ petition was pending for 6 months, the writ petition was directed to be converted into appeal. The other 2 judgments which I have given, my lords, is to indicate that consistently this honorable court is entertaining the appeals as a miscellaneous first appeal on a substantial question of law and has been deciding the matter on a substantial question of law. There is a substantive remedy, my lords, under section 63 capital A. Pleadings, my lords, they have never stated, because in Deepak Apparel's case, the full bench of this honorable court said, if there's an alternative remedy, there should be a pleading as to why the alternative remedy is not sufficient, which is conspicuously absent.
Not efficacious.
Yes.
No,
Lords, the 2 more judgments, my lords.
A judicial review is not a.
No, that's okay. No doubt there's no bar. But if there's a substantial remedy by way of appeal, why don't you pursue that?
Lord, judicial review is not a bar, Lord. Here,
No, we're not saying
there is
it's
a
not-
prima facie illegality.
We're not saying
Lord,
it's
that
not-
I'll satisfy your lordship.
We're not saying it's not maintainable.
Yes.
I'm not on that point.
Yes.
Nor are they on that point.
Yes.
Whether it could be entertained when
Yes.
all your factual contentions could be
We're
well
considering.
appreciated in the first appeal.
Lord, your lordship could have it day after tomorrow. We'll, at 2:30, Lord.
I lean towards alternative remedies.
Lord, we'll convince your lordship.
Judgments could use.
Realist, realist,
Appeal entertainment.
realist.
Thursday.
Sir. Iveru
At 2:30, Lord, or at the top of the list in the morning.
Thank you.
15th.
15th.
Please, my lords.
2:30, request.
They can make a mention, lords. I am before the lords whenever they
ಅಲ್ಲ
make a mention.
ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ 2:30 ಬಿಟ್ರೆ we'll take it.
Correct. But I'm saying just think about it.
We'll consider it.
If it is, if it would, if you are of the view that you'll go before the miscellaneous first appeal, then simply you can advance it even before that. Think about it.
Yes, yes. But one issue is, 150 applicants are received, applications. The decision is taken in print and ink, the recommendation of the political person is brought in.
No, correct, but what we're
Print and
saying, these very contentions can be subject matter of the substantive appeal if it is there.
But our issue is
Think
that
about it. Think about
226 is a court which will interfere in such situations.
But with so many of your
Extraneous
friends, with so many of your
interference.
friends standing, I don't want to get into it. Let us.
We'll look into it.
Yes, yes.
Please.
Next. Huh. Just 1 minute.
Your lordship,
Just 1 minute, just 1. The page was, just wait.
42. Serial number 42, Mohan.
Realist. Relist on.
22. 43. 44. 44.
43 short date, we have the passport. 43 short date code, passport. Date code.
Fourth. 44.
Relist on.
44.
Relist.
17.4. 45.
Milords, I'm appealing for the petitioner, Milords. The matter pertains to the refund of EMD amount, Milords. Even after completion of the services, they have not refunded the EMD amount.
My lord, there are serious violations of the work order.
There is no violation. There is
No, violation of the work
clause
order.
in the agreement.
There's a clause in the,
But then you put it in writing.
yes,
State to put their stand in writing. Objections to be filed within 10 days from today.
No, any date may kindly be fixed, Milords. Since there is a clause under the agreement which says that it is the duty of the department to ensure that the revised minimum wages are
After
paid by
10,
them.
after 10 days. After 10 days. Yes.
46.
Obliged.
Relist.
17. 47.
All accounts have been declared as NPA. We are asking for dealing with the NPA.
My lord,
Objection from past 7 months.
my lord, I need to make some submissions. My lord, have it, my lord. Next week, any date, my lord, I'll make submissions on this.
Let us.
No, there are two loans. One loan is, my lord, is a NPA. The other loan is, my lord, standard. My lord, in view of the RBI guidelines, my lord, is a one loan is a NPA, my lord, other loan will automatically become NPA. So that, my lord, he has to regularize the, my lord, that overdraft account first.
Let us see. Relist next week.
Yes.
Grateful.
18.7. 48 urgent. 49.
My lord, in this case, my lord, I am for the
49, my lords.
respondent.
Ready to liquidate the account, the loan account. I pay for the petitioners, my lords. I'm ready to liquidate the loan account. The bank has to give me the details of the amount that is pending and to who I have to make it out to, my lords.
My lord, in this case, husband and wife dispute. My lord, we initiated the measure under the provisions of the service here. Now, my lord, the wife is telling that I am ready to pay the account. Either he is a borrower or not the mortgager. What permits will accept the money.
You accept it. What for?
And as far as the document is concerned, my lord, she is not the owner. They are also asking the documents to return. And we can't return the documents. Borrower is also a respondent number 2 in this matter. He is also not ready.
For respondent number 2. Because there's a matter pending before the trial court, family court. Till that is decided, plus if they're not released.
After tomorrow, the matter will be taken up in this matter.
Borrower. Plus in the meantime, I liquidate the account.
Relist the matter in the fresh matters list on. 14.
15.
50.
50.
Relist. Short date.
28.
Relist in fresh matters list on.
21.
Yes.
51 urgent. 52.
Relist. Who appears for the bank? You, sir? Francis Xavier is here only. Francis Xavier is directed to accept notice for the respondent bank. Relist.
15th.
Yes.
53.
53, my lord, the possession notice, my lord, challenge before this honorable court. My lord, the interim order is, my lord, operating from 2024. My lord, some urgency in this matter, my lord.
Relist in fresh matters list.
16.
Grateful.
54.
Water. Relist on.
22. 55.
I am here. Lord, in this case, Lord, 55. The elections, my Lord, which has been held stayed by this court, my Lord, only because election has already been completed. Result is been stayed. But there is urgency, my Lord, we requested.
The matter, my lord, where
tomorrow, my Lord,
approximately some 5,000 voters were excluded.
No, that
one
is a,
petition is there, our impleading applications are there, my lords, and then
no, that has to be, my lord,
there is a
it has to
second
be
bit
decided
petition
by the
also.
civil court, because there is an order by the
No,
high
no,
court, my lord.
the
Relist
elections were
on
conducted by
top
statutory
of,
authority.
just relist on top of the preliminary hearing list on
18.
18th.
56.
Can it be on 21st, not if it is not all right?
No, no, it is
21st was Monday, not 18th, 21st.
21st.
Wait.
56.
For the petitioner in this matter, we take up next week.
List the matter in the fresh matters list on
21st.
So interim order may be extended.
interim order is extended till the next date.
57.
Karnataka Boxing Association.
Because the matter will be taken up next week, because I'll file my objection.
Because the interim order has been passed against us. I think a short date.
My lords, I have a short submission in this, my lord. For R7, notice is being issued to the personal residence of a retired judge of the Delhi High Court instead of the ex
All
officio
the
returning
contesting
officer.
respondents are served.
My lords, there's a memo and there's a letter also from the retired honorable justice of the Delhi.
So
High
what is
Court.
what is the address you appear for?
R7, my lords.
You
That's
appear
it.
for
I'm not appearing for R7. The returning officer, it's an ex officio position, but the address provided by the petitioner is the personal residence
No,
of
correct.
a retired judge.
57. Do you have the address, madam?
My lords, the address will be that of the federation. The returning officer, that is
57.
R7.
Pardon. 57. 57. You have filed the memo.
My lords, I'm filing the memo right away. My
All the
lords.
contesting respondents are duly served.
No, who appears for R7?
Federation has to be served.
Who appears for R7?
I'm filing for the returning officer, that is R7.
So then you will have to take who appears for R7.
No, my lords, I'm just for the person who is being served incorrectly because of the incorrect address. So, my lords, if the petitioner may be directed to carry out service on the Boxing Federation.
Memo filed to the effect that the address of R7 shown is that of a former judge of the Delhi High Court, who is currently judicial member, appellate tribunal for electricity. Accordingly, taking note of the same, petitioner to amend the cause title furnishing the correct address of R7. Relist the matter. Next week, then a short date. 21st.
58.
Yes, my lord. My lord, I am appearing for the petitioner, my lord. I am only requesting for the shorter date because, lordship, in this case, lordship, matter has not been taken for last many hearing, lordship, and it is matter related to the lordship tender matter. And next week, lordship, I am requesting for the next week.
16th.
Can it be on 15th, lordship?
15th.
15th, lordship. I am requesting for 15th, lordship.
59. Parshuram.
Relist. Wherever interim order there, it stands extended.
28. 59. 60. 60 urgent. 61.
Relist. Fresh matter. List in fresh matters list on
15th.
15th.
62.
Fresh. Issue notice. AGA. ಆಗಿದೆ. Relist in the fresh matters list on
63.
Relist.
64. Rupesh.
Relist.
65.
Relist. List in fresh matters list on
66.
Manoj, I'm appearing on behalf of the petitioner in the matter.
It's a worksheet. Vignesh Shetty.
Manoj, allow me kindly for a moment. Manoj, Mr. Vignesh Shetty is the person who appears on behalf of the respondent in the matter.
No, but
Manoj, what has happened is
they have
that
they have
in this
filed
matter,
their-
no 13.2, no 13.4 notice has been served upon me. Manoj, in fact, a third party, your lordships were pleased on the last date of hearing to maneuver my file, Manoj. This is the 6th date, Manoj. I'm appearing on behalf of the petitioner, seeking just an interim stay, at least on the auction of the property till your lordships finally hear us.
What has happened to the auction?
Without delivering any notice to me, my lords.
What has happened to the auction? Auction, what has happened?
My lords, today is the 6th hearing.
This is the
None of the person appearing on behalf of the SBI has been able to apprise your lordships about the status of the auction. My lords, let your lordships hear me at length first, and then my learned friend should decide. And this is not to be decided by my learned friend here.
The auction has not taken place, you have to report. Then fresh steps will have to be taken.
Very well.
Whether it's taken or not, you have to say.
My lords,
On
I
the
will,
date-
if your lordships...
If on the date, 1 minute, if on the date fixed nothing has happened, you report so, we'll close it, keeping open all contentions.
My lords, my humble
matter.
request is to give me 5 minutes of hearing on any rosters day that your lordships roster allow.
The matter,
And
the fresh matters list.
My lords, my one humble request is, my lords, may post this matter for 23rd or 24th. I have come from Delhi, your lordships.
Fresh
And
matters list on 20.
Top of the list, if your lordships may say.
Fresh matters, it will reach. 23rd.
My lords, meanwhile, 23rd. Meanwhile, my lords may direct them at least not to maintain the status quo. Nothing else am I burdening your lordships with.
Let us see. If there's anything, you have to furnish information team also. In the interregnum.
My lords, then otherwise this will become infructuous, your lordships.
In the interregnum, the respondent bank to communicate to the petitioner if any action has been taken pursuant to the sale notice. Yes.
My lords, if they auction the property, this exercise will become infructuous,
Any
your
action
lordships.
taken by the respondent bank, needless to state, is subject to orders to be passed. Yes, next.
So listed on 23rd.
65, your lordship.
Grateful.
67.
Your lordship, serial number 65, your lordship.
We have relisting it in fresh matters list, 65. Yes, next. Relist in fresh matters list.
15. 68.
Relist. Relist in fresh matters list on.
16.
Yes.
69.
List. List 69, 70, 72, 17 and 18 in the list 2, in the fresh matters list. In the fresh matters list on office to show the name of learned counsel B. Pramod as representing the respondents.
16.
Respondent number 1. Office to show the name of learned counsel B. Pramod as representing R1 in all the matters. Yes.
16. 71.
Appear for the petitioner, my lord.
Yes.
It is a tender related.
71.
71 matter, my lord, we filed the affidavit on last date of hearing, my lord, the government. My lord.
From the
So
last 2-3 days.
what has happened now? What is the stand taken by you in the affidavit?
My lord, that the learned AAG Reuben Jacob is appearing in that matter.
List
Lordship
the
may have it
matter.
anytime whenever.
Fresh matters list short date code. 10th. Yes.
In the fresh matter.
72 urgents. 73.
And I'm appearing for a petitioner. They have to.
Relist.
The objections, my lord, they are not at fight.
Relist.
The Nandini Milk Booth Parlor, my lord.
Let us see. Relist.
Interim.
29.
There is an interim order.
Please.
Then you wait. Let us see.
Please.
Interim order earlier granted is extended till the next date. Matter is adjourned. Let them file this.
74.
fresh matters.
Yes.
Huh? Notice interim order consider. Relist in fresh matters list on
17. 75.
Where, my lord, the lordship had asked me to file the status report. The status report is ready, my lord, if I'll file it before the court. This, my lord, I also had raised a preliminary objection saying that they are exposing public cause. However, the matter related to certain allegations against the supply of micro irrigating thing. So the status report I'm filing, my lord. And
the status report filed by the AGA is taken on record. Relist.
based on that, the matter also can be disposed of on any date.
The list in the fresh matters list on
18.
yes.
76.
Relist.
Yes. Be promoted.
Let us see. Relist on
22.
yes.
77.
My lord, appearing for the respondent bank, my lord, in this case, the sale has already taken place. We had submitted sale certificate, my lord. It is to go to DRT, but it may be relisted, my lord, on some date.
List the matter in the fresh matters list on
17.
yes.
78.
Lord, this is a case where no sales certificate issued, my lord. I submitted last occasion, but maybe
List short date code
11.
yes.
79.
79, my lord. This is where sales certificate issued, my lord. In fact, last occasion to lordship.
Well, I have 78 to 79.
79.
79.
My lord, my submission was that, my lord, it was sold for a
Short date code. Short date.
fresh matters list, my lord.
List in fresh matters list on 79.
11. 80.
Huh? Relist.
28. 81.
Respect to local bodies. So it has to go before it specially ordered, is it? There is already interim order earlier granted is extended till the next date. Relist. Yes.
Malaj, any short date may be given, Malaj.
Huh?
Certain office objections have to be overruled, Malaj.
Relist. Office objections to be complied in the interregnum.
But office objections ought to be
Serve
overruled,
copies. Serve copies.
29.
Yes.
29. 84.
Or 82. Huh? Okay, let us relist. The list in fresh matters in preliminary hearing list on
18th.
18th.
85.
Yes.
Here is a matter of error, where the petitioner, during the pendency of the matter, this house is sold to some third party, taking money from petitioner, also some third party state, and the petitioner continues to pay even certain interim orders that will pass in this matter. My lord, this is the third time the matter.
No interim order is passed yet.
It is passed.
Passed.
It is passed, but my lord, my only preference is that it can be taken up in fresh matters.
It
Because,
is.
my lord, there is urgency in this matter. Every day I'm paying EMI, somebody else is
No,
paying my house.
there's no stay of the EMI.
No stay of EMI. I'm supposed to pay because I ordered from bank.
Just wait. List the matter in the fresh matters list. Short date code. Nale Yagu. 10th. 10th. 10th.
10th.
Yes.
86,
Huh? So and so is directed to accept notice for R4.
The masking of the names, my lord, and the.
Relist in preliminary hearing list on.
21st,
Yes.
87,
I'm for the petitioner in this case, my lord.
87,
Respondent has filed
K.V.
some
Lokesh.
IA, my lord.
My lord, is only deposit amount release direction for.
I have deposited, interim order was granted to comply that order. I have deposited amount, my lord. To release that amount, they have filed an IA, my lord.
We'll allow that.
Yes, my lord.
IA 1 of 25 has been filed by the respondent bank seeking for release of the deposited amount. Petitioner pursuant to an interim direction
Yes, my lord.
of this court has deposited a sum of rupees 10 lakhs. Full stop. The again procedure Manjunath. Again the transfer. ಏನು ಮಾಡ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ಅಷ್ಟೇನಾ The registry is directed to transfer the said amount to the bank. Respondent bank to file a memo with necessary details of account number etc. to enable transfer in terms of the order passed. Accordingly, IA 1 of 25 is disposed of. Yes.
88,
Relist.
89,
Relist.
90,
Relist.
91,
Relist.
92,
Relist. Has been
Review of
stayed.
stay granted by the Honorable Court. There is urgency in the matter, my lord.
You appear for
I am for the impleading applicant.
recovery by whom?
Recovery proceedings initiated by us through respondent number 1 and 2.
Government.
Yes.
Short date code. Relist.
16th,
These are proceedings arising out of RERA, my lord.
Huh?
The proceedings arising out of RERA.
Yes. Next.
93,
Your Lordship, appearing for the petitioner in this matter, there are outstanding dues despite providing services from 2023, Your Lordship. They have acknowledged the debt, but they have not. A short date may be given. It may be listed in the fresh matters list, Your Lordship.
In the preliminary hearing list on.
14,
Yes.
In the fresh matters list, Your Lordship.
94,
Appear for petitioner, my lord.
Relist.
This case, my lord, it's a government school, my lord. It's a government school, my lord.
Just 1 minute. Yes.
My lord, it's a government school, my lords. But the thing is, the petitioner is not cooperating with it, but it's not, the rule is going to the rule of my lords. They're ruling the school, my lords, and not providing the school, proper school at all, my lords. There's no proper education also, my lords.
This is the matter.
And we are for impeding applicants, my lords.
Fresh matters list on.
They started ruling the school, my lords.
Submission 94.1 ಅಲ್ಲಿ entry ಮಾಡಿದೆ ಸರ್, entry ಮಾಡಿ extend ಆಗಿ.
15th.
Lords, there's an urgency in this matter, my lords. Can't you short it, my lords?
15th in the fresh matters list.
Please, my lords.
95,
Relist.
96,
Relist.
97,
Relist.
98,
Relist.
99,
My lord, petitioner in this case, my lord, assistant commissioner has cancelled my residential certificate, my lord. Based on that, my lord, the concerned officials of, I'm working as a Anganwadi assistant, my lord. They are removing my job, my lord. In the last date, my lord suggested to file application, making the officer of the women and child department as a party, my lord. Till disposal of the writ petition, kindly.
No, that will have it tomorrow, day after tomorrow. Let us see what IA.
Impleading application, my lord.
The notice must go. Released.
And they are trying to remove my job, my lord. I will.
We'll have it
Working as Anganwadi assistant, my lord. That will affect on.
Issue notice on IA. Filed under order 1 rule 10. List the matter in the fresh matters list. Short date.
16th,
16.
Public.
100,
Relist.
101,
Yes, Your
January, not even 1 rupee is paid.
Your lordship, I have received the NOC from the previous council. I need some time, my lordship. I'll file the wakalat in the counter.
Yes, yes, we are council. And your lordship of not even 1 rupee is paid. And he is a sub-licensee. Only question is, let the interim order be not extended. That's all. As per the orders of my lord, they have to pay 57 lakh and all. 53 lakh 44,000. As per the order report, arrears is larger than that.
You have not paid, madam, we'll have to vacate the interim order.
ಇಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಇದೆ. ವಾಟ್ ಐ ಆಮ್ ಸಬ್ಮಿಟಿಂಗ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಸರ್ಟನ್ ಅದರ್ ಪೆಟಿಷನರ್ಸ್ ಹ್ಯಾವ್ ಟು ಬಿ ಇನ್ಕ್ಲೂಡೆಡ್ ಇನ್
No,
ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
If you don't pay,
This order is going to affect those people also.
it's of no relevance to the court.
So I may be.
No, I'm not going to extend the interim order unless you pay. You tell us you're going to pay,
Maybe
I'll
kind-
extend.
No, my
What is your
lordship,
instruction?
they have given
What is your
wrong
inst-
calculations, my lordship. That has to be brought before this honorable court, my
I've
lordship.
considered everything on the last date. I'm not going to revisit
Lordship,
it.
no, my lordship. Now I come on record, my lordship.
No, no,
May
I'm
I be
sorry.
given an opportunity?
I can't extend the interim order.
Okay, may be given an opportunity to submit, my lordship.
No, no,
I may come on record first, my lordship.
you can do
There are,
whatever.
lordship, the shopkeepers are being affected very badly. And they have to be brought on record, my lordship. They have gone and made a huge ruckus there.
The
Kindly see, my
interim
lordship,
order-
I got the newspaper clippings,
The
everything.
interim order
Your
passed on
lordship,
20th June 2025 had directed the petitioner
2 weeks time may be given,
pay.
lordship. 2 weeks time may be given.
certain amounts as specified in para 10 of the order. Full stop.
Not even 1 rupee is the cost.
It is noticed that till date petitioners have not adhered to payment. Full stop. Next. It is clear that the court, while granting an interim order, had stipulated that amount was required to be paid for use and occupation. Full stop. If that be the premise of protection extended, non-payment does not entitle the petitioner of any further protection.
This may be a week's time may be granted, my lordship. Please, my lordship, it's my humble submission.
I will give you, provided you are going to pay. I'm not going to simply extend if you're not going
My
to pay.
lordship, there are certain things which has
That
not
is
been
different.
brought
No,
before the.
that is different. Money you have to pay.
That-
If there's a
Because the
error,
calculation itself is wrong,
that we'll
lordship.
see. We'll adjust it towards future.
The calculation, I have to
We'll
bring it
adjust
in the
it.
calculation. How much have I have paid, my lordship?
If it's made clear that
1 week time may be granted.
it's made clear that the interim order is extended
Pay 1
finally,
week.
finally on the condition that the amount as ordered on 20th June 2025 to be paid within 1 week from today. If there is no compliance, court would be constrained to revise the interim order. 1 week, relist the matter on 16.
If they don't pay it.
I've stated, I'll revise it.
Yes.
I made it
It may
clear.
be revised now itself, so that if they don't pay it, automatically it would go.
My name may be reflected. I
Office to-
undertake to file
Office
wakalat.
to show the name of so and so. But madam, please take it from me
Yes, ma'am.
that I'm not going to extend it. Last time, we have dealt this matter with detail. Once the amount is quantified, if there's any calculation error, future it will be adjusted. What we have ordered, you have to pay. You cannot argue again with respect to that amount. Yes, next.
102, KS Ravi Kumar,
Yes, relist.
29. 103,
Relist. It's relist. Wherever interim order there stands extended. Yes.
104.
The review petitioner, my lordship, may be listed next week, your lordship.
Relist. Relist.
28.
Yes.
105.
Relist. Yes.
106.
Relist.
The petitioner copy has been served, we've already given it to the counter, proof is here. And it's urgent matter because we have apprehension the KPID is going to seize the bank funded properties. There is in this petitioner who already admitted that he has misused the money for these properties, and I'm representing the bank as well as the depositor association. And they have allowed, the petitioner is willing to lease the property. We have asked to sell the property by a court commissioner and deposit to the bank or to the court.
This is the matter in the fresh matters list shortly.
107.
Your Lordship, I appear for the petitioner in this matter. The writ petition was filed in the year 2023 to delist and mask the petitioner's name from news articles, which is mentioning about the petitioner's arrest in 2016. Subsequently, petitioner was acquitted in these offences also in 2018.
Appearing for respondent number 2 in this matter, my lord.
Appearing for respondent number 7 in this matter, my lord.
Appearing for respondent number 3, my lord.
108. Ajesh Kumar.
Your Lordship, a date may be given, Your Lordship.
29. 108.
Similar matters is on 21st, my lord. 107.
Next.
108. Ajesh Kumar.
Relist.
109.
I appeal for the petitioner, my lord. The petitioner had approached the apex court, and the apex court has already disposed of this matter, my lord. My house is sold. I have no place to stay. I'm 83 years old, my lord.
This is the matter in the fresh matters list on.
17.
Yes.
110.
1 for the respondent. Auction notice has been stayed. Some urgency. They haven't complied with the interim order in entirety. They had to pay 20%. They haven't paid the entire 20%. Any short date?
Relist in fresh matters list on.
11. Great. 111.
I'm appearing for the petitioner in this matter, Your Honor. The respondent had sought to file their objections. They have not filed it, Your Honor. In fact, there's an application for early hearing. It may be disposed of and it may be listed on 15th or 22nd for preliminary hearing, Your Honor.
All right, he has disputed questions of fact. He's seeking setting as a sale deed.
Relist on.
29.
Yes.
On for preliminary hearing, Your Honor, there's an application also.
112.
It is.
For the petitioner, Your Lordship.
On 15th, Your Honor. I request on 15th or 22nd, Your Honor.
112.
For the petitioner, Your Lordship, during the pendency of this writ petition, my lords, the respondents have settled the matter. So, given the fact that there are some goods that are supposed to be recalled by respondent number 1, who's the Chief Commissioner of the Consumer Protection Act, we request that the matter be posted at the earliest, Your Lordship. An IA for early hearing has been preferred.
You're saying matter is settled, then there ends the matter.
No, my lords, but I am seeking for recall of goods so that the matter is settled as in against the company, Your Lordship. They have been given wrongs. They have been providing goods in contrast to this.
In the fresh matters list on.
17.
Yes.
113.
113, my lord, I beg to appear on behalf of respondent. My lord, sale, my lord, assailed before this honorable court in the month of January 2024. This honorable court shown certain in the sale not taken place. My lord, later, my lord, they given a one-time settlement offer. This honorable court directed me to consider, which we considered and rejected. No, my lord, more than 6 crore is outstanding. Interim notice operating from 2023. My lord, there's an urgency in this matter.
Fresh matters list on. 11th.
Grateful, my lord.
114.
Relist. Relist in matters list on.
21. 115.
Your Lordships, I appear for the petitioners in serial number 121, Your Lordships.
No, 115, just wait.
115.
Relist.
116.
My lord, appearing for the respondent bank, my lord, there is an unconditional interim order obtained by the tenant. 11 crores is the due. My lord, connected matter is actually posted on 16, my lord. It may be posted in fresh matters. 11 crores are due, my lord.
List in fresh matters list.
Sir, respondent 3 and 5 notice is not served, sir, actually.
My lord, that is, my lord, it's a collusive suit. My lord, may kindly post it along with WP 630.
They are the borrowers, sir. They are saying that.
Madam, please don't argue. I'm giving you a date. Just
yes, my lord. Yes, my lord.
116, relist the matter in the preliminary hearing list.
Please interim
On-
order.
My lord, it may be combined with that other matter, my lord. My colleague will give the number.
List along with the WP
63
number
6300 of 2025, my lord.
6300 of 2025.
Yes, my lord. Grateful, my lord.
117,
Obliged. Relist.
118,
Relist.
119,
List.
120,
Relist. Relist.
17, 18, 121,
Lordships, I appear for the petitioner.
Whenever interim orders are there, it stands extended.
21,
I appear for the petitioner, your lordships. There is
Relist.
an interim order. Interim order is subsisting, your lordship.
Interim order.
Maybe.
Wherever interim orders are there, it stands extended.
24,
Relist.
Petitioning this matter, my lord. Kindly wait, 16th, my lord.
police.
First matter. General parole matter, my lord.
17th.
125,
My lords, matter pertaining to provisional attachment order by the ED, my lord. Today it is going to expire, 30 days is going to expire, my lord. If the adjudicating authority confirms my order, my writ petition becomes infructuous, my lord. So kindly have it tomorrow on the first matters list, my lord.
Right, Nale. Tomorrow in the fresh matters list.
Grateful, my lord.
125. Nale. Otherwise, day after tomorrow, it will come in the first list.
Day after tomorrow.
Day after tomorrow in the
Fresh
fresh
matters
matters list. Yes.
126,
I am for the petitioner, your lordship. This matter pertains to Senior Citizenship Act, your lordship. The matter is urgency. It may be listed in the short date, your lordship.
17,
Obliged, your lordship.
127,
Relist.
128,
Relist. List week after next. Yes.
129,
Relist.
bank note. 130 and 131,
Relist.
I appear for respond number 1 in this matter, my lord. The matter pertaining to survey
List the matter in the fresh matters list.
17, 132,
I am for petitioner.
Real.
Requesting for a short date because
though I am a
necessary party and
Relist.
the caveat have not been made a party.
Yes, relist.
Date 12.
My lord, interim order may.
Interim orders will stand extended wherever it's there.
133,
Relist.
My lords, I'm for the petitioner. My lords, this matter is an MSME order, my lords, which the respondent wasn't a MSME at the time of the petition file, my lords. The arbitration is on 21/7/2025, my lords. And after the notices issued to the respondent, not even once the matter is heard, my lords, may be kept on before 21/7, my lords.
List in fresh matters list on
18th,
18th.
Please, my lords.
134,
Petitioner to serve copies of the petition on counsel for the respondent. Relist.
135 urgent, 137,
136.
136, 136,
My lord, I am the petitioner. There is an interim order.
Interim order earlier granted,
My lord,
extended till the next date.
My humble submission is that I am a senior citizen with advanced age. I am appealing 14%. I have paid entire loan with interest, and I have paid in excess 1 lakh rupees. And by fraudulently and dishonestly altering the terms and conditions in the repayment schedule, my lord, they are fastening about 18 lakhs extra liability on me.
Let us see.
This may be kindly be on priority basis taken up for hearing and disposal during the course of this week or next week.
Relist.
18th, 137,
My lord, I may be permitted to file the written arguments.
Yes.
137,
Relist.
138,
Relist.
21st, 139,
Relist.
140,
Respondent 3.
This one,
My lords, all we are saying is that there is a violation of the racing license condition because a horse owner cannot be named as a steward. That's all. Here,
Copy of the
evidently, horse
petition may
owner
be
has been
served
named
on.
as a steward. Therefore, we are asking for an inquiry to be conducted by the state to consider whether the license
my
condition
lord,
has been
I
violated
made
or
a
not.
submission on last date of hearing also, my lord. The Mysore Race Club is registered under the Companies Act, my lord. If any violation, my lord, they will have to file the complaint there, my lord.
Yes.
I appear for respondent 3, which is the club, my lord. Order was to serve a copy, my lord. I have not received any copy of the papers. I request petition papers may be served up and I'll file a response to the same. My lord.
My lords, we've served a copy, but we'll serve a copy to my lord. Mr.
List in fresh matters list on short date code.
11th.
11th.
Lord, may it be Monday, my lord, 14th, if I may request. Senior counsel is not available there. That's my only request.
14th.
14th.
Much.
141 urgent, 142 passport.
List in fresh matters list.
14th.
No.
43.
Appear for the petitioner in the matter. Lordships, it's covered matter. Manvat Kaval, already this honorable court has quashed the proceedings with respect to it was supposed to be listed in preliminary hearing, your lordships. May I request the matter be taken in preliminary. It's covered, your lordships. There's already a coordinate bench has quashed it. I produced the order copy also.
ECGP.
Game forest.
Relist.
Interim order to be extended, your lordships.
Lordship.
Huh?
59 is a substantial scheme matter, Lordship, directed that I serve the bank. Anytime week of 14th.
Interim stay is not yet considered.
28.
Lordship, left that open.
50.
59.
Lordship.
Just wait. 59.
28.
List the matter in fresh matters list.
Week of 14th, any day convenient to Lordship.
17th.
Please.
Lord.
59.
27.
And they are challenging the order passed in OA.
Second list, 15, serial number 15.
15 or 16.
Yes.
15 or 16. This is only for mandatory. Issue work order.
Of course. Relist. 15 and 16 relist.
21.
Yes.
17 and 18 urgent. 21.
21, my lord, we have to file objections in this matter. A week's time may be granted, my lord.
This week after next.
22 urgent. 23.
Lordship, I am for the petitioner, Lordship.
23.
Lordship, direction may be given to registry to respondent number 4 to present before R7. Lordship, respondent number 7 denied to take the hand summons.
21.
23.
Now, what is this memo for withdrawal?
Not withdrawn, Lordship.
23. 22 in a memo for withdrawal.
Registry may directed to Lordship R4 to give direction to R7 to appear before this honorable court. It is a matter of defreezing the bank account. He has not taken the hand summons. All the way from Bengaluru to Chennai, I went, Lordship.
Who's R7?
Inspector of Police, Cybercrime PS, Office of the Commissioner. Lordship, I served R4, the DGIG of the Commissioner, R5 additional.
Let us see. We'll see, but his superior officers are served, we'll see.
Lordship, they will not come back. They don't have, they are not giving value for the hand summons.
In case it's police at Chennai, how you can communicate?
At best is, my lord, the DGP office, there is a coordinating officer. We can request them to get the information.
DGP?
DGP of Karnataka, there is an officer.
Intimation.
To coordinate with the interstate police, certain matters, my lord, that we can, that I will verify and get.
AGA is directed to intimate concerned in the office of the DGP to ensure communication of pendency of the present proceedings to the officers of the police department in Tamil Nadu. Copy of the order to be handed over to AGA. Now you give the details to the
Much obliged, my lord.
Relist.
21st.
Yes.
24.
Where am I?
Relist.
25,
Relist.
26,
Question for the petitioner lordship, matter is pending 2024. 14th of
17,
Hmm.
27,
This matter is pertaining to the execution of the proceedings before vide your lordship. The order was passed during 2009. After 15 years, they are filed this petition challenging that order.
List in fresh matters list short date code.
11th,
And we have entertained and given stay.
Yes, sir.
11th,
Sir, 143 interim order extension. ಅಲ್ಲ ಮೇಡಮ್ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್
Petition copy ಕೊಟ್ಬಿಡಿ. What end date ಕೊಟ್ಟಿರೋದು? ಕೊಡಿ petition copy. So serial number 29, sir. 107.